30A ಅಡ್ಜರ್ಮೆಂಟ್ ಯಾರ್ಯಾರ್ದು ಅಂತ ನೋಟ್ ಮಾಡ್ಕೋಬೇಕು. ಗೊತ್ತಾಗಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಕೇಳಿ ಹೇಳ್ತೀನಿ, ಇಲ್ಲ ಅವ್ರು ಕೇಳಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಸಾಹೇಬ್ರು ಹೇಳಿಲ್ಲ ಅಂದ್ರೂ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕು. ಬ್ರೇಕಪ್ ಆಗಿದ್ರೆ ಹಿಂದೆ ಇದ್ರೆ ಸಾಹೇಬ್ರು ಕೇಳಿ ಎಕ್ಸ್ಟೆಂಡ್ ಕೊಡಿ ಸರ್. ಮಂಡೇ ಬರುತ್ತೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಸಾಹೇಬ್ರು ಬರ್ಬೋದು. ನಾಳೆಗಂದ್ರೆ ಸಾಹೇಬ್ರು ಆರ್ಡರ್ ಸರಿ ಅಧ್ಯಕ್ಷ ಅಷ್ಟಿಲ್ಲ. ನಾನು ಫೋನ್ ಮಾಡಿ ಎಷ್ಟಿದೆ ಅಂತ ಫೋನ್ ಮಾಡಬೇಕಂತ ಗೊತ್ತಾಗ್ತದೆ. ಹಾಂ, ಆರ್ಡರ್ ಸರಿಯ ಅಡ್ಮಿಷನ್ ಎಷ್ಟಿದೆ ಬಿಲ್ಡಿಂಗ್ ಇರಬೇಕಲ್ಲ ಒಂದಾಗಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಲ್ಲ, ಪೆಂಡಿಂಗ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರುವಂಥದ್ದಿದ್ರೆ ತಗೊಳ್ಳಿ. ನಾಗರಾಜು ಇದು ಬೇರೆ ಬೇರೆ ಲೆಟರ್ ಬೇರೆ ಬೇರೆ ಲೆಟರ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ರಾಜೇಶ್ ಮತ್ತೆ ಕೂಡ ಕೊಟ್ಬಿಡ್ತಾರೆ. ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಒಂದು ಕೊಟ್ಬಿಡಪ್ಪ, ಬಾಕಿ ಪೆಂಡಿಂಗ್ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್. ಕೊಟ್ಬಿಡ ನಾನು ಮಾಡ್ತೀನಿ. ಇಲ್ವಾ ವೆಂಕಟೇಶ್ ಇವತ್ತು? ಸರಿ ಆಯ್ತು. ಇನ್ನೂ ಇರ್ಬೇಕು ನಾಗರಾಜು. ನಾಗರಾಜು ಇನ್ನೂ ಇದೆ. ಹಾ, ಇಲ್ಲಿ 26 ತನಕ ಆಗಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 26. 27 ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು. ಅದು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ನಂಗೆ ಕೊಟ್ಬಿಡಿ. ಇಪ್ಪತ್ತೇಳಿಂದ ಸದಾನಂದ. ಅರವತ್ತೆರಡವರೆಗೂ ಕೊಟ್ಬಿಡ. ಸಾಹೇಬ್ರು ಬರ್ಬೇಕು ಅದಕ್ಕೆ. ಇರ್ಲಿ ಬಿಡ. 62 ವರೆಗೂ 62 ನ ಅದು ಕೆಳಗೆ ಕಳ್ಳ
Yes. No, all fresh matters tomorrow. Pudi. Fresh matters first time tomorrow. Iskandli avaru. Yes. Tomorrow. Yes. Why? Not ready. Tomorrow. Very tomorrow. Very. Fresh matters. Office objection is post madakadri. Yes. Tomorrow. Yes. Tomorrow. Yes. No, everybody is taking 5 minutes. It's now 200 matters, Mr. What to do that? No, this only another hardly 5 days is there. Only I can hear that preliminary matters. Not only your matter, Mr. So many matters. I know that. I know the problem, but you also know my problem. How can I do that 200, 300 matters per day? We'll fix it on 3rd June. Let us see after that. 3rd June. Yes. First, second. Fresh matter tomorrow. Fresh matter tomorrow. We'll see. Tomorrow. We'll see and tomorrow morning. Yes, tomorrow. Yes. Tomorrow. Yes. We'll see that when the arrest warrant issued. Today is what is that? You need not certified copy, madam. You see, every day they will get in a Xerox and do it. All this explanation tomorrow. Yes. Fresh matter tomorrow, Kudi. Infructuous. Yes, tomorrow.
Thereafter, it was released last week from the partner. So I filed a IA for modification of interim order.
Where it is released?
It was reserved for the judgment. Another roster, my lord. Thereafter, it was released from the partner. So I filed that because of, I understand because in coming month is a vacation. So I filed an IA only for the modification of interim.
Modification by that same judge, it has to go before the same court.
No, my lord. It was today. It was released and also
released main matter. If it is any modification of the interim order, it has to go before the same bench.
My lord.
Yes, anyhow, you will have it on 28th. Let us.
My lord, it will be Friday, my lord.
28th. Let us see that. Yes.
28.
Yes.
I mean, for second time, the first thing it was not ordered in notice. I dropped an adjournment.
Only adjournment tomorrow. Yes.
Lordship matters. My LR application notice.
Sorry, out.
Yes. 30th.
Lordship, this matter was date was given by your Lordship today, but it is not listed. It's a fresh matter. Fresh matter.
No notice is issued.
No, my lord. It is not come for first time.
Tomorrow, Kudi. First time or tomorrow. Yes.
Interim order has been obtained by suppressing earlier round of litigations. I filed an application for vacating.
Yes, 28th. Yes.
Please, I also filed a vacating application, my lord.
Yes, 29th. Yes.
The other side has disobeyed the interim order passed by this honorable court. I filed an IA for disobedience. There's some urgency in the matter, my lords. The judgments in fact say that disobedience happened.
Yes, 29th.
I'm so big.
Caveat petition was put up, filed, my lords. The same was not put up before this court, and the opposite party had granted interim order.
Vacating application.
Now they are dispossessing us, my lords.
Have you filed an application for vacating?
No, my lords.
And they file an application for vacating. 29th.
My lords too.
My lords,
Otherwise, it will not reach, Mr.
my lords, the matter was listed on 2nd of April, my lords. The date was fixed on 18th due to the paucity of time. My lords, the matter has not come up. My lords, the same issue has been decided by the Supreme Court, my lords.
Matter will come on 25th. Yes.
Yeah.
Mellots.
Seen because of holiday has been,
Lords, 25th senior council is not there. Lords, 20.
then 29th.
Grateful.
Mellots, kindly leave Mellots. Mellots, I have filed the IA for vacating stay Mellots. The court has granted stay and they are putting up the building Mellots.
Vacating stay,
Please.
28th. Yes.
Please.
First matter tomorrow.
Fresh matter tomorrow, yes.
Let's orders are passed in my favor, 39 rule 1 and 2. It's been 1 year, my lords. The respondent defendants therein have violated the orders multiple times, which has also resulted in filing of section 39(2)A, order 39(2)A proceedings. My lords, I've also filed an application, my lords, for police protection. I'm unable to put up construction, my lord. I have availed bank loans, my lord. My request, there's some urgency for
Yes,
construction.
29th, yes.
Okay.
The matters were listed online. The lordship directed that if the trial court doesn't consider the application for temporary injunction, the lordship will consider it on 16th. The 16th matter was not listed. Again, I moved a memo on 17th. Date was given. Again, the matter is not listed. The old memo na follow up, but it's still not being listed.
Yes,
The urgency is this one.
25th, yes.
Some urgency, because ಇದರಲ್ಲಿ ಬ್ಯಾಂಕ್ ಅವರು ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ರು. 45 days ನಾಳೆ ಎಕ್ಸ್ಪೈರಿ ಆಗುತ್ತೆ. ಆಪ್ಷನ್ ನೋಟಿಸ್ will be issued. Auction will be. That is the reason.
Yes, 24th, yes.
Adjournments if any, list number 1 adjournments.
Still number 40, your lordship. It's become infructuous.
Serial number
40.
14.
Please.
Cognate counsel for the petitioner has filed a memo stating that in view, person to withdraw this above writ petition having become infructuous. Memo is taken on record. The above writ petition is dismissed having become infructuous.
Number 40, your lordship.
Serial number
40,
6, please, Lord.
40.
Please, my lords. And for the petitioner, my lord, I pray for a week's time in this matter.
At the request of counsel for the petitioner, leave this matter up to 2 weeks.
Serial number 6, please, Lord.
6. Yes, Mr.
The respondent counsel is present for this court.
Yes, sir. The
Immediately
request of
after
counsel
vacation,
for the
please.
petitioner, leave this matter up to 2 weeks.
Serial number 7, my lords.
Serial number 30. At the request of counsel for the petitioner, leave this matter next week. Yes, let us see, 28.
Serial number 7, my lords.
Serial number 7.
Short accommodation, my
And
lords.
for the petitioner,
respondent, my lords.
your lordships, there, it may be posted next week. There's a status
you
quo
are
in this
appearing
matter.
for?
I'm for the petitioner in this matter. And they have started construction. Status quo is there. Let them maintain the status quo and it may be posted next week, your lordship.
My lords, since short accommodation, my lords, next week, it may be taken up on
Next
29,
week
my
is
lords.
fine, but let them maintain status quo.
My lords,
Without seeing that file, I will
Status
not
quo
grant.
already,
Concurrent
status quo
finding, my
is
lords.
Swami.
Want to grant any status quo, you grant it, madam.
Alla
Concurrent finding,
Swami,
my lords.
For an adjournment, either you say yes or no.
next week,
Don't
your
say that status quo. Without seeing the file, I have to grant any status quo.
obliged.
Why that judge should be sit, madam? You can go and get it from that
ಇಲ್ಲ
register.
ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಯಾಕಂದ್ರೆ ಯಾರೋ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅನ್ನೋದ್ರಿಂದ ಒಂದೇ reason.
ನೀವು
Short accommodation.
ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡಿ, ಗ್ರಾಂಟ್ ಕೊಡಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿ, ಆರ್ಡರ್ ಮಾಡಿ ಅಂದ್ರೆ ನಮ್ಮ ಫೈಲ್
ಸ್ಟೇಟಸ್ ಕೋ ಆಲ್ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ.
If it is there, then you say that continue the status quo.
no, my lords,
Continue. There is a
nothing status quo is there, my lords, in this matter. It was heard, my lords, and it was posted for to produce the documents, my lords. Serial number 7,
Then I will not grant stay. We'll hear that matter.
my lords. Short accommodation, my lords, since senior uncle has been passed away, my lords.
Yes. There is no order of status quo, madam.
It was heard, my lords, in the last occasion.
No, your lordship.
ಇದೆಯಾ? Then also petition also permitted to produce the documents so that corrupt land so and so.
Concurrent finding, my lords.
There is no order of status quo, madam. ಸುಮ್ನೆ ಹೇಳ್ತಿರಲ್ರಿ. Yes. Leave this matter. When do you want, mister?
29th or 30th, my lord.
Yes, 29th.
Grateful, my lord.
Obliged.
Matter for vacating stay,
Hmm.
Monday or Tuesday.
29th, yes.
29, 28.
28th I have given so many matters. 29th. Yes.
28 or 27th.
28th, yes.
Serial number 4, petition is dead, you know. Pray for some time to bring the loss.
Yes, sir. The
Serial
request
number
of
4.
counsel for the petitioner. Leave this matter after 2 weeks.
No, serial number 79, may I seek for a 2 days adjournment, permit to compliance with non-compliance. Serial number 79.
Yes, 2 weeks time is granted to comply of subjection. Yes.
Much
Serial
obliged.
number 85.
Yes.
2 weeks.
You are appearing for?
I am for the respondent.
Yes. Which respondent?
Respondent number 3, 8 and 9.
Who has filed that application for vacating?
Vacating ಇನ್ನೊಬ್ರು respondent.
ಮತ್ತ ಅವ್ರು ಕೇಳ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ಇದ್ರೊಳಗಡೆ issues ಗೆ ಕಾಪಿ ಬೇಕಿತ್ತು ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್
No,
ಡಿಸ್ಕಸ್
they have filed an application for vacating.
ಇಶ್ಯೂಸ್ ಗೆ ಕಾಪಿ ಬೇಕು ಅಂತ ತಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರಿ. ಇಶ್ಯೂಸ್ ಕಾಪಿ ಯಾರ ಹತ್ರ ರೆಡಿ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇಶ್ಯೂಸ್ ಕಾಪಿ ಇದ್ರೆ ತಾವು ಆರ್ಗ್ಯೂ ಆರ್ಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೆ, ಅದಕ್ಕೋಸ್ಕರ.
No, that council who has filed an IFR vacating is not there.
ಅದೇ ಇಶ್ಯೂಸ್ ಕಾಪಿ ತಗೊಂಬನ್ನಿ ಅಂತ ಕೂಡ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ವಿ, ಕಾಪಿ ರೆಡಿ ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
You are appealing for which respondent?
3, 8 and 9.
At the request of council for respondent number 3, 8, 9. Is this matter after 2 weeks? Interim order granted earlier is extended till next. Yes.
ಕಾಪಿ ರೆಡಿ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
ಇವ್ರು ಅವರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
ಮಾಡ್ತೀವಿ.
Number 1 for preliminary hearing, serial number 1, Mohan BK.
For petitioner, my lord. The matter is settled before local my lord, and petition is.
You want to withdraw?
Infectious.
Yes, learned counsel for the petitioner submit that filed in a memo stating that parties has settled in a matter out of in the local adalat. Hence, prior sought, hence writ petition become infructuous. The memo is taken on record. The above writ petition is dismissed having become infructuous.
Serial number 2, Shankara Narayana Bhatt B.
Yes, none appears. Leave this matter after 2 weeks.
Serial number 3, Girisha NR. Serial number 3.
Appear for the.
Yes, Mr.
The order on the challenge is, my lord, at section A, page 10. The trial court has allowed an application filed by defendant for impounding a document which is a sale agreement.
Suit for?
The suit for specific performance. Where I had filed for specific performance with respect to a scheduled property. In 2014, I entered into an agreement for the purchase of the property.
Now, what is that order you are challenging now?
The order is at page 22. Page 22. Where IA number 6 filed by defendant under section 33 and 34 of Karnataka Stamp Act is allowed. And the plaintiff is directed to pay stamp duty and penalty of 3,15,000. So the defendant had filed an application.
ಆಯ್ತು, ಏನಾಯ್ತು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ?
Order I am challenging that actually.
No, you are challenging after 2 years. I am asking that what has happened in between 2 years. It has passed in 2024, mister.
Yes, my lord.
Then?
But it has not come before the court.
ಏನಾಗಿದೆ ರೀ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Total it is for cross examination.
What has happened to this payment of stamp duty, mister?
Payment I have not done.
Then
I have prepared an appeal. I did not make the payment.
ಅದಕ್ಕೆ ಕೇಸ್ 2 ವರ್ಷ ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡಿದ್ದೆ. You have not moved this matter.
I have moved, but it did not come up.
There is no memo, mister. Office itself has posted this matter.
This matter.
What has happened to that payment, mister?
Payment is not made.
You have just mentioned before the trial court saying that matter is pending. Then you are taking that advantage.
Proceeding is continuing.
Yes.
I have not paid the.
Issue notice.
Serial number 4, adjourned. Serial number 5, Prakash KM. Serial number 5.
Hearing for the petitioner, lordships.
Yes, ma'am.
Petition seeking that in my application and order 1 rule 10(2) was dismissed. In the FTP proceedings 3 of 2015, your lordships.
Yes, what is your right?
Your lordships, earlier to this FTP proceedings. Suit for partition.
Partition. Suit is decreed.
Partly decreed, your lordships.
Yes, then who are you?
I am no way connected to the respondents in these matters. But in fact, I am in possession of these survey number 119.
How did you come to possession, madam?
The same was given, I received the same through Srimati Mallamma.
Who is Mallamma?
Through a registered will. She was in earlier the property bearing survey number 119 of 1A of 2 acres was in her name. Through a registered will dated 31/8/1971.
Where is that order passed by the trial court? Which is that impugned order?
Impugned order is at page number 160, your lordships. Operative.
160.
Your lordships just.
Where is that, madam? Get ready, yes. Is this matter 2 weeks? Yes.
Your lordship's notice may be issued in this matter.
No, you are not ready in that matter, madam. How can?
Serial number 6, 7 adjourned. Serial number 8 Arshit N, VB Shivakumar.
Here for the petitioner, my lords.
Yes.
My lords, in this case, my lords, there are 10 defendants, my lords. T1 to 8 was served. T9 and 10 years service agala. Now, my lords, basis on that steps are not taken on the first occasion. Time is granted by the court. On the second occasion, the entire suit is dismissed, my lords. Ideally, and on the next day, I filed an I under 9 Rule 4. The court says this is not the right provision. It has to be filed under 9 Rule 9, my lords. That is on that sole ground. And on the very next day, I filed. The order sheet may be seen at page number 38.
What is that order you are challenging now?
Order passed by the trial court at page number 39, my lords. Page number 38, on non-appearance, I have taken the steps insofar as D9 and 10 is concerned, my lord. Page 38 of my petition. I'll PF paid on the left-hand side. I have taken steps to 9 and 10. They have not appeared. They are my family members, my lord. They are deliberately not appearing before the court. 9 and 10 are my family members. They are brother-in-law and sister-in-law. Now, my lords, basis my non-appearance, the court states that despite plaintiff remained absent, conduct of the plaintiff is considered. She is not diligent in this aspect, and the plaintiff is not interested to prosecute the case. And at 5:45, matter is called out, and suit is dismissed for default. My lords, there is an interim order in my favor not to create third-party rights, my lords, in the property. Now, on the very next day, as soon as the order is passed, I advance the matter. On the next page down, notice.
No, that you have filed an application. You have to file an application under which provision?
My lord, since it is dismissed, my lord, D1 to 8 is served. So my contention is the IA should be filed under 9 Rule 4, my lords, not under 9 Rule 9. Even the trial court should have dismissed the suit only against 9 and 10 because D1 to 8 are served, represented, and they have filed.
No, application filed under Order 9, Rule 9.
No, my lords, I have not filed under 9 Rule 9. I have filed under 9 Rule 4. The trial court dismisses it saying I should have filed under 9 Rule 9. My submission before this court is when all except 2 defendants, all the other defendants are served. So the suit ought to have proceeded against 1 to 8.
Yes, notice.
My lords, the respondent is on caveat, my lords. I have served the matter. In fact, the suit is dismissed.
I think, sir, who is serial number rest is? Who are that other respondents?
My lords, D1 to 8.
I notice kodi, yes.
Caveat, I've already served them. They are on caveat.
We will hear. Let the notice, yes.
Serial number 9.
Caveat is yes.
Copy has been served. Office objection was have not served. RPADL Kottidin have served the memo also.
I will you take
But
notice.
the date
You
may
one
be-
more copy, see you serve much.
I will serve. And the date may be fixed because the matter is dismissed.
On 10th June. Yes.
Obliged.
Serial number 9, Nagaraja S. Serial number 9.
None appear for the petitioner. Leaves this matter of 2 weeks.
Serial number 10, MS Raghavendra, Sinchana MR.
Leaves this matter after 2 weeks.
Serial number 11, Nagaraja S.
In this case, I am open for the petition.
Yes.
But in this case, suit for partition has been filed by the husband of the respondent number 1. And thereafterwards, before summons has been served on the defendants, defendants are none other than the father and mother and the sisters of the plaintiff.
Suit for partition.
Suit for partition. And before serving the summons, they have entered into the compromise. He has taken all his sisters and father, he has obtained the signature in the document as in the compromise.
You are also defendant without your consent. How that?
They were also present, he did not, he was aged about 80 years.
Now, what is that order you are challenging here?
Order under challenge is the compromise entered into before the Lok Adalat.
No, that you cannot file a writ petition. You have to file writ petition.
As far as Lok Adalat is concerned, so I cannot prefer an appeal.
No, you have to file a writ under GM, not the CAPC.
It is under GM. It may be classified as
Yes.
the GM
In
only.
this writ petition, petitioner has called in question. Really the order.
Order is next B minutes.
Annexure B,
Please,
page.
in page 19 minutes. 19, the operative portion of the order is available in page number 22 minutes.
Yes, called in question.
21.
Order compromise degree passed by Lok Adalat. The office is directed to reclassify this as in a GM RES and post before the roster bench.
May I request for a date, minutes?
Move ಮಾಡಿಯಲ್ಲಿ. Yes.
Cell number 12, Arvind Basappa Reddy.
Appear for petition.
Hmm.
This is a case where my lord, the petitioner had purchased the property, my lord, during on 2/4/2005. Then my lord, he has engaged in an advocate and engaged in an advocate to appear. What has happened, my lord, the petitioner had a major health issue, my lord, because she had irregular pregnancy issues and all that. She was unable to attend the court, In the meanwhile, my lord, the respondent has filed a petition for partition suit. And the advocate appeared for some time, my lord, filed a retired memo before the court. That was not communicated to us. And the court passed an order, notice to the petitioner. No notices is served. Ex parte order has been passed. Granting the decree is passed of Venkatama. Now, what has happened, the Venkatama herself is the claiming.
That order you are challenging now.
Challenging is the order, a miscellaneous petition filed to challenging the order passed by the page number.
No, you have filed in a suit.
19.
You have filed in a, what is the petition you have filed?
I have filed miscellaneous petition.
For under which provision?
Order 9 rules and order 5.
Order 9
And
rule 13.
court directed notice, no notice served.
No, that ex parte order has been passed.
Yes, ex parte order.
Where is that order?
That page number 54, last can 54.
Order 43 rule.
The portion is 66, your lordship.
No, where is that trial court order, Mr.
19.
19.
19. Issue notice that the order passed, but no notice served us.
Alala, I want to see
Sorry.
where is that order.
Sorry. Ex parte.
Ex parte order ಎಲ್ಲಿದೆ?
We filed an application for stay of the proceedings in view of no notice served and no occasion has been given to us.
You have
But-
filed application under order 9 rule 13. Where is that order, ex parte order, Mr.? Trial court order ಎಲ್ಲಿದೆ?
54 ex parte order for me.
ಎಲ್ಲಿದೆ ಅದು order?
File ಮಾಡಿ part of the records. And 66 is the portion of the order.
60?
54 is the order.
54 is the
6
order.
is the operative portion.
ಯಾಕೆ ಇದೆಲ್ಲ ಪಿನ್ ಮಾಡಿಟ್ಟಿದೆ? Suit of the plaintiff hereby degreed with the cost, plaintiff jointly so and so. Defendant cost so and so. Now you have been placed ex parte.
Also, no notice served also. The ex parte ಆಯ್ತು ನಾ ಹೇಳಿದೆ the reason I have stated my lord because of her bad health, irregular health.
Yes, take notice. Yes, notice.
I'm seeking because FDP ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನಾಳೆ ಪ್ರಾಬ್ಲಮ್ ಏನಾದ್ರು ಆಗ್ಬಿಟ್ಟಾತು ಅಂತ ಅದಕ್ಕೆ ಒಂದು ಇಂಟೀರಿಯಂ ಆರ್ಡರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
See, what if there is anything is passed in that FDP, you can challenge that.
Again, another
No, this is different. FDP proceedings, you have to be filed separate, yes.
Serial number 13, case Harish for petitioner Guru Raja Shetty K.
At non-filing of return statement, I filed return statement along with IA. Of course, delay is about 10 years in filing the return statement along with IA. But kindly similar page 82 and 83.
Good
for a declaration of a 1985 sale deed. But that clever drafting principle will apply here, not. Suit filed in the year 2015, seeking declaration in relation to sale deeds and documents of the year 1989. But I have entered appearance through my, I have admitted not. I have, it's not, I'm not saying that I did not receive summons or anything. I entered through my advocate, Wakalat filed in June 2015. But kindly, for a moment, come to page 82 and 83. Written typed copy of the order sheet. But even in 2024, Lord, the service is not complete. There are about 30, I am the defendant number 37. There are several defendants. But even in 2024, November 2024, only here service is taken to be completed. I am the only contesting defendant. Page 82, last part, 17/12/24. Avattu plaintiff evidence anta bandide. Adalmele IA for amendment haktare 83 li. Page 83 li. IA for amendment allow agutte for amended plaint antare. Amele for additional written statement antare. 22/2025 ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ತಾವು ನೋಡಿದ್ರೆ it is posted to 18/3/25 for additional written statement. On 18/3 I have filed the IA along with all that I am requesting is an opportunity to contest.
No, see, that is not that. Now if you allowed, then he will file, he will file another application for that. That will go on.
Perhaps of 10 years ಮೇಲೆ
ಅವ್ರಿಗೇನು ಅನಾನುಕೂಲ ಆಗೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅನಾನುಕೂಲ ಅಲ್ಲ. Diligent, what that word says. It is not that whether it will prejudice or not.
Yes.
First thing is that whether you see that order 8. Where is that order passed by the trial court?
Order also kindly come to page.
Now, what is the stage in the suit?
ಅದೇ ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾಗ
further evidence my lord.
No, ಏನಂತ ಏನ್
Where is that order? Order.
Not a very speaking order. Page 57. It starts at page 55. Defendant number 37 has filed present application seeking delay in filing return statement to be condoned. It is contended that even after receiving notice from the court, he appeared through his counsel and forgot the next date of hearing. Further, in the meanwhile, his father had died due to ill health and that he had taken treatment for nearly 3 years.
I think now that it is not that now evidence stage, they will
my
impose
lordship,
cost and permitted him to do that.
No, my lordship is the illegal transaction suit for partition.
You know, notice agilla,
but anyway, it's the very poor family, my lordship. They kindly see that.
Alla adukku return statement.
Correct. But what happened, my lordship? It is 2015 matters. They are not filed the return.
No, 2025 process is not completed.
No, my lordship. Already his process is completed.
See that order sheet, Mr.
Yes, my lordship.
2025, you have filed an additional written amendment of plaint.
And it is posted for additional.
No, that is the additional, my lordship. The ones is filed 2015, they are filed the wakalat.
No, even 2025, it is still in the place of pleading. That's what I'm asking.
Yes, correct. Yes, correct. My lordship
Not
is
that
correct.
important. See, if it is the stage of arguments or evidence and all, then it will cause a prejudice.
My lordship, once is allowed this application in several, it's the defend, my lordship, more than 37 defend. No one can not file the WS. It is post.
They have not filed. He has filed it in the 2025.
No, there is anyone is not filed the WS, my lordship. It's once is given opportunity, then other party has come. It's not finalized, my lordship.
Yes. Yes, what is that value of that property?
It's more than, my lordship. It is the 3
My friend says he is poor, but I am saying I am also poor. I have taken care of.
What is that value of that property?
Property I have not seen.
What is that value? Mr.?
Property, my lordship, it is the 4 acres property.
At value ಎಷ್ಟು ಹೇಳ್ರಿ 4 acres depending
It's
upon.
more than 1 crore, 2 crores, my lord.
Yes, you pay that cost of rupees 50,000, Mr. We'll allow that.
ಅವ್ರಿಗೆ ತಂದೆಗೆ
No, if you are succeeding 4 acres property, Mr.
kindly see page 108.
No, if you are ready to pay 50,000 rupees cost, then I will allow
kindly see
that.
page 108.
Yes.
108. ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ 50 ಲಕ್ಷ ಅಂತ ಹಾಕ್ತಾರೆ.
ಆಯ್ತು, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಇದೆ.
50
It's the now property value, my lordship.
ಇವ್ರಿಗೆ notice order
in
ಆಗಿಲ್ಲ.
the-
But anyway,
in the-
page 108 ಅಲ್ಲಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅವ್ರು ಹಾಕಿರೋದು ನಾನಲ್ಲ. ಇವತ್ತು
It's the present value of more than 3 crores, 4 crores.
ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಇವ್ರು ಇವತ್ತು ಕೇಳಿದಾಗ ಕಾಸ್ಟ್ ಹಾಕ್ತಾರೆ ಅಂದ್ರೆ ಇವ್ರು ಜಾಸ್ತಿ ವ್ಯಾಲ್ಯೂ ಹೇಳ್ಬಾರ್ದು. ಇವ್ರು ಏನ್ ಇಲ್ಲಿ he has to stand by his pleadings.
What is that pleading?
50 lakhs ಅಂತ ಅವರೇ ಹೇಳಿ.
ಆಯ್ತು, 50 lakhs ಗೆ 50,000 rupees. You pay that cost, I will allow that. Otherwise, I will say that it's. No, Mr. It's not allow that.
ಅಲ್ಲ ತಾವು ನಿನ್ನೆ 9 years ಗೆ 15,000 ರೂಪಾಯಿ ಹಾಕಿದ್ದೀರಾ.
It's all ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು ಅಂತ.
ಇದು
ನೀವು ಯಾವ್ದೋ ಹಳ್ಳಿಯಲ್ಲಿ ಪಾಪ ಪ್ರಾಪರ್ಟಿ
ಹಳ್ಳಿ ಇದೆ.
25,000
No,
ರೂಪಾಯಿ.
that is jurisdiction of the Rabbalapura city, my lord.
Yes. What you say that?
50,000 ರೂಪಾಯಿ ಬಹಳ ಆಗ್ಬೋದು.
Otherwise, you have given up for 10 years, Mr. That means to say you are not interested in the property.
ಕ್ಯಾನ್ಸರ್ ಎಲ್ಲ ಟ್ರೀಟ್ಮೆಂಟ್ ಎಲ್ಲ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀನಿ.
Nothing else, my lordship. Affidavit, kindly see the affidavit, my lord.
Yes.
ಅಲ್ಲ ಇವರು ನೋಟಿಸ್ ಆರ್ಡರ್
Kindly see the affidavit, my lordship. I read the affidavit.
Serial number ಎಷ್ಟಿದು?
13.
13th. No, he is appeared. He has filed an wakalat.
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ಇನ್ನು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು.
ಆಯ್ತು.
ಅಲ್ಲಿ ನಾವು ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ.
ಅಲ್ಲ, they are informed before the trial court. That reason, my lord, I filed
Page
the wakalat.
127.
ಆಯ್ತು, you pay that cost, then I will.
Page 127.
Yes.
ಕ್ಯಾನ್ಸರ್ ಎಲ್ಲ ಆಗಿದೆ. ನಾವು
ಆಯ್ತು, ಅದೆಲ್ಲ ನೋಡೇ ಬಿಟ್ಟೆ 10 ವರ್ಷ ಆದ್ರೂ ಕೂಡ we are giving an opportunity, Mr. Yes.
50 ಬಾಳ 50 ಬಾಳ
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ಅದೇ ತಾವು ನಿನ್ನೆ ಮಾಡಿದಷ್ಟು 9 ವರ್ಷಕ್ಕೆ ತಾವು 15,000 ರೂಪಾಯಿ.
No, it's all depend. Therefore, I asked that value of the property.
This is the illegal transaction, my lord.
Value is more. All that false litigations will also more. We have seen that, Mr. Yes. Filing in a return statement after 10 years, if you are not interested, it's create so many things, Mr. Yes. Yes. 35,000 rupees in this writ petition. You are the petition plaintiff.
Yes, my lord.
Yes, in this writ petition. Petitioner called in question. Order dated 27/9/2025. Passed by additional senior civil judge Doddaballapura in OS number 146 of 2025, whereby application filed by the defendant petitioner seeking permission to file the return statement has been rejected. Plaintiff has filed in a suit for declaration. Summons has been served when?
June 2015 I have filed wakalat.
Has been
26/6
served to the petitioner in the year 2015. After lapse of more than 10 years, the application is filed for permission to file a return statement. Since there is a delay is not properly explained, the trial court has rejected that application. Learned counsel appearing for the rejected. Learned counsel appearing for the petitioner submitted that. Who has suffering from cancer?
his father, petitioner's father,
Petitioner father was suffering from the cancer. Petitioner was
admitted to different hospitals over a period of 3 years.
unable to instruct the council to file an return statement. The
Agriculturist with no other source of income.
Yes. Be that as it may, even in the year 2024, the service to that other respondent was not completed. When that application has been filed, issues frame agita.
Illa.
Additional
One
issues.
cannot file the WS, my lordship. Is directly posted for the evidence.
Yes,
ಅಲ್ಲ, ಹಾಗೆ
2025.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇಶ್ಯೂಸ್ಗೆ ಅಂತಾನೆ ಒಂದು ಸ್ಟೇಜ್ ಕೊಟ್ಟಿದೆ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
It's the
2025.
additional issues, my lordship.
In the 2024, the service has not completed. Considering now that matter is posted for evidence, considering this aspect of the matter and also in the interest of justice, this court is of the opinion that imposing the cost, the application may be allowed. Accordingly, writ petition is allowed, order dated so and so is set aside. The application filed by the petitioner along with that written statement is allowed, and written statement is directed to be taken on record. Subject to condition, petitioner has to pay cost of rupees 35,000 to that plaintiff.
25.
Yes, 25,000 to that plaintiff.
Oh, my lordship is a very poor, my lord. My lordship, the kindly, there are no documents, scans or whatever it is, they are not produced any document, my lord.
25,000 rupees to be payable to that plaintiffs by next date of hearing. What is that next date?
Next date, my lordship,
By next date of hearing.
10/10/6.
Yes.
Right. It's a very poor family, my lordship. That reason I am submitting.
Yes.
Cell number 14 disposed of. Cell number 15 Ganesh Bhatt OH for petitioner. Naveen Kumar P. Serial number 15.
None appears. Leave this matter for 2 weeks.
Cell number 16 BC Venkatesh.
Please, my lord.
Lord, in a suit for partition, filed by my lord, my younger sister, it came to be decreed, my lord, thereafter FDP was filed. My lord, in an FDP, my lord, my younger brother's son, he filed an objection saying that, my lord, I already executed, released it in favor of, my lord, in their favor. So immediately, my lord, I came to know that I filed an application. Before that, my lord, I filed a detailed complaint and police gave an endorsement stating that since the FDP proceedings, I cannot proceed further. In fact, my lord, immediately I filed an application on IA number 8, seeking to challenge that released it executed by me. Means, my lord, by fraudulently they got executed my share. Then, my lord, the court, my lord, after calling for objection, rejected my application containing that I have to file a separate suit. In fact, it is not covered by decision saying that not in an FDP, it is a continuation of the original suit. So whatever they claim not between the interested parties, not I have to adjudicate between the FDP, final degree proceeding.
Where is that order you are challenging?
Please, not an impugned order. Impugned order, my lord, the page number, relevant page number, my lord, page number 24, my lord.
24.
24, my lord, last, my lord, fifth line. According to section 80 of Indian Evidence Act, court can presume the document as genuine unless the contrary evidence against the receipt of the document. Therefore, if any executant of a document challenging the registered documents stating by claim fraud obtained the document, then the executant of the document must file suit for cancellation of deed, and the executor must obtain the decree from the court. Therefore, this court is of the opinion that the application filed by respondent number 2 is not maintainable.
No, even for cancellation of that documents can be urged in the FDP.
Please, that is what, my lord, this court held. In page number 2021. I have only one copy. Let me read, my lord, then I will pass it on. Just one relevant portion that I will read. Page number 21. 21. Yes, my lord, I answer point number 1 by holding that the final decree proceedings on a share being allotted to one of the parties, if such party were to expire during the pendency of suit, proceedings have to be left so on so on. Then, my lord, in previous paragraph, 16.10, sorry, page number 20. In the present case, the dispute between the 9th defendant, legal heirs of 10th defendant, and as above, the share of 10th defendant is required to be allotted some sort. In order to draw final decree court will have to power and competent to decide all issues and disputed between the parties, so as to give effect to a final decree, including determination of any claim of legal hardship, heirship, testamentary succession, etc., so long as it required to drawing up a final decree.
No, that is there, Mr. Cancellation.
In this case, they will challenge the will.
No, see, cancellation of the will. See, on the basis of the will, the rights can be cancellation of the will or cancellation of sale deed or cancellation of that any lease deed can be done it in that FDP proceedings.
Not this, since it is a continuation of the original proceedings, not the FDP.
No, original proceedings nobody has challenged. How can we? See,
after filing,
RFA is the original proceedings. In the RFA, you can file an application for. No, show me a judgment.
Please.
In FDP proceedings, you can seek for a cancellation of that document.
There is a judgment on this one. The mark madidane, but I have only one copy. In fact, I marked not relevant portion.
Effect of the final degree, including determination of any legal rights, testimony, succession, all that can be done. Whether he is in a legal heir, whether he is
even I can challenge the registered document.
Show me that it can be sought for set aside in that.
Mark madidane. Mark madidane.
I thought.
I have only one
During the
copy.
pendency of the proceedings having left behind the will, dispute related to the will between the existing parties, the proceedings shall be determined final degree proceedings. Will melgade, you have any right or not passing that will, mister.
No, my lord, in the present proceedings, after passing a decree.
No,
my lord,
you are
without my
not
knowledge-
claiming a right on that release deed. You are saying that release deed has to be cancelled. Can it be done it in that FDP
Yes,
procedure?
according to my
Show me
decision,
that this judgment is not applicable. They said
It is there.
this is on the basis of the will, they are claiming in a right, mister. It is not passing of in a will.
My lord, in the case, my lord, only my share has been released in their favor by fraudulently. That too, my lord, after passing a decree.
No,
Passing a decree.
you are,
Before filing FTP.
no, your relief is that to quash that will or that set aside that will.
Cancellation of the.
Cancellation of a will.
Please.
Can it be done in that FDP proceedings? Show me.
That is, my lord,
This is not the judgment. You see that?
Please,
ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
sir.
ಅಲ್ಲಿ will ಮೇಲೆ they are claiming on that success.
My lord, there is an observation made by this court. Please, may I permit reading.
Yes.
But in this case.
Yes,
My lord,
tomorrow.
in pair number 9, my lord, it is referred.
Day after
In
tomorrow,
my lord, in
Friday.
Supreme Court judgment.
Judgment
ಒಂದು pair ಅಷ್ಟೇ ಓದಿ.
ಕೊಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ತಂದು ಕೊಡಿ.
Please.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೆಫರೆನ್ಸ್.
Please.
ಅದು ನೀವು ಇಟ್ಕೊಂಡು ನಮಗೆ ಕಾಪಿ ಇಲ್ಲ.
I'm sorry, sir.
Yes.
Tomorrow.
Get that copy, mister. Yes. Day after tomorrow.
Please.
Cell number 17, but Ganapati.
Kindly have it on 25.
Yes, sir. The request is this matter of 2 weeks.
25th. Senior ತಾಯಿಯವರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅದಕ್ಕೆ
25th, 29th, yes.
Cell number 18, Raja Aditya Sadashivan for petitioner, connected matter.
For respondent.
Joseph
Yes.
Anil Kumar.
On the last occasion, my lord, the petitioner submit that they will produce some documents to say that the material which I supplied was rejected and returned. Other basis ಮೇಲೆ ಯಾವ್ದು documents ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
Yes. Yes, mister.
Yeah, it appears that all the rejection was done over WhatsApp. Three-year-old WhatsApp communication, they are still sourcing out the WhatsApp communication. But admittedly, there has been rejection. They have also acknowledged the rejection. And they have.
Now, where is that WhatsApp? You have copy?
ಇಲ್ಲ ಅವ್ರು 3 ವರ್ಷ ಹಳೆ ವಾಟ್ಸ್ಆಪ್ ಅವ್ರು ತೆಗಿಸ್ತಾ ಇದ್ದಾರೆ.
When do you want?
Maybe 1st of June.
Yes, sir.
Let me submit. It's a false statement.
ಅಲ್ರಿ ನೀವೇ ಹೇಳಿದ್ರಿ ಅವ್ರು ಯಾವ್ದೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ.
ಅದಾದ್ಮೇಲೆ
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರು ಕೇಳ್ತಾರೆ.
ನಾನು ಅದಕ್ಕೆ learned friend wants to argue without those documents. I am also ready on merits. ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ.
Please this matter 1st June at the request of counsel for the parties. Yes.
In preliminary hearing.
Yes, same.
Serial number.
Date
1st June.
Serial number 19, Suresh M.
Plus petitioner.
Yes.
Plus petitioner challenge my lord's compromise decree.
Plus the provision was, in the application, my lord, the provision was wrongly mentioned as 9-13. Lord, said with section 151, he had mentioned, my lords, but prayer is correctly mentioned, my lords.
Where is that?
Lords, compromise application, my lords. Plus annexure B, the
Annexure?
order, annexure B is a compromise decree. Application.
What is the suit for?
Suit for partition, my lords. The
Who has-
parties have settled the my lords issue. And my
Who
lords,
are you?
Lords, I am the plaintiff.
You are the party.
Yes, my lords, I am the party. But my lords, in the allotting, my lords, the properties, my lords, they wrongly mentioned in the compromise decree, my lords, because of that reason, my lords, the plaintiff had challenged the compromise decree under, my lords, only because, my lords, the provision was wrongly mentioned, my lords, the.
Where is that order?
My lords, annexure E, my lords, misorder, annexure E.
Annexure
Annexure D, my lords.
D.
Annexure D is the application.
Annexure D is that application.
E is the my lord's order. This order.
What is that application you have filed?
My lords, application, the provision was wrongly mentioned, my lords, but prayer is correct, my lords.
What is that prayer?
Prayer, my lord, to set aside the compromise decree entered between the parties.
On what ground you are seeking set aside in that compromise?
My lords, because, my lords, as per we have settled the my lords, issues between the parties, the schedule is wrongly, my lords, the schedule mentioned in the compromise decree is different. What we have, my lords, discussed is different.
my lords, within 6 months, my lords, on the decree.
No, is it your case that they have played in a fraud on
Fraud,
you?
yes,
Where
my
is that pleading?
Lords, kindly see, my lords, page number 62. Para number 10 in the start agreement.
Yes, read.
Unfortunately, very recently, the petitioner heard that first week of June 2014, from the mouth of his neighbor, that respondent at instigation of collusion and other respondent planning to sell away the properties whichever given for the life, being surprised, the petitioner tried to convince the mother and brothers, but they blindly refused to hear the advice of the petitioner. In fact, even the claimant that it is all over respondent is liberty to sell the properties, her will being shocked. The petitioner approached the London advocate Trigger, who is turn spoken to the respondents over the phone, advised them to go to the accordingly to the settlement, and to also told them not to alienate any properties. But the respondent did not heed the advice, and the advocate has regretted and told to take appropriate action deems fit to take his better interest. Hence, the petition to set aside compromise decree.
Advised them to go on according to the settlement and also told them not to alienate the property, but the respondent did not heed the advice and the advocate has regretted. ಎಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಏನು ಹೇಳಿಲ್ಲಲ್ಲ.
Plus, first parallel start.
ಎಲ್ಲಿದ? Yes, notice.
Also, I also sought for interim order.
Notice, let us see. Yes.
Cell number 20, Bhagat Venkatesh R for petitioner, SB Lakshmi.
ಸರಳಿ ಸ್ವಾಮಿ, ನನಗೆ ಕೆಳಗಡೆ ಕೂಟಲ್ಲಿ FTP ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾಗಿದ್ರೆ ಒಂದು ಮೆಮೊ ಹಾಕಿ ರಿಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಐ ಫೈಲ್ಡ್ ದಿ ವಕಾಲತ್. ಮೈ ವಕಾಲತ್ ಮೇ ಬಿ ಕೈಂಡ್ಲಿ ಟೇಕನ್ ಆನ್ ರೆಕಾರ್ಡ್, ಮೈ ಲಾರ್ಡ್, ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 10 to 22, ಮೈ ಲಾರ್ಡ್.
ಇದೆ ನಿಮ್ಮ ವಕಾಲತ್ ಇದೆ.
ಅಲ್ಲ, ಅದು ನಾನು ಪರ್ಮಿಷನ್ ಇಲ್ಲದೆ ಫೈಲ್ ಮಾಡಿಬಿಟ್ಟು ನೋಟಿಸ್
after hearing will permit. You want time for this thing? What you want now? Yes,
ನನಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
I'll serve a copy, my lord.
Yes.
Maybe given a short date before vacation, I'll
Monday.
serve a copy, my lord.
Monday, my lord.
Yes. Leave this matter.
Because matter is of 1989, my lord.
Yes.
89 decree, my lord.
Yes. Now what is that challenging?
My lord, I have challenged the commissioner for survival. They have directed for a survive, my lord. I have challenged that order, my lord.
In FDB proceedings?
Yeah, FDB proceedings.
Yes, when that order of the commissioner is passed.
ಇದರಲ್ಲಿ may make one submission.
Yes, 8/1/2026. Yes.
ಈ ಪೆಟಿಷನರ್ ಇದಾರಲ್ಲ ಸ್ವಾಮಿ,
ಆಯ್ತು, ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ? ಟೈಮ್ ಬೇಕಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ, ನನಗೆ ಕಾಪಿ ಬೇಕು ಸ್ವಾಮಿ.
ಆಯ್ತು, ಕಾಪಿ ಕೊಡಿ.
Immediately before vacation itself, my lord. I'll serve a copy and I'll
Yes,
get it.
29th.
Please,
Yes.
please.
Cell number 21, PB Raju for petitioner, MOV Manjunatha.
Appearing for respondent, your lordship, filing NOC wakalat. Filing NOC wakalat, your lordship.
Yes, yes, Mr.
Divergent findings, my lord. The suit for injunction. But the trial court would grant me an order of injunction in respect of a road which is lying in between the suit schedule properties. But the trial court categorically extracts all the schedules in respect of all the properties.
Filing NOC wakalat, my lord.
All I'm saying is, my lord, now what the first appellate court says is, ಈಗ ಒಂದು ಫೆನ್ಸ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಎಲ್ಲ ಶೆಡ್ಯೂಲ್ಗಳು ನೋಡ್ಬಿಟ್ಟು ರೋಡ್ ಇದೆ ಅಂತ ಫೈಂಡಿಂಗ್ ಕೊಡ್ತದೆ. ದಿ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಸೇಸ್ ದಟ್ ಇಸ್ ಅ ಮಿನಿ ಟ್ರಯಲ್. My lord, one of the burdens, suit for injunction. There is a road which is leading in between the two properties of the
Trial court has granted an injunction.
Trial court.
Appellate court.
Appellate court says, since the trial court has extracted all the schedules, it is a mini trial antade. My lord, it cannot be a mere formality. The trial court necessarily has to see the suit documents.
Yes.
Suit documents examine ಮಾಡಿದ್ನ mini trial ಅಂತ ಹೇಳ್ಬಿಟ್ಟು set aside ಮಾಡ್ಬಿಡೋದು.
Where is that order?
My lord, kindly come to page 20 onwards, my lord. Page 18 in the Odan, sir. Para 8. The trial court, after hearing both parties, has allowed the said application and has restrained the appellant defendant herein from blocking or closing the usage of the existing 8 feet road.
That, during the pendency of that appeal, any stay is there?
One component. All I'm asking is, let there be a status quo, because they are now, one minute, sir. You are now claiming a right over the entire passage. Now, a compound kallak nilsidare. Let it be as it is, because tomorrow what they will do?
4 years back,
No, it's still pending.
The trial court, what they have held is, they have sought for mandatory injunction to demolish the Now they have filed an application again, mandatory injunction seeking
Naturally.
stay of this.
No. Now, whatever the position as on today, you maintain status quo. What is wrong in that? That is also benefited to you if that.
Because my apprehension is tomorrow they will further develop.
We have tomorrow. I don't know what is the present situation.
What is their present situation should be maintained. See,
That is all I am
during the
asking.
pendency of that appeal before that first appellate court, is there any stay of that trial court judgment?
No.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಒಂದೇ ಸತಿ ಈ ತರ ಕೊಟ್ಟಿರೋದು.
Then if take it better, otherwise this from 2023 he has any benefit of that trial court order for 3 years. Think that status quo or you want that stay?
Please, I'll take instruction.
Yes, tomorrow.
Wakalat.
File it in the counter. Yes. On Friday. Yes, leave this matter on Friday.
Cell number 22, BM Siddhappa for petitioner, Ashok P. Patil.
For the respondents, my lord, I seek for an accommodation of 1 day, my lord.
I am opposing this. This is the third time they are.
May kindly be posted on Friday, my lord.
Because they are.
What is that urgency, Mr. Siddhappa?
What has happened in the FDP proceedings? The main petition is different and the amendment seek is a different. And in the what is the preliminary decree is not incorporated in the amendment application. That application came to be allowed. Against which I am before your lordship.
Now, when is the suit? So when is that FDP proceedings next
Now,
date?
now the trial court ordered for commissioner and submit the report without in accordance with the preliminary decree.
Yes, madam.
Kindly, my lord, 1 day's accommodation.
Your
On
lordship
Friday,
kindly
it
see
may
the
be.
order sheet, how many times they were taken. Last occasion also your lordship granted time.
Yes, council request respondent
On Friday, it may kindly be posted, my lord.
as a last chance at the request of council for the respondent. Use this matter on Friday. Yes.
Obliged, ma'am.
Friday, otherwise we'll pass an order.
Obliged.
Cell number 23, Siva Prakash M for petitioner, K. Chandan.
For the petitioner, my lord, challenging IN number 11, 12 and 13, my lord. Production of additional documents recall.
Suit for?
Suit for, my lord, cancellation of revocation of agreement. Sorry. Page number, my lord, can you see the page number 22 of the petition?
No, you are the plaintiff.
Please, my lord.
Suit for?
Suit for, my lord, the cancel the registered revocation of general of power of attorney.
Cancellation of GPA.
Yes, my lord.
No,
So, my lord, already.
suit is for declaring that the revocation is wrong.
Revocation is wrong. Yes. You have executed an GPA.
Yes, my lord.
Yes. Now that, what is that application you are challenging?
My lord, recall, reopen and addition, production of additional documents, my lord.
Why?
A number 11 to 13, my lord.
What was the stage?
My lord, both the sides evidence completed, my lord.
It was
after
for arguments, final argument.
Question
So,
for argument.
whose evidence you wants to recall?
Plaintiff, my lord.
Plaintiff
PW1,
evidence.
yes,
You are the plaintiff.
yes, my lord.
Then what will be that next consequence? Defendant has to again adduce that evidence, recalling that. Then it will be that,
Immediate
saying that all process, Mr.
My lord, if your lordship permits me, I would like to make some submissions on this. My lord, the subject land is a granted land and the defendants are the legal heirs of the original grantee. My lord, it appears that the plaintiff had taken some documents saying that he will get permission from the government to sell the property. And it is the contention of the defendants that only permission to GPA was supposed to be given only to secure permission of the government to sell the property. However, there were clauses inserted with respect to alienation and other things. And hence they went and revoked the GPA that was issued, which is now under challenge. My lord, the issue here is I would like to take your lordship to para 3 of the written
What is your right to say that he cannot be revoked? Is there any consideration?
Yes, my lord.
No consideration, my lord.
Even if it is a consideration, it is granted under that depressed class.
PTCL.
Then
SC/ST
no,
grant.
right, Mr. He cannot be give any, even if you don't take that this is this thing, one is GPA, even if it is in a sale deed.
Lord, what happens in that case is using the GPA, the plaintiff goes ahead and executes an agreement to sale with the third party.
Is there any, who is the position in that property?
My lord, according to them, they are in the possession. According to me, I am in the possession.
You are in the position.
I am in the
My lord,
possession of the land.
as per GP and agreement, my lord, I am in the position, my lord.
Then okay, we'll stay that suit, we'll hear that.
My lord, I would like to make a submission here. I would like to take your lordship to paragraph 3, page 5 of the writ petition, my lord. My lord, 4-5 lines after paragraph 3, my lord.
No, where is that impugned order?
My lord, the impugned order is at page 90, my lord.
90.
90. The reason why the learned trial court has rejected the application is that no reasons are forthcoming. What is to be done is not forthcoming because the application doesn't say whether they want to do further examination in chief or examination in chief of the plaintiff or defendant's cross examination. Nothing is forthcoming. And the reason and these.
You read that.
My lord, at page 92, my lord.
Para 5.
Para 5. On going through the records, it appears that the applications are filed when the stage was posted for arguments. In this case, the evidence of both sides has been closed. At this belated stage, the present applications are filed by stating that the documents ought to be produced necessary and same are required to be marked in the present suit. However, IA 11 of the plaintiff has sought to recall the order dated so and so to produce additional documents. In IA 13, it is sought to pass appropriate order to produce the documents. IA 12, it is stated that the case is required to be reopened from the stage of arguments to evidence. On careful perusal of the affidavits, there is not even a single word by the SPA holder of the plaintiff that whether the stage is to be recalled for further chief of PW1, further evidence of plaintiff or for evidence of defendants. The application is drafted in a casual manner without specially stating what the SPA holder of the plaintiff intend to examine, which of the witness. Unless there is specific prayer, the applications cannot be allowed by assuming something by the court. Under such circumstances, I have the opinion I11.
ಏನು ಇಲ್ಲಲ್ಲ ನೀವು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕು ಯಾಕೆ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕು ವಾಟ್ ಇಸ್ ದಟ್ ಯೂಸ್
Page number
and
39.
apart from this, my lord,
39 annex
this court has held that even executing a GPA to secure permission is also null and void. This court has this is a settled principle of law.
As far as the main matters to be decided.
Yes, main matter. Now the trial is over, and what this
Secondly, page number 41, the application and acknowledgement submitted to the revenue authorities through the GPA holder. This dependent idರಲ್ಲಿ ನಮ್ಮ ಮೂಲಕ application ಆಗ್ತಿದ್ದಾರೆ grant ಗೆ permission ಗೆ ಎಲ್ಲಾನು ಆ documents it is necessary for adjudication.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಇದೆ ನೀವು
there is no reason, my lord, at page 49, my lord, the documents
dispute that he has given a GPA to you.
Yes, ma'am.
For taking a permission. He has also having a right to revoke that. That doesn't mean that, see, it is not any other general provision. It is under the PTCL Act.
Yes.
It is not his property. It is in a property vest with the state. He cannot be alienated for a certain period. And then after that act came into the force, without the permission, he can't do it.
Only 3 documents, my lord, without further delay, my lord.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ತೋರಿಸಿ.
What documents? Page 49 may be looked into, my lord.
Yes.
Page number 40 onwards, my lord.
41,
my lord.
49, endorsement issued by the Deputy Commissioner Bank.
40 what is there?
41, my lord. Application and acknowledgement submitted to the revenue authorities. Correspondence of the revenue inspector and village accountant showing efforts undertaking for sale permission. Internal communication related to financial delegate with the dependents and GPA executed in favor of the plaintiffs. ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೆಸಸರಿ ಇದೆ ಸ್ವಾಮಿ ನಮಗೆ ಅದರಲ್ಲಿ
application and acknowledgement submitted to the revenue authorities, there is no dispute. There is no dispute. He has given a GPA. Main question is that whether he can execute it in a GPA.
Whether such GPA is valid or not is the main question.
Without notice, my lord, they are cancel my revocable general.
ಅವ್ರು ಏನು ಮಾಡದೇ ಬೇಡ್ರಿ. That automatically if you go before the TSC, everything will go, mister. Nothing will be survived. Yes, you have now filed in a bold statement that too when the matter is posted for arguments. Yes, that's all. Tali in this petition. ಇವೆಲ್ಲ ಸುಮ್ಮನೆ ಡ್ರ್ಯಾಗ್ ಮಾಡಕ್ ಅಷ್ಟೇ 2 ದಿನ ಅಂತ ಅಷ್ಟೇ. Yes, filed an application. You filed this writ petition. Questioning order dated 14/1/2026 passed by Principal Senior Civil Judge JMFC Devnalli on IA number 11/12/30, whereby application came to be dismissed. Plaintiff has filed in a suit for cancellation of revocation of GPA. On service of summons, defendant has appeared through counsel, has filed written statement. On the basis of the pleadings of the parties, the trial court has framed that issue. Thereafter, plaintiff as well as defendant has adduced their evidence. When the matter is posted for arguments, the plaintiff has filed this application, IN number 11, for recalling that order dated 5/8/2024, IN number 12, reopening the case from the stage of argument to adduce that evidence, IN number 13, to produce the documents. The evidence of plaintiff has been closed on 5/8/2024. When that application is filed?
15/7/2025.
Thereafter, matter was posted for argument. What is the date of application?
Applications 15/7/25.
15, after lapse of nearly 1 year, the application has been filed for recalling that order dated 5/8/2024. Even in that application, they have not specifically stated to recall that which witnesses and what are the documents they have to be produced. Since the application is filed in casual manner and of the belated stage, the trial court has justified in rejecting that application. There is no error or illegalities in the order passed by the trial court. Writ petition is devoid of merit, accordingly dismissed.
Cell number 24, Ravi Shankar A.
Great.
for petitioner.
Yes,
Krishna, my lord, suit for specific performance.
yes,
Trial court granted specific performance. I executed the decree.
yes.
Trial court also granted me an order saying that the Shirastar to be deputed
Hmm.
for execution of the sale deed because the defendant/JDR did not turn up. When the Shirastar went to the sub-registrar office, the sub-registrar did not want to register the document for want of 11E sketch. We produced the two judgments of this honorable court saying that in spite of not having a 11E sketch, they had to execute because it's the order of the court that is more relevant. In spite of that, he gives a endorsement in page 47 on the commission. When is the commission warrant? On the commission warrant, annexure E, in page 46 and 47. 46 is the commission warrant issued by the court. 47 is the endorsement. ಈ ನ್ಯಾಯಾಲಯದ ಜಾರಿ ಸಂಖ್ಯೆ ಆದೇಶದಂತೆ ಸೊ 17 4 ಎಕರೆ ಪೈಕಿ 3 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು ನೋಂದಾಯಿಸಲು ಕಾವೇರಿ 2 ತಂತ್ರಾಂಶದಲ್ಲಿ 11E ಸ್ಕೆಚ್ ಅಗತ್ಯವಿರುತ್ತೆ. ಆದ್ದರಿಂದ ನೋಂದಾಯಿಸಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ನೋಂದಣಿಕರು ತಿಳಿಸಿರಿಂದ ನೋಂದಣಿಗೆ ಅವಕಾಶ.
There is a subsequently amendment to that act.
ಅದಕ್ಕೆ ಇಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಇನ್ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ಅಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆದಂಗಿದೆ, ವೆರಿಫೈ.
ಏನು?
Yes, amendment to that Land Revenue Act.
I will verify.
You verify that. Therefore, they are insisting that.
ಈಗ
Now,
ಕೆಳಗಡೆ ಅಲ್ಲ, ಇದು ಮಾಡಿರೋದು ಯಾವಾಗ ಸ್ವಾಮಿ? ಇದು ಮಾಡಿರೋದು ಒಂದು 6 ತಿಂಗಳಾಗುತ್ತೆ.
ಯಾವ್ದು?
ಇದು ಮಾಡಿರೋದು.
No, this amendment is long back. Maybe 1 year back there is an amendment. Land Revenue Act. Now that without 11E sketch, it will not, I think so. Verify that.
ಅಲ್ಲ, ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ kindly imagine a situation where about 20 acres are there, all granted lands. ಅದು ಯಾವುದು ಇನ್ನು ಹದ್ಬಸ್ತಾಗಿಲ್ಲ, 4D ಆಗಿಲ್ಲ, ಏನು ಆಗಿಲ್ಲ. ಸೊ 11E sketch ಆಗೋವರೆಗೂ 4D ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಎಂಟೈರ್ 20 acres ಅವರು ಹದ್ಬಸ್ತು ಮತ್ತೆ 4D ಮಾಡ್ಬೇಕು.
But if there is any law, we cannot. Just you are relying on the Justice Krishna Kumar.
ಅಲ್ಲ, ಜಸ್ಟಿಸ್ ಇವ್ರು ಮೊಗ್ದಮ್ ಅವ್ರದ್ದು ಮತ್ತೆ ನಾಗಪ್ರಸನ್ನ ಅವ್ರದ್ದು ಹಾಕಿದ್ದೀನಿ ಅಲ್ಲಿ. ಇಂಕ್ ಪೇಜ್ 55 and ink page 88. Both judgments are of recent origin, November 2025.
Yes.
November 20, kindly Can I persuade my lord to ink page 85 para 7?
Anyhow, you take notice, government advocate,
In the meantime,
by that whether that amendment has been made or yes.
ಈ ಎಕ್ಸಿಕ್ಯೂಷನ್ಗೆ ಅಲ್ಲಿ ಈಗ ವಜಾ ಮಾಡ್ತೀವಿ ಯಾಕೆಂದ್ರೆ ಇದು ಹಿಂಗಾಗಿದೆ ಇದೆಲ್ಲ ಸಾರ್ಟ್ ಔಟ್ ಆದ್ಮೇಲೆ ಅಂದ್ರೆ ಮತ್ತಿನ್ನ ನಾನು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡು
Execution ಯಾಕೆ ವಜಾ ಮಾಡ್ತಾರೆ? They have to be
ಟ್ರಯಲ್
executed.
ಕೋರ್ಟ್ ನಲ್ಲಿ ಅಲ್ಲ ನಾನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಯಾಕೆಂದ್ರೆ ಈ ತರ ಬಂದ್ಬಿಟ್ಟಿದೆ ಎಂಡಾಸ್ಮೆಂಟ್ ಅದಕ್ಕೊಂದು ಲಿಮಿಟೆಡ್ ಸ್ಟೇ ಕೊಟ್ರೆ ನಾನು ಇದನ್ನ ನಿಂತು ಯಾಕೆಂದ್ರೆ ಅದು ವಜಾ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಈ ಸ್ಟೇಜಿಗೆ ತರ್ಸಕ್ ಇನ್ನು 4 ವರ್ಷ ಬೇಕು.
Yes, then stay of further proceedings in execution 33 of 2012.
Yes.
Till next date of hearing before.
ಅಷ್ಟ
Civil judge JMFC. ಯಾವ ಊರದು?
ಆಲೂರ್.
Yes, you get that, Mr. What is the status on that?
ನಾನು ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್.
Yes, you also verify that.
Great.
Cell number 25, V. Sanjay Krishna.
ಒಂದು ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ತೀರಿ ಸರ್?
Yes.
Immediately after vacation, second week, third week of
15th June.
15th. Great.
Copy ಕೊಡಿ government ಅದು.
Yes. 25.
Lords, writ of mandamus seeking direction to consider IA number 19 to appointment of court commissioner to record the cross examination of PW1. What has happened is, my lord, the suit is for partition. Plaintiff led his evidence as PW1. He was also cross examined. My lords, when it was posted for 9th defendant to cross examine him on 6/2/2025, my lords, they filed an IA under order 3 rule 2 to be represented by a SPA holder. Without providing an opportunity, my lord, the trial court allowed the application. I challenged the same order in WP number 8961 of 2025. This honorable court, my lords, was pleased to stay the operation of the order on 2/4/2025, where your lordship may kindly find it at page 50, annexure D. My lords, after this, my lords, the only reason the PW1 is not coming before the court is, my lords, he is not well, is what their submission is. I filed an IA, my lords, seeking that let the court commissioner be appointed. I'll further cross-examine him, my lords, wherever he is in his home. My lords, the trial court has kept my IA in abeyance, and my lords is keeping the matter posted like await further orders. That be
No, that is what that tomorrow your writ petition is dismissed. What will be the consequence?
My lords, SPA holder under order 3 rule 2.
That has to be decided. You pursue that earlier matter. If that matter is allowed, writ petition is allowed, then you can seek for a direction to dispose of the case.
My lords, the reason why they have filed an IA is, my lords, to lead their further evidence. All I am seeking is, my lord, to cross-examine on the evidence which is already led by the PW1.
Now they wants to cross-examination through GPA.
Yes, my lords.
That you have challenged that. That is pending. Court has not passed final order. Just because passing an interim order is not that you are succeeded. Yes,
The court has only, my lords, stayed the operation of the order, not the entire proceeding. But the trial court, my lords, has been posting the matters like await further orders. My lords, he is aged about 85 years.
That is what that the court apprehension that tomorrow writ petition is dismissed. Then what is that effect of that order of the trial court? Is it not, it has to be permanent? Again, that they have to redo that. You take notice, we call this matter together, then we'll dispose of.
Grateful, my lords. My lords, the notice with respect to respondent number 2 to 18 may be dispensed. Respondent number 1 is only the contesting party. I'll produce the memo with respect.
Filed in a memo seeking dispensation of notice to 2 to
18.
2 to 18. Issue emergent notice to respondent number 1. This matter along with the WP 8961 of 2025.
Grateful.
Bill number 26, B.R. Vishwanath for petitioner, V. Sheshagiri Rao.
Yes, speaking the cross examination of
My lords, I
commissioner.
seek for accommodation, my lords, today senior is not.
Yes,
However, in the last,
Lordship may kindly post it after vacation, my lord.
After
a
vacation.
date may be fixed, my lords.
Yes, this matter. When do you want?
April
After
1st
vacation,
week, my
immediately
lords.
after vacation,
Immediately.
any day.
Yes, leave this matter on 4th June.
Let the execution
We
date
had
be deferred
undertook on
till
the
then.
last occasion, my lords, will get the matter deferred.
ಎಲ್ಲಿ ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ?
28ನೇ
ಅಲ್ಲಿ
ತಾರೀಕಿದೆ.
2/5 ಗೆ ಇದೆ, ಅದನ್ನ ಬಿಯಾಂಡ್ second week of June ಮಾಡಿದ್ರೆ ಸಾಕು.
Executing court is directed to defer that matter.
After
And
4.
4th June.
Yes.
Yes.
Obvious.
At the request of counsel for the respondent. Leave this matter on 4th. The executing court is directed to defer that matter beyond 4th June, yes.
Cell number 27, Meena V.
I'm for
Syed
the respondent number
Siddharth
1, my lord. I
Lord,
seek
this
for
is
a
a
day's
matter in-
accommodation, my lord. It
Yes,
may
ma'am.
kindly posted on Friday, my lord.
Can it be posted on Monday, my lord?
Monday, yes, sir, the request.
Tuesday, kindly, my lord.
Respondent.
Tuesday.
Yes, madam, Tuesday.
One.
Yes, yes.
Yes, ma'am.
Tuesday, yes.
Obliged, ma'am.
Request of the respondent, please this matter on Tuesday.
Respondent number 1, my lord.
Yes, one.
Cell number 28, Chidananda KD Laya.
Yes.
As against rejection of the application for injunction, my lordship.
Suit for?
Suit for injunction.
Hmm.
As against a trespass into the property of the plaintiff.
Hmm.
My
You
lordship kindly.
you are the plaintiff or a defendant?
I am the plaintiff, my lordship.
You filed in a suit
Yes.
for injunction?
Suit for injunction as against putting up the construction in my property.
Hmm.
That was rejected, as against which I preferred MA.
Hmm.
That is also rejected.
Where is
Now,
that order of trial?
impugned order, my lordship, of MA.
Why it is rejected?
There is no reason court says that the matter to be adjudicated in the course of trial.
Establish the prima facie
So some
case.
property of the property which was allotted to me has been sold.
No, what is that apprehension?
Apprehension, my lordship, my lordship can refer to Annexure C.
Hmm.
It's a deed of partition, my lordship, page number 44.
Hmm.
Wherein 2.5 cents of land, my lordship, allotted to Keshava,
Hmm.
party number 2.
Hmm.
And to the party number 3, last 3 lines, my lordship, in the first page.
Page
Solochani was allotted with 2.5 cents.
45.
2.5.
Page number?
Page number 44.
44.
Deed of
Yes.
partition. All the parties claim right under the same partition deed.
Hmm.
Now 2.5 allotted to the 2 of the parties, and I was in party number 9. Last line, my lordship.
Hmm.
Varija, Ummattu. Now, my lordship kindly refer to page number 52, my lordship.
ಆಯ್ತು ನೀವು ಇದ್ರ ಮೇಲ್ಗಡೆ ಹಾಕಿದ್ರಿ.
ಹೌದು sir.
Then who is that defendant?
He is the purchaser from Keshav and Solachini. Now, my lordship kindly refer to
What
page
is
number
your case?
58.
He is encroaching your property.
Yes, my lordship.
Now that
My
what
lordship
is the-
kindly refer to page 58.
what is the
Sketch.
injunction you have sought?
Injunction not to trespass into my property and putting up the constructions. Page 58, my lordship.
Is he putting up any construction?
Yes, as per his own sketch, if the my lordship is to compare the sketches,
Hmm.
it's a clear case of encroachment to my property.
Where is that?
My lordship referred to page 58.
No, he is already put up a construction.
Partially can put up you, my lordship. At an undisputed point of time when he has laid foundation or approached the court.
But
Courts
now
did
he
not
has
grant.
already, yes, any construction will be subject to the result of the writ petition.
Conditional status quo as on the date of the
No,
pending.
that we can't stop that construction. It is already.
It is purely, if the court is to peruse my sketch, my lordship, totally it is my property.
No, both the
100% they have putting up the construction my
concurrently
property.
held against you.
Yes.
Now that we can't, if he succeed, then he has to give up that.
Only structure is ready, rest of the
Yes.
area is
now
not complete.
Issue notice. Any construction made on suit scheduled property is subject to the result of this writ petition. Yes.
I take notice to the council appearing for the trial court.
In addition, permitted to serve a copy on the council appearing for the respondent before the trial court. That's all.
Cell number 29, BK Manjunath.
Yes.
Just a partition deed, an extent of 1 acre 32 meters was allotted to the petitioner. My lord, annexure A is the partition deed, my lord. Then as per annexure B, my lord, RTC showed my name. And I have been in possession and enjoyment of it. Then my lord, the respondent tried to interfere. I filed an application suit for my lord injunction and declaration. The trial court, my lord, granted permanent injunction restraining the respondent from interfering. Against that, my lord, he filed miscellaneous appeal. Miscellaneous appeal was also, my lord, dismissed. My lord, now in spite of all these things, my lord, I am a 70 years old. He is trying to interfere with my possession. Then, my lord, I filed an application for police protection. The learned judge rejects, my lord, application on the ground for agricultural land. Police protection cannot be given. There is no such law, my lord. Kindly take the impugned order, my lord. Page 181, page 81, my lord. The relevant portion. Your Lordship may kindly come to the relevant portion of the impugned order in page 87, my lord. In page 87, para 8, bottom, your left side. Admittedly, the suitable properties on agricultural land and the defendants taken defense that the plaintiff has executed an agreement of sale in the year 2019 by handing
You
over the
take notice.
Yes.
Yes.
Interim order, my lord, because I am
interim order? Interim
police
order
protection, police protection.
Then main prayer. ನಾನೇ police protection ಕೊಟ್ರೆ ಏನು ಉಳಿತು ಮತ್ತೆ ಅವರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದು. Yes. Issue emergent notice.
Number 30 adjourn, seal number 31 Prakasha M for petitioner VP Shivakumar.
Yes.
Copies.
Yes. You serve a copy. Yes. When do you want, Mister?
Yes.
Any date, no, which my lord, and if he gives the copy tomorrow also.
No, when is the suit?
Next week, my lord. Suit for partition, separate partition, and suit is decreed.
ಯಾವತ್ತಿದೆ date trial court ಅಲ್ಲಿ?
ನಾಳೆನೇ ಇದೆ.
Friday. Yes.
Monday.
Monday. Yes. Give the copy.
Seal number 32 Rajaditya Sadashivan.
Yes, Mister.
IA is filed, I am the defendant before GNWC court. IA is filed challenging the jurisdiction of the court for return of the claim. Instead of deciding on the jurisdiction, the court has posted for inquiry. Now, the facts of the case are both myself.
You have filed who has filed this?
I have, the respondent has filed the petition for GNWC for being appointed as guardian of the child. Admitted facts are both petitioner and respondent are permanent residents of USA. Child is born in USA and is a natural citizen of USA. The courts in India do not have jurisdiction. Admitted facts are that the child has never come to India. Throughout for 4 years it was brought up in USA. School, everything is in USA. It was kidnapped and brought to India by the respondent without informing the petitioner. Within 7 days of coming into India, GNWC case is filed. Now, under Section 9 of GNWC Act, the child should be an ordinary resident of the territorial jurisdiction.
Of the court.
Of the court.
When that application is filed.
When the application is filed. When the application is filed, it was residing only for 9 days. It is not an ordinary resident. It came, the child was in Bangalore only for a period of 9 days before.
What is that order passed by the trial court?
The order passed by trial court is that we have heard we need to have an inquiry. Now, problem with one, there is no need for an inquiry. All the documents are admitted. All the facts which are just now
stated. What is
stated.
that order you are challenging now?
The order that I'm challenging is that the court does not pass any order. Kindly see Annexure A, page number 21. Interim order IA number 3. The petitioner has filed objection. I've heard both sides. Under the facts and circumstances of the case, at this juncture, it is difficult to opine about ordinary residents of the ward. Hence, inquiry is required. Therefore, no order is passed. Inquiry for IA. Problem because all the facts which I have just now narrated are categorically admitted by the respondent in the statement of objections. We being permanent residents of USA is not at all in dispute.
24/4/2026 ಯಾವತ್ತು? I will
24 ನಾಳಿದ್ದಿದೆ.
Dispose of that application by end of June. Will that direction can be given. We can't say that trial court not to hear that matter on IA and directly pass an order on merits.
Then the direction may be granted for very quick disposal for whatever inquiry contemplated by the trial court.
Yes.
And one request, my lord. Internally, we had also filed I had filed a habeas corpus petition on the ground that the GNWC court does not have any jurisdiction. It is only the High Court under habeas corpus. The habeas corpus was disposed of on the ground that since the matter is seized by the GNWC court, we will wait for the orders on the jurisdiction. The habeas corpus court also made an observation that because the petition, that is myself, I am being granted video access to speak to the child.
You have filed an habeas corpus that child is illegal detention by that your wife or the court?
No, by the wife.
Then why that waiting that court directions?
The habeas corpus court, this honorable court has held that because the matter is seized because the GNWC case was already filed, the custody of the child is a matter before.
Your case is that custody of the child is illegal.
Custody of the child is also illegal. Removal of the child from USA to India is also illegal. That is the ground on which
the case is not in a material.
The observation made in
the custody of the mother is not an illegal custody. It may be brought That is different, but now that it is not illegal custody of mother.
Yes. Now, whether custody, my only, the reason why I mentioned habeas, the reason why I mentioned habeas corpus is that there's an observation made by habeas corpus on an undertaking given by the respondent.
ಈ application decide ಮಾಡಿದ್ರೆ ಎರಡು ತೀರ್ಮಾನ ಆದಂಗ ಆಯ್ತಲ್ಲ ಅಲ್ಲಿ.
ಹೌದು. One request, my lord. They had made an undertaking that video conference facility will be given to the petitioner to speak to the child. I am in USA, the child is in India. Video conference, they are speaking in the Haley, that observation was made. Now, once the habeas corpus petition was disposed of, they have denied me access. My only request is that let the respondent be given direction to give me access.
Application before the court, what is not there, I am not under 226 to do all these things. Yes, in this writ petition, petitioner called, petitioner sought following relief, prior extractment. Respondent herein as filed GNWC petition for custody of, what is the name of the child?
Shrija Venkatraman.
Custody of the child named Shrija Venkatraman. On service of summons, petitioner herein as appear through counsel as filed IA under Order 7 Rule 10 read with section 151 of CPC, praying to return the petition to the petitioner as that GNWC court has no jurisdiction. Since no order has been passed on that application, petitioner is before this court. In view of the above, without expressing any opinion on the merit of the case, the GNWC court is directed to dispose of that IA number 3 filed by that petitioner herein in accordance with law as expeditiously as possible, not later than by end of June 2026. Yes. All the contentions of the parties left open. All pending applications are disposed of.
Serial number 33, A. Madhusudan Rao.
Suit is filed for partition and separate possession. Respondents 1 to 7 are the members, joined members of the family, my lord. And what has happened is, the trial court, after considering the materials on record, grant an order of injunction in favor of the plaintiff. My lord, despite the order of injunction being there, respondents, my lord, alienated the properties in favor of third parties. They wanted to come on, we brought them on record, they were brought on record.
Yes.
Now, this order passed with the trial court was challenged before the first appellate court. First appellate court, while referring to the principles laid down with Honorable High Court and Supreme Court to the effect that the appellate court should not normally substitute its opinion and all that, still reversed the order on only one ground, on two grounds. One ground is that earlier a suit was filed by me. That suit was dismissed, was withdrawn by me with liberty to file a fresh suit on the same cause of action. And I have filed the present suit. The trial, the first appellate court refers to the pleadings in the earlier suit. Says I am not entitled for the relief. My submission is whether in what context those pleadings
So
were
what
made.
is that injunction granted by the trial court?
Not to alienate the properties. Despite that, there was an injunction order.
Issue notice. Parties are directed not to alienate the suit scheduled property till next date of hearing.
Much obliged.
Number 34, Egde Sumana Mahadev.
For petitioner, please.
Yes.
The petitioner is a defendant. The connected matters, both his lordship, one is suit for declaration and one is suit for partition. The respondent number 3 and 4 filed the application order 1 Rule 10 sub class 2 to implead as a party. The original, so one suit is in 2009, please, Your Honor. My suit is 2006. Suit for partition and separate position OS 396/2009. And one suit filed by me is to 291/2016. The earlier it was 2006 matter renumbered as transferred to senior division. It was renumbered as 2000.
Suit enake.
None suit for declaration.
Your suit for declaration.
Yes, and my property is only one property. The respondent number 3 and 4 filed the application 1 Rule 10 to implead them, they are interested in the suit to contest this case.
Who has filed that application?
The respondent number 3 and 4.
In which suit?
396/2009.
That partition suit ಅಲ್ಲಿ ನಿಮ್ಮ
ಅವ್ರು ಇಂಪ್ಲೀಡ್ ಆಗ್ತಾರೆ. ಎರಡು ಕ್ಲಬ್ ಆಗಿದೆ ಸ್ವಾಮಿ. Both the matter was clubbed together and common evidence was recorded.
No, that respondent herein has filed an application for impleading.
Please, Lordship.
What is their interest?
Their interest, the property survey number 60/1 and 71/3, they got a right. My humble submission, they themselves has filed the suit against me, please, Lordship, OS 859/2022.
Their application is allowed.
Allowed.
Where is that order?
The order is in page number 77, please, Your Honor. Order portion is 82. 81, I maybe, please, Your Honor, para 11.
Read.
The carefully reason assigned by in the affidavit annexed IA 13, the application have taken a contention that the suit schedule property, suit properties have a bearing number 57/2, 60/1, 60/2, 71/3 have already been partitioned among the Vanna Gangamma and Ganga Ramaya, who is the different number 2 herein, and accordingly the land measuring 1 acre 32 guntas, 57/2 land measuring 2 acres 38 guntas, survey number 60/1 31 guntas, and 71/3 1 acre 13 guntas, 60/2 were allotted to Vanna Gangamma, who is the mother of the applicants, and accordingly revenue records were admitted in their name in respect of the case. In support of the said contention, they have furnished the copy of the revenue records. In that regard, please, Lordship, they themselves has filed the OS 559/2022.
Further in the present.
Further, please, Lordship, on the property mentioned in OS 296/2009, subject matter of the OS suit 859/2022. 859 filed by them, suit for declaration against me, declaring that they are the absolute owner of the suit schedule properties.
ಆ suit club ಆಗಿಲ್ಲ.
ಅದು ಕ್ಲಬ್ ಆಗಿಲ್ಲ.
ಅದಕ್ಕೆ ಅವರು ಇಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ they have filed the application order 39 rule 1 and 2 against me. That was dismissed. They have filed the MFA before this honorable court, please, Your Honor. MFA also dismissed. After dismissal of the said suit, Your Honor, they have filed the application before this court.
ಆಯ್ತು, ಅವ್ರು ಇಂಪ್ಲೀಡ್ ಆದ್ರೆ ನಿಮಗೆ what is the problem?
ಅಲ್ಲ, they are already partitioned and they have already allotted this share. They have no right at all. They themselves have pleaded in their own suit.
Issue notice. Yeah, further proceedings in OS number
396/2009.
291 of 2016 and OS number 396 of 2009. Pending in the file of senior civil judge Nelamangala till next date of hearing.
Grateful.
Cell number 35, Subbareddy Kane for petitioner.
Yes.
Petitioner, my lords, but senior is on his legs just for a passover.
For the respondent.
Seek for a passover.
Passover or day after tomorrow?
Day after tomorrow.
Day after tomorrow.
Tomorrow, my lords.
Day after tomorrow. Yes.
But in the fresh matters list only, my lords.
ಅದೇ ಬರುತ್ತೆ, ಏನು ಚೇಂಜ್ ಆಗುತ್ತೆ. Yes.
Grateful.
Cell number 36, PM Siddamalappa.
Yes.
Petitioner, please, Lordship. In this case, please, Lordship, the petitioner has filed the application order 7 rule 11, the rejection of plaint. The trial court passed the order. I request in page number 52, please, Lordship. Suit for declaration and position. The page, that application will be considered on along with merit. That order was passed. Suit for declaration and position. I filed the application order 7 rule 11, please, Lordship. Rejection of plaint. The trial court has taken into consideration the IA number 5 is kept open and same will be considered along with merit.
ಎಲ್ಲಿದೆ order?
In page number 52, please, Lordship. The only small speaking order was passed. The detailed order was not passed and the application is not considered. The matter is shut down for plaintiff evidence.
ಆಯ್ತು, what is that ground you are raised in that order 7 rule 11?
I have purchased the suit schedule property in 1982, please, Lordship. And I am in the possession of the property. He purchased the property in 2005. He has challenged my sale deed. I request plaint page, please, Lordship.
On what ground you are seeking for rejection of the plaint?
The suit itself is not maintainable. They are claiming the right over the property with converted land. Mine is the agriculture land and he has not paid the sufficient court fee and there is no cause of action against me. In that regard, I filed, please lordship, the trial court has not considered my application. It is only a pass order, it will be kept open and
Read that.
second para in in page number 52, please lordship.
Yes.
Perusal on the record, the case was set down for further chief of PW1. Moreover, the relevant with respect to the court fee already framed. Hence, the IFIE is kept open. The same will be considered along with the merit. The parties are directed to lead their evidence. That is the order. If I have the application is not considered and along with merit, my right will be approved, please lordship.
Heard. Issue notice, stay of further proceedings in OS number 357 of 2019. Pending in the file of second additional senior civil judge Devanalli, till next date of hearing.
Cell number 37.
Third additional, please.
Third additional. Yes.
Subramanya Kaushik.
Grateful.
Prepare for the petition. Defendant's writ petition.
Yes.
What is under challenge is allowing of the amendment of plaint. I oppose the amendment of plaint on the ground of limitation. Suit is for specific performance. 9 properties are there in the suit as originally instituted.
Yes.
3 properties they did not seek specific performance. 3 properties were left. In respect of those 3 properties, after a period of 9 years after the institution of the suit, nearly 11 years after the agreement for sale, the suit for the amendment is sought to be made. That amendment is allowed. May I request your lordship kindly to take note of a few dates, my lord.
No, where is that order?
The order commences at page 18.
18.
18. Reasoning, my lord, commences at 26 effectively from para 15.
26.
26, my lord.
Yes.
Para 15.
Yes.
In the present case, the amendment does not introduce any new property alien to the agreement of sale dated so and so. The plain schedule C properties form larger schedule A property covered under the same agreement. Pendency of litigations in respect of survey numbers 36, 37 and 38 were already pleaded in the original plaint and an injunction was sought in respect thereof. Therefore, the foundation for the present relief already exists in the original pleadings. The proposed amendment is based on subsequent events, namely disposal of writ petition number so and so and OS number so and so. Incorporating such subsequent developments which have a direct bearing on the entitlement of the plaintiffs to seek specific performance of those items cannot be said to fundamentally alter the nature of the suit. The suit continues to be one for specific performance. At best, there is an enlargement of the relief. Para 17. As regards limitation, the question whether the claim in respect of items 1 and 3 of plain schedule is barred by limitation involves a mixed question of fact and law, including the date of refusal and readiness and willingness. The plea of limitation raised by the defendants is a substantial defense which can be adjudicated at the time of trial. Merely because such a plea is available, the amendment cannot be rejected at the threshold, particularly when foundational facts are already on record. The question of limitation is kept open. 18, I did not urge, another defendant urged. Para 19, I may be permitted to read. With regard to prejudice, no irreparable prejudice is demonstrated. Any inconvenience caused to the defendants can be compensated by granting liberty to file additional pleadings and additional issues. No accrued right is taken away merely by allowing the amendment. Rather, the rights of the parties will be adjudicated comprehensively in same proceedings, thereby avoiding multiplicity. The substance is mixed question of fact and law. On that time, my lord. On the face of it, it is barred by time. I may be permitted to demonstrate in 2 minutes. Kindly take the agreement for sale. It is at page 62. The agreement is dated 4/3/2015.
Yes.
Admittedly, there is a sale deed in my favor. I am subsequent purchaser. That sale deed is 8/6/2016.
Yes.
I'm sorry, 8/6/2016. Even prior to that, the agreement was terminated on 13/5/2016. Plaintiff himself pleads it in the plaint at page 48.
Yes.
And the suit is filed on 16/7/2016. Now, what the plaintiff says is there were certain litigations pending. That litigation, according to the plaintiff, got disposed of at page 128. That is on 17/12/2016.
Yes.
Page 128. 17/12/2016, some suit was pending in respect of that property that is dismissed for non-prosecution.
Yes.
Another property, the plaintiff says there was a writ petition pending. At page 124, that writ petition is disposed of.
Yes.
That is on 6th April 2017.
Yes.
These are documents produced by the plaintiff himself.
Yes.
If, as on April 2017 itself, the right to sue accrued, this application is filed on 24/10/2025.
Yes. Heard. Issue notice. Stay of further proceedings in OS number 396 of 2016, pending in the file of second additional senior civil judge, JMFC, Nelamangala.
My lord, I'm seeking dispensation as against 6 to 8. I'm filing a memo to that effect.
Cell number 38, Sudesh Kumar Acharya.
Yes.
The writ petition is by the decree holder. He has obtained a decree, my lord, against the respondent herein. My lord, he has put the execution petition, my lord, for recovery of the money. My lord, kindly see the execution petition dated at annexure E, my lord. Page 68, my lord.
Yes.
Well, kindly note down the date, my lord,
Yes.
which was filed on, my lord, 21/2/2023.
Yes.
My lord, along with the application, my lord, I filed an application for raising the attachment of the immovable property of the judgment debtor. Well, that is at annexure B, my lord, under section 60.
Yes.
But for the recovery of 22,65,000, for which, my lord, purpose was sought for the raising of the attachment against scheduled property as per annexure B.
Yes.
Well, as on the date of filing the execution petition, there was a saleable interest in respect to this property was there.
Yes.
Now here also, your lordship may kindly notice the date 18/12/2023. Next page.
Yes.
Well, soon after this application is moved, my lord,
Yes.
the judgment debtor, my lord, as per annexure H, my lord, page 87.
Yes.
87, my lord.
Yes.
Well, she executed the gift deed in favor of her husband cleverly.
Yes.
21. Now, my lord, in the raising of the attachment application order, though I convinced the judge that, this is an afterthought, my lord, so only after the application is within a span of 3 days, my lord, she executes the deed
Yes.
in favor of husband. Now, in the impugned order passed at annexure A,
Yes.
passed by the execution court, my lord, without assigning any reason, my lord, only paragraph number, my lord, last paragraph.
Page.
Kindly see, my lord, page 22, my lord. That is paragraph number 16. On perusal of the material on record, it is evident that as on the date of the filing of the executive petition, the scheduled property does not stand in the name of the judgment debtor. Absolutely wrong, my lord, without looking into the document.
Issue notice. Parties are directed to maintain status quo in respect of petition scheduled property till next date of hearing.
Grateful.
Cell number 39, Angad Kamath for petitioner.
To the petitioner, my lord.
And for the
Defendant's
respondent number
petition.
1, my lord.
Yes.
I have filed objections today, my lord.
I have
in
no
the
difficulty. I am ready to argue.
Yes.
Lord, defendant's petition, Lord.
Yes.
Suit initially filed for bare injunction,
Yes.
later converted to a comprehensive title suit.
Yes.
Lord, that was filed in 2004. Now we are in 24.
Yes.
Lord, I took out 3 applications, 35 to 38, for recall, reopening, and for production of a certain document.
Yes.
The document that I wanted to produce, Lord, the lordship's perusal.
So what is that order passed by the trial court?
That application for production of that document has been rejected as not being relevant.
Yes.
Now, the only thing I'll have to satisfy lordship is the document which I'm seeking to produce and mark is a relevant document. That's all. But your lordship will see in the memo, Lord, that I've just passed on. Document number 4, which begins at page 28. In the index note, if your lordship will only see the index.
Yes.
Document 4 and 5.
Yes.
Judgment in OS 9897 of 2006 and decree in OS 9897 of 2006.
What is that?
Yes. Lord. Now, these are the 2 documents that I sought to produce.
Yes.
Now, Lord, this is a 2004 suit which the plaintiff had filed.
Yes.
Plaintiff initially filed a suit for bare injunction, Lord. Your lordship will find that at page 7, Lord, of the plaint. Just please see page 7 of that same document memo which I passed on.
Yes.
Please see the schedule, Lord.
Yes.
Your lordship are at the schedule, Lord.
Yes.
All that piece and parcel of the property bearing site number 52 formed in Omkar Nagar layout out of survey number 3/3B situated at Ganakal village, South Taluk. This is the suit schedule, Lord. Now, Lord, in 2006, I file a comprehensive suit in which I claim title to this very 3/3B, the entire survey number.
Yes.
This is only 7 guntas in that survey number. I asked for comprehensive title of the entire 3/3B.
This plaintiff is the party in that.
Plaintiff is defendant number 2 in that 2006 suit.
Yes.
Now that suit in which he participated as a defendant, contested that suit in 2025 September is now decreed and there's a comprehensive title declaration in my favor.
Yes.
I now want to produce that and part. She claims title to this in the 2004 suit. She later amended that suit. I just want to show your lordship the amended suit.
That judgment and decree passed in favor is not challenged. It is.
There is an RFA pending. It was filed in August. Decree came in.
My lord.
Decree,
Two
RFA is
Now
pending.
that, let it be.
Yes.
What is the difficulties if it is produced?
That's
the
all I'm
documents?
saying.
My lord, let the court see the amended plaint.
Yeah,
my
I'm
lord.
going to come to the amended plaint.
Plaint which is produced along with the memo is the earlier plaint, my lord.
I'm coming to that.
Currently, the plaint has been amended and the schedule has been amended, my lord. It is produced at annexure.
I have
B,
produced
my
it in
lord.
my petition itself.
Annexure B, my lord.
Your lordship will
Kindly
come.
see
Just
page
1 minute, madam. I'm
number-
not done.
What is
Just 1
the
minute.
difficulties if it is produced that?
My lord, the
Judgment and-
subject matter in that suit.
What is
and
the stage in the suit now?
Final arguments, my lord. My lord, I may be permitted to file this memo, my lord. Here, in this memo, this court and the trial court, both the courts have held that the subject matter in 8729 and 9897 both are different, my lord.
Yes, you complete that.
Yes.
Yes.
Your lordship will now come to my main petition, lord.
Yes.
Memo was only to show your lordship what I asked for, what I wanted to mark.
Yes.
Yes, lord. Now if your lordship come to the main petition, the amended plaint, lord. Now your lordship will come to page 41 of the main petition.
Yes.
But your lordship will see the schedule. They claim title. Your lordship will see the prayer first at page 41.
Yes.
By granting permanent injunction is prayer A. Prayer A.1 is declare the plaintiff as the absolute owner in lawful possession, so and so. Now they change only the survey number. Please see the suit schedule below.
That boundary is same.
Boundary is same. Measurement same.
Boundary is prevails over that survey number, madam.
Exactly, my lord. That is the same stand
Now,
taken by us.
what is that boundary in your suit?
That is different, my lord. 3 by
I'll show
3.
your lordship.
It's whether this part of the land is included or not.
In my 2006 suit, what your lordship will find in the judgment and decree, lord. I'll just show your lordship what the suit schedule is. Since that is for 1 acre, the entire survey number, no, it's not just a particular site. They are claiming a site in that survey number.
No,
Mine
is
in
it
respect of
that in that boundary it is include this boundary also?
No, my lord.
According to them, that is what has happened.
No, my
The
lord.
only question is, I'm only saying this document has been marked because they are claiming title to this property on the basis of a sale deed concerning 3/3B.
No, you want only a marker.
Only mark, only mark.
My lord, I just want to.
It will be subject to appreciation of evidence, whether it's relevant or not relevant. That's
No,
what I'm
see, when is that next date?
24th, tomorrow for final
My
argument.
lord,
Let him mark it and proceed further.
On the same
my
day,
lord, I just want to draw your attention to the memo which I have given, my lord. At page number 23, my lord. This honorable court has only held that there is a tabular column filed by the petitioners, my lord, in that suit, wherein they have clearly compared the difference between both the suits, my lord. At page 26, my lord, what emerges from analytical excavation is that the two suits are found upon different topographies, figuratively and literally, my lord. My lord, this judgment is not necessary for adjudication of the present suit, my lord, and moreover that is being challenged in RFA, my lord, and it is pending, my lord. There are two different RFAs filed, my lord. One is by us and the other one is by the defendant number 1, my lord.
Now, only thing is, court has to see whether suit scheduled properties is a part of that earlier degree or not. That's all. If it is not, it will
My
be
lord.
rejected. What is the difficulty if it is?
And
My lord, they can produce the same along with the memo of citations
Yes, then
also,
we'll
my lord.
hear that matter. Yes. You take notice, you are taking notice to whom?
Respondent number 1, my lord. My lord, I had
What dispensation
filed
so far?
Others.
Dispensation so far.
Yes, you are the only, you are the plaintiff.
Yes, my lord, I am the
Number
plaintiff.
9.
Yes.
The judge is also transferred, my lord. Even if the matter is stayed and this was heard before the concurrent court hall, my lord. Now to the actual court, the judge is newly appointed, my lord. Post that only arguments will be commenced, my lord.
Yes, we'll see that. We'll fix the date after vacation. We'll hear that and yes. So and so is undertake to appear for. Cavator is undertake to appear for respondent number 1. Counsel for the petitioner has filed a memo seeking dispensation of notice to respondent number 2 to 12. Yes. Leave this matter on 10th June. The trial court is directed to defer the matter beyond 10th June. We'll hear that. So great, yes. ಏನಿದೆ dispensation for a period of 2 weeks. Yes.
For 40 1 okay or for
Yes.
In CL number 41, I accept notice for respondent number 1, my lord.
Yes. Who is that? Yes.
SS Parikshit, my lord.
Yes, yes.
My lordship, this is a partition for, suit for partition. My colleague will.
Yes, 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 yes.
My lord, this is suit for partition and declaration, wherein the petitioner is seeking for equal partition from her father's property and declaration that she is an absolute owner of Schedule C property.
What is that order
Her
you are
bequeath
selling?
in will dated, the order dated 29/1/2026, my lord.
Where
The
is
lordship may kindly see page 44.
Oh.
The facts of the case is this, my lord.
No, you just see that what is that order you are selling?
Instant application as filed by the counsel for plaintiff under section 151 of CPC requesting the court to put initials to exhibit 20 to 62 in interest of justice. Following page, in page 45.
My lordship, what has happened in 2016 while marking the exhibits, my lordship, the signature was left out.
Yes, I understood that. Yeah,
Yes,
let us see. If there is any difficulties, I will ask you. Don't take extra time. Yes. Yes.
Instated
You
in
read that, yes.
Instated in affidavit filed by applicant in support of application that on 30/8/2016, these exhibits P1 to 63 marked in evidence of PW1. Inadvertently, signatures or initials on document not put. The plaintiff applied for certified copies and certified copies of exhibit 20 to 63 not provided, as those exhibits were not signed. It is worth to note here that as stated by plaintiff, these exhibits 20 to 63 marked on 30/8/2016, there is no explanation or office note to say why these documents are not signed and why concerned bench clerk at relevant point of time not obtained signatures on exhibits. Only after these explanation and office note by concerned official or concerned bench clerk, initials or signatures on exhibits to be considered.
I thought explanation ಕೇಳಿದ್ದಾರೆ. Nothing has been done.
My lordship, now the stage is for the final arguments, my lordship.
No, without verifying that they went for a final argument.
Please, my lordship.
We have obtained.
We thought, we have applied for certified copy. That has been rejected. Application has been rejected.
Court has some doubt.
We
Why
have
it has
obtained
not been signed. Therefore, it is sought for an explanation. But now it has been, if the argument is concluded, then there is no.
No, even for the
We
final
We have
arguments.
obtained certified copies
Please.
from exhibit 1 to 19.
Stay of further proceedings in OS number 25593 of 2018, pending in the file of 28th Additional City Civil and Session Judge Bangalore till next date of hearing. You are taking notice to whom, Mr.?
For respondent number 1, my lord, suit is of the year 2008, my lord. They're filing 1 hour on the other application and they're dragging on the case.
Court is not rejected that. Court said we will verify from that
Please, my lord.
bench, but proceeded to hear that argument and if disposed of.
No,
then
my lord, on
they
their
cannot say
submission only the cross examination has been closed, my lord. It is available in the. Please, my lord.
Close when that court itself said that marked documents has been marked, if it has not been signed, it is the fault of the bench clerk or the court. It is not the party. Court has to examine if it is
Please,
true or
ma'am.
not. Court has accepted that.
Please, my lord.
Before conclusion, they have posted for an argument. Yes, let us see. Yes.
A date may kindly be fixed, my lord. The other is.
So is undertake to appear for respondent number 1. Issue emergent notice to respondent number 2. Yes, leave this matter immediately after service of notice.
Date may kindly be fixed, my lord, in the month of
Yes.
June.
16th June, yes.
Much obliged.
Cell number 42, yes, sir, Sri Prasad.
Forfeiture of right to file return statement beyond 120 days. Page number 12 is the impugned order.
Page number 12.
No reasonings assigned, Lord.
Already ಯಾವತ್ತು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಇದು 18/4/2026 ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿರೋದು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ ಎಲ್ಲ ಕೋರ್ಟಿಗೂ. Why again they are passing that 120 days?
And it was, the stage was for filing written statement only. On that particular day, the learned presiding officer was on
of
leave.
that Karnataka amendment.
Please, Lord.
Court has no power to grant after 120 days, but that validity has been.
Correct, stayed. WP 8884 of 26.
We have directed to communicate this to all civil judges instead of.
Despite that, this order is passed.
This is unnecessary litigations. The suit will be stayed
Please.
Yes, heard. Issue notice. Stay of further proceedings in OS number 360 of 2025. Pending on the file of Principal Civil Judge JMFC, Chenigiri, till next date of hearing.
Grateful.
Bill number 43, Sridhar Chakravarti.
petitioner,
petitioner. Yes.
The suit for dissolution was filed by respondents which came to be decreed. The same was challenged by this honorable, before this honorable court, and a stay was granted not to draw up the final decree proceedings. In final decree proceedings, they have filed an application for bifurcation of the scheduled property through a commissioner. My lord, our main contention before RFA was the original suit itself is nullity in the eyes of law, and they had no locus standi to file an application under section 44 of the Partnership Act. The suit itself is nullity because they were third parties. They had no right at all. My lord, nothing has been considered by the trial court, my lord. Just a plain order has been passed that only there is no stay in respect of appointment of commissioner. How can appointment of commissioner be granted?
No, normally in RFA, we are granting a stay not to draw final degree. Till then they can proceed. Appointment of commissioner
my
and
lord,
all.
you can proceed if the judgment is valid. But I will demonstrate how it is nullity in the eyes of law. My lord, the dispute is pertaining to an arbitration that is not in dispute. My lord, the arbitrator.
We are protecting the interest of all the parties. Let them not to draw the final proceedings. Till then they can proceed. Suppose if you fails, they can pass in a final degree. It is not that you are going to succeed. Is it not?
Correct.
Therefore, such an order is passed. Suppose if it succeed, then the FDP will go. What is that fault in appointing the commissioner? Why you
So, my
want?
lord, the judgment is nullity. ನಾನು ಅದನ್ನ demonstrate ಮಾಡ್ತೀನಿ. Give me 2 minutes time, my lord.
ಆಯ್ತ್ರಿ ಅದನ್ನ RFL ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ತಾನೆ?
Yes.
RFL ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ತಾನೆ?
Yes.
ನಾನೇ ಡಿಸೈಡ್ ಮಾಡ್ಬಿಡ್ಲಾ ಇಲ್ಲಿ?
ಅಲ್ಲ ಇದರಲ್ಲಿ
RFA after hearing that court said that go ahead with that execution proceedings, not draw that final degree proceedings.
My lord, I filed an application for amendment of pleadings where I raised 2 points. One, nullity, and they had no locus standi. After appreciating my point of law,
yes,
based on the judgments placed on record, it was pleased to order till further orders. My lord, the judgment itself is nullity. I will just prove in 2 minutes.
No, are you challenging the judgment before me in the RFA?
No, I am not challenging
Then
that.
how can I see whether
Pursuant to that, my lord, pursuant to that,
pending before that other court, can I examine that, Mr.?
That the commissioner itself is not permissible, my lord.
Yes, yes.
Kindly, for a moment, kindly turn to page. The order passed, my lord, the claim petition before the arbitration tribunal is dismissed in toto. They had gone. They had sought for inculcating them as partners and reconstitution of the partition deed, which was denied in toto. They are not at all a partners.
You go before that RFA court.
Yes.
And seeking a stay of that entire judgment and degree. Then FDP court cannot. RFA court has said that you go ahead with that. Now you are seeing.
RFA court has not to go ahead with that, my lord. It has stayed. For a moment, kindly see the order passed by this honorable court.
Where is that? Show me.
My lords, I'm producing the orders of the RFA.
Yes. He has not produced.
I have
Oh, my produced
Produced
lords.
it.
Where is that?
RFA.
Which one? I have stated in my memorandum that RFA they stayed.
No, my lords, it's in the end, my lords, it's stay of drawing of final decree.
Yes.
Yes.
That is all. Is
What I submitted. Staying up a final decree is still further orders. Now kindly see the observation.
Stay of
Drawing of final decree.
drawing of final degree means what? They can proceed with that final degree proceedings.
Yes, my lord.
Not to.
I
pass
filed an application regarding that the judgment itself is nullity in the eyes of law, which can be questioned at any point of time.
Yes.
Now, my lord, kindly see the observation of the trial court.
Yes.
It is so in a casual manner. Turn to page 25, my lord.
Yes.
My pleadings, my grounds have been urged in paragraph 6 and 7. Now, my lord, kindly turn to paragraph 13. The record revealed that the suit filed by the plaintiff, may you find it, my lord, page 25. The records reveal that the suit filed by the plaintiff's petitioner herein OS number so and so came to be decreed by this court by its order dated 10/3/2023, holding that the partnership firm by name Messrs. Aeroville has dissolved. Plaintiffs are entitled to 45% of share in the suit schedule property by meets and bounds, and also they are entitled to get exclusive possession over the same. Defendants number 2 and 3 are permanently restrained from alienating the suit schedule property unless it is divided by meets and bounds. Feeling aggrieved by the order passed in the said suit, respondents number 2 and 3 have challenged the same in appeal in RFA so and so on the file of the High Court. No doubt, 22/2/2024 Honorable High Court in RFA state the drawing up a final decree proceedings, still further orders. But however, now the stage is for appointment of commissioner for division of properties, which will not come in the way of drawing up the final decree. It means to say that there is no stay of appointment of commissioner for division of the property, which enables the court to arrive certain conclusion over the dispute parties to the petition. Lord, the arbitration matters, there is an embargo under CPC, under section 9 to adjudicate. Like my lord, under section 5 of the Arbitration Act, minimal judicial intervention is there. The suit, my lord, kindly see the observation of the arbitrator, my lord, at paragraph 30, page 32, paragraph 11.
Yes.
What was their claim?
Yes.
Page 32, paragraph 11.
Yes.
Claimant would refer to section 40 of the Arbitration Conciliation Act 96 in support of their statement. They say that they have a right in terms of clause 17 of the deed. With these averments, allegation, the claimant seek for the following prayer. This is the prayer. An award be passed directing the registration of the partnership deed produced as annexure F, or in the alternative, the honorable sole arbitrator may draft a partnership deed with respect to first respondent partnership firm reconstituted with claimants and respondent 2 and 3 as its partners, and registered the same before the jurisdiction sub-registrar in the interest of justice. They were not the partners at all. They came before the tribunal seeking for inculcating as the partners. The suit is filed by a third party. Kindly see the order of the trial court, my lord, at page.
No, I am not examining that. What is
No, my lord,
wrong
for
in
a
that?
moment, they had no locus standi only.
Yes.
They are third parties. For a moment, my lord. The suit was decreed based on a third party's claim. Kindly see what does section 44, my lord, at annexure G.
Counsel, I am not.
One ನಿಮಿಷ ನಾನು ಅದು 44 explain ಮಾಡ್ಬಿಡ್ತೀನಿ ಆಮೇಲೆ my lord may decide.
No, I don't want that.
So please, my lord, can a third party go and seek for a dissolution of firm?
No, that is under that RFA, Mr.
Correct, my lord. For a moment,
No,
they
Mr.
can also not dispute that.
When
They
you
are
have-
not partners.
No, when you have filed an RFA, I might have been having the roster, I have decided that granted an interim order. Now that is not my roster. Don't argue that. Now you argue that what is wrong in that order passed by the trial court on your execution petition.
None of my grounds urged on nullity
Yes.
and locus standi have not been considered.
Yes.
Kindly turn to page 108 at annexure G.
Yes.
108, my lord. I have extracted that the provision of law.
Yes.
It was amply clear in the order of the award of the arbitrator that they are not the partners. Just now I read out. Now kindly see section 44, what it says. Dissolution by court.
No, I am not on that. Yes.
At the suit of a partner anta shuru agutte. A suit can be filed only by a partner.
No, that whether you are, I am not hearing that appeal whether arbitration order is wrong or not. This is only an FDP proceedings.
Correct, my lord.
FDP proceedings.
The question of nullity, my lord, can be raised at any point of time.
No, that is pending before that RFA, Mr.
My lord, that is my ground in that application, which that has not been considered at all.
That's all.
My lord, for a moment, my lord, the Delhi High Court on this identical matter, my lord, has dismissed the suit itself, that there is an embargo.
That is, can that FDP proceedings can be dismissed when that decree has been passed? Only can be done it in that RFA.
I agree, my lord.
Yes.
But
Then
this
still you are
order,
arguing.
the order passed, my lord, is illegal.
Yes.
It does not have any weightage because it is direct intervention of section 5 of Arbitration Act and section 9 of CPC.
Yes.
As well as, my lord, they have diverted the arbitration proceedings completely from, after an award is passed, the only option left to them was to go to section 34 under before the commercial court. They have directly jumped into civil court, which has no jurisdiction at all.
Yes.
Then the judgment itself is nullity. Then how can the FDP proceedings can culminate, my lord?
Yes. In this writ petition.
My lords, in support of my arguments, I'd like to produce this citation, my lords, passed by the same bench, my lords.
What is that?
That my lords, that drawing up a final decree, that from an interim order, it is not in, may I turn to page from para number 5, my lords, the finding. From the above, it is not in dispute that interim order granted by this court in RSC so and so was drawing up a final decree only and therefore decree court would be justified in proceeding up to that stage. As such, appointment of court commissioner cannot be assailed on the ground that second appeal was pending. Hence, objection of the counsel for respondents would be justified.
Yes. In this writ petition, petitioner called in question order dated 17/3/2026 passed by nineteenth Additional City Civil and Session Judge in FDP 79 of 2023 on IA number 1 of 2024 filed by respondent herein. Respondent herein has filed a suit for
Dissolution of partnership firm.
dissolution of partnership firm. The suit came to be in OS number 4223 of 2018. The suit came to be decreed by judgment and decree dated 10/3/2023. Being agreed by the same, the petitioner herein has filed an RFA before this court in RFA number 113113 of 2023. This court, by order dated 22/2/2024, has admitted that appeal, granted an interim order, drawing up a final degree state till next date of hearing.
Till further orders later on.
Next.
Allah. Later on, it was heard after I filed this amendment application.
Yes.
It was heard in detail.
Yes,
Then
thereafter,
being convinced, it was posted for further orders.
thereafter, that interim order has been granted, extended until further orders. In the meantime, the respondent herein has filed an FDP proceedings in FDP number 79 of 2023 and also filed, which is that IA?
IA 1 of 24, my lords.
IA?
IA 1 of 2024.
IA 1 of
Annexure A, my lord.
2024 under order 26 rule 13, seeking appointment of the civil engineer as a court commissioner to make division of the suit scheduled property. Same came to be allowed, being agreed by the same. The petitioner is before this court. Learned counsel appearing for the petitioner has contended that the judgment and decree passed by the trial court in OS number 4223 of 2018 is itself is without jurisdiction. The respondent herein has no locus standi to file any suit when degree itself is in nullity and same is challenged before this court filing in an RFA. The FDP court has no jurisdiction to proceed in that final degree proceedings. Learned counsel appearing for Kevetar.
Yes, my lords. All the respondents.
Kevetar respondents contended that in that regular first appeal, the court has granted interim order, drawing a final degree is stayed. Therefore, the FDP court has proceeded to appoint a commissioner to ascertain the share, and no final degree has been drawn. She is also relied on judgment of this court in writ petition number 105631 of 2023, disposed of on 13th March 2024.
Copy could you?
Heard the learned counsel for the parties. It is not in dispute. The respondent herein has filed a suit in OS number 4223 of 2018, seeking dissolution of partnership firm. It is also not in dispute The trial court has decreed the suit by judgment and decree dated 10/3/2023. Thereafter, respondent herein has filed an FDP number 79 of 2023. In the meantime, being agreed by judgment and decree, the petitioner herein has filed a regular first appeal before this court in RFA number 1113 of 2023. This court, by order dated 22/2/2024, has admitted that appeal, drawing up a final degree stayed till next date of hearing. Learned counsel for the petitioner submitted that thereafter. What is the next date when confirm? You have the copy?
I have the copy, not produced it, my lord. I have
Submitted that subsequently, this court in RFA has extended that interim order until further orders. What is granted, what is that interim order granted in RFA is only drawing of final degree is stayed. And judgment and degree passed by the trial court is not stayed. And FDP proceedings dated FDP number 79 of 2023 is also not stayed. Therefore, the FDP court can appoint a commissioner, but he cannot drop the final degree. Till that stage, FDP proceedings can be continued. Even this court in similar circumstances in WP 105631 of 2023 has held para 5 extractment. In view of the above, there is no error or illegalities in the order passed by the FDP court. The writ petition is devoid of merit, accordingly dismissed.
Grateful, my lord.
44, K. Manjunath Gowda.
Yes.
Thank you, my lord. And the petitioner, yesterday after the hearing of this honorable court, my lord, see, in trial court lawyer has been argued the matter. Sir, no representation, defendant number 10 and 11. See, court is urgent, objections is not filed and posted for hearing on IA number 18 on 24/7/2026, my lord. See, my lord, my grievance is, my lord, after the interim order of this honorable court, my lord. See, court is given granted time only for 15 days for dispose the matter. See, after withdrawing application.
What is this matter?
Police protection, my lord. Yesterday, IA number 17, my lord. See, my lord, come to page number, my lord, 78, my lord.
Page number?
78, my lord.
78.
Annexure E, my lord.
No, you have filed in a suit.
A suit for declaration, my lord. In the suit, my lord, see, interim order has been granted. After that, this honorable court also is interim order has been granted, my lord. After that, my lord, my police protection application is pending. See, application IA number 17 is pending, my lord. This honorable trial court, my lord. See, you please withdraw the IA number 17. See, file a fresh application, IA number 18. See, and for 9/4/2026, my lord, I'll withdraw the IA number 17, my lord.
No order has been passed.
No order has been passed. Earlier, this court has been granted 15 days, my lord.
Petitioner seeking
Number 18, my lord, page number
direction
67
to the trial court to dispose of that IA number 18 as expeditiously as possible. Petitioner plaintiff has filed in a suit for
declaration.
Suit for declaration. Along with that, plaintiff he has also filed an application under order 39 rule 1 and 2. The trial court has granted a temporary injunction order. Since defendant has disobeyed that order, the plaintiff has filed an IA number 17 for police protection. No order has been passed on IA number 17. He has approached this court filing in a writ petition in WP number 5619 of 2026. This court by order dated 20th February 2026 has directed the trial court to dispose of that I number 17 in OS number 21 of 2022 as expeditiously as possible. ಎಷ್ಟು ದಿನ ಹೇಳಿದ್ರು?
My lord,
Within
ಅದರಲ್ಲಿ
period of 2 weeks
2 weeks.
from 24 to
After
2026.
further is, my lord, same matter has been listed. See, problem is, my lord, 20th is order passed, my lord. 24th copy is not released, my lord. Further, my lord, I'll notice to roster bench, my lord. This court has been extended on 7/4/2026, my lord. The date of 7/4/2026 in the 15 days ಅಂತ extend ಮಾಡಿದ್ರು, my lord.
Thereafter, on 7/4,
2026, my lord. In my memo. 82, page number 82, my lord. In my memo also is mentioned 7/4/2026, my lord. 82, my lord, page number 82.
Thereafter, this court has extended that period. ಯಾವತ್ತಿಂದ 7/4?
7/4/2026 ಇಂದ this matter is listed on 8/4/2026. On 8/4/2026 to 15 days.
So 26 or 25 ರೀ?
ಇಲ್ಲ sir, 26, my lord.
This order is passed under 24/2.
24/2, my lord.
ಯಾವತ್ ಮತ್ತೆ ಬಂದಿತ್ತು? ಮತ್ತೆ ಅವ್ರ ಬೆಂಚ್ ಅದೇ ಬೆಂಚ್ ಮೇಲೆ
ಅದೇ ಬೆಂಚ್ ಮುಂದೆನೆ ಬಂತು, my lord. Copy is not released.
Yes, thereafter, as this court has extended, ಯಾವತ್ತಿಂದ ಯಾವತ್ತಿಗೆ?
7/4/2026 ಇಂದ 15 days, my lord.
On 7/4/2026 has extended 2 more weeks from that day. Thereafter, the net counsel appearing for the petitioner has submitted that. Thereafter, on the instruction of the court, he has withdrawn that I number 17. On same relief, he has filed an I number 18. So far, no order has been passed on I number 18, hence he is before this court. Be that as it may, all the parties has appeared before the trial court, and this court in earlier occasion on similar application has already directed the trial court to dispose of the application filed by the plaintiff for police protection within 15 days. Now I number 18 is also filed on the same, seeking same relief. In spite of all the parties has appeared, the trial court has not passed any order. Now matter is posted on 27/4/2026. The trial court is directed to dispose of that application on or before 30th of April 2026. Yes.
Highly obliged, my lord.
Yes.
Cell number 45, KV Narasimhan.
ಅದೊಂದು ಕಳಿಸ್ಕೊಡಿ ಬೇಗ.
Lord, I appear for the petitioner. Lord, I'm challenging the impugned order at annexure G, my lord, and the quashing of the entire FDP proceedings.
Yes.
Lord, without a preliminary decree, my lord, the FDP court is proceeding to adjudicate, my lord, and demarcate right with respect to item number 5 property. My lord, initially, my lord, there was suit 1 to 5. There were 5 items of the suit properties. Lord, respondent number 1 to 3 filed a suit for partition against defendant 1 to 4, brothers and sisters against the brothers, before the trial court in OS number 248 of 2011, seeking for 3/7 share in the suit properties. Lord, the trial court by order dated 6/9/2014 granted 3/7 share to plaintiff number 1 to 3, that is 3 sisters.
Yes.
Lord, against which a first appeal, my lord, came to be filed by defendant number 2, one of the brother.
Yes.
In the meanwhile, my lord, the FDP court proceeded and demarcated item number 1 to 4, as there was only stay with respect to item number 5. So there was FDP decree also. So 2 RFAs came to be filed before this court. Not before this court, a compromise came to be entered between all the parties. My lords may take page 33 for a moment.
Yes.
Not point number 5 may be looked into.
Yes.
My lord, the appellant and respondents have agreed and concedes that the judgment and decree passed in OS 248 of 2011 dated 6/9/2014 may kindly set aside insofar as item number 5 of the suit schedule property, and the appellant and respondent number 4 to 6 are to work out their right in item number 5 and above properties by filing necessary application in original suit for amendment of plaint. Whether the item number 5 and above said 3 properties are the joint family properties or not has to be decided by the trial court in accordance with law by giving fair opportunity to the appellant and respondent number 4 to 6. For the same, respondent number 1 to 3 have no objection. So my lord, with respect to item number 5 and 3 other properties, there was an agreement, there was a compromise, my lord, to re-adjudicate the matter before the trial court between appellant and respondent number 4 to 6.
Yes.
My lord, appellant therein is the defendant number 2 before the trial court.
Yes.
And respondent number 4 to 6 are the LRs of defendant number 3 before the trial court. My lord, subsequently, one of the LRs of defendant number 3 files an application before the trial court, my lord, seeking to restore the matter on record to adjudicate with respect to item number 5 and other 3 properties. My lord. My lord, it is at annexure C, my lord. My lord's may come at page 50. Page 50, annexure C.
Yes.
An application came to be filed to restore the file back to the trial court.
Yes.
My lord, this application is allowed and the matter is restored and pending before the trial court.
Yes.
My lord, meanwhile, what is original defendant number 4 does, that is one of the brother, my lord, who has agreed that to give away the property in item number 5. He files an application in order 26 rule 9 before the FDP court asking for demarcation in item number 5 property.
Yes.
Lords may come to annexure E, my lord. Annexure F, page 86.
Yes.
Lord, this application is filed by defendant number 4 before the original court, YK Jairamu, seeking for appointment of court commissioner to demarcate item number 5 property on 20/2/2025.
Yes.
My lord, on the very same day at page 139, this application is allowed.
Yes.
My lord, meanwhile, my lord, I also file an application seeking to set aside this order. My lord, my grievance is, my lord, when item number 5, the very adjudication of whether item number 5 is self-acquired property or joint family property is pending before trial court. My lord, now FDP court, my lord, cannot appoint a court commissioner and further proceed with the matter, my lord.
Issue notice. Stay of order dated 28/2/2025.
Please, 20/2/2025 and the further proceedings.
No, 2025, what are you doing, mister? 1 year is over.
My lord, I filed an application to recall that order also. That is still pending.
When you have filed, you go and pursue that, then why
My
you
lord,
are challenging that?
My lord, the entire thing is not maintainable.
If that court will recall, then why you are before this court? You wait for that order. You can't do two remedies. They are recalling and approaching this court.
In fact, the very FDP proceedings is not, it could not have been initiated because of the compromise which the parties have entered.
Take notice, yes.
My lord, may I?
Yes, yes, it is 2025, mister. We'll see.
2025, my lord, but the entire FDP, there's no preliminary decree with respect to item number 5, my lord.
1 year you have not done anything, mister.
Lord,
Yes. You
in
take
fact,
notice, we'll
there
see.
are 2 applications, my lord. I have already filed, I have pursued before the FDP court. Because there's nothing is happening before that court, I am before this court.
Yes.
I have filed 2 applications,
Now-
IA number 9, my lord.
They are not proceeding with that matter. Then why do you want to stay?
My lord, IA number 9, my lord. My lord, court commissioner is appointed, my lord. He might come any moment. And also, my lord, there's another application filed seeking for.
Has not come from last 1 year. Now what is that urgency, mister?
Lord, there's no preliminary decree, my lord. I have filed an application seeking.
I will hear that.
My
We
lord.
are not rejecting that. Question of
My lord,
interim order
annexure,
that.
annexure K may be looked into, my lord.
Yes, heard. Issue notice. In addition, petitioner is also permitted to serve a counsel appearing for the respondent before the trial court. Leave this matter on 11th June. Yes.
Lord, may I request for stay of FDP. My lord, preliminary decree ne illa.
Sir, after 1 year, we can't, we don't know what has happened. We have kept quiet for 1 year now that, yes.
46,
Hand delivery, operative. Tomorrow I'll furnish the
Yes.
order.
Lord, may I take 1 more minute? Preliminary decree is not there, my lord. They can't proceed without a preliminary
No,
decree.
mister, you are an 100% case, but it is in a delay. 1 year you have kept, one year, 3 months, mister. I am
1
about
year
to grant
there-
interim order. I
there
am
I-
seeing that, mister, then, yes, when
There
we
I
are
filed
waited
an
for
application.
1.5 years, why can't 1.5 month? That shows that there is no urgency, mister.
Request for preliminary hearing, my lord, on 11th.
Yes,
preliminary hearing anta mention.
Yes, post this matter on preliminary hearing and so on.
Please, grateful.
Yes.
Cell number 46, Manu
For the
BP.
petitioner, my lord. The petition is challenging the order dated at page number 12, my lord.
Yes.
Order dated 18/9/2024, my lord. The petitioner is the judgment data. Respondent is the decree holder.
Hmm.
My lord, the respondent is the insurer. Is paid the amount to the claimant under the pay and recovery, my lord.
Now, degree for what?
That is at page number 42, my lord.
42.
42 is the answer. At annexure B.
Hmm.
The petitioner and respondents are the respondent in the claim petition filed by the some Sahina, one Sahina, under the motor vehicle accident, my lord.
Entitled to the compensation of 2,70,000.
2 lakhs under the principle of pay and recovery, my lord.
You are that.
I'm the owner of the vehicle.
Yes. Hmm.
And there is a direction by the tribunal that for the
Has to pay respondent
number
number
2, that is the respondent herein.
1 and 2 error.
One is the petitioner. Second is the respondent or insurer.
Insurer.
Liability
on both.
Yes, but both are liable. And there is a direction that you pay the direction to the insurer. You pay first and recover the amount from the
pay and recovery policy.
Yes, my lord.
Yes.
Accordingly, he paid, my lord. Subsequently, under the principle of pay and recovery, my lord, he filed the execution petition, my lord. The execution court has the procedure undertaken, my lord, by the before issuing arrest warrant, my lord. Now I'm challenging the arrest warrant issued by the executing court. That is at page number 12, my lord. Page number 12, my lord. Before that, my lord, in the page number 12, the arrest notice issued to the JDR is not personally served to the JDR, my lord. Is served to the wife of the JDR. It is clearly mentioned, but the case is called out. Counsel for the DHR has filed objection. Notice served to the wife of the JDR. JDR is absent. As such, issue arrest notice to the JDR and hearing application, so on so. My lord, on 18/9/2024, the case is called out. Issue arrest warrant, my lord. The JDR, my submission, my lord. Before issuing a arrest warrant, my lord, there is a statutory obligation on the part of the executing court to verify whether is any competent to financially, whether is any means to pay the decretal amount or not, my lord. That a statutory obligation that the procedure inquiry has not been undertaken by the executing court.
Where is that?
That is the Jolly Judge. The first head note, man.
No, you read that operative portion, not head note.
Head note.
Operative portion was read.
Operative portion, my lord. Yes. At 11 of 11.
Yes.
The words which are heard are as since the date of decree, the means to pay the amount decree. This implies superficially read that if at any time after the passing of an old decree, the judgment debtor had come to some resources and had not discharged the decree, he could not be detained in prison even though that earlier point of time was found to be penniless. This is not a sound position apart from being a human going by the standards of Article 11 bracket of Covenant and Article 21 of Constitution. The simple default or discharge is not enough. There must be some element of bad faith beyond mere indifference to pay, or some deliberate or rescuant disposition of in the past, or alternatively current means to pay decree or substantial part of it. The provision emphasizes the need to establish not mere omission to pay, but an attitude of refusal.
No, what is he?
Yes, my lord.
What is it, your client?
My client, my lord, is a senior citizen, my lord, who aged about 65.
Senior citizen,
but he's not doing anything, my lord. He's suffering from, my lord, there is a medical record to show that.
What is that?
He's suffering from cervical spine problem.
What is he? What is his? He's a retired official or an?
He's not official. Nothing, my lord. He's staying in the home, my lord.
No, you don't have any sources of income.
As of now, my lord, as per my.
As of now, have you filed an affidavit showing that he has no income? Have you stated in the petition, Mister? That protection is given.
I have stated in the
sending in a civil prison.
Yes, sir.
Is no useful person who don't have any money.
Yes, sir.
Because they have to maintain that persons. That is what the intention that.
That is true, my lord.
If you have any money, therefore you cannot be sent. That is
That
not
is
the.
true, my lord. My lord,
Whether, have you stated that you have no money?
yes, but the petition, in the petition are stated, my lord.
Yeah, where is that?
My lord, it is submits para 11, my lord. It is submits that petitioner is suffering from cervical spine bracket plane disorder problem. Thus, petitioner is not positioned to do work. A petitioner is completely depending on others and the above
You don't have any property, any this thing. Have you stated that, mister?
the property of,
Only you,
that is true, my lord. One aspect, my lord.
if you have money, it can be attached. If you have any property, it can be attached.
My lord,
If you don't have anything,
yes, my lord.
what is the purpose in sending the
My
jail?
lord,
That is what the.
Exactly, my lord. One
You have
sub-
everything, but don't send me a jail and don't ask me to pay. Then what is the purpose of obtaining the degree, mister?
One submission, my lord. If really I have any property, my lord, they can attach the property, my lord. For sending me into the prison, my
No,
lord.
that's what that. If you have any property, see, if you are not present the court, if you are appear before the court, court will ask to submit your asset and this thing.
The court has to
If you are
conduct an
not
inquiry, my
appeared,
lord.
then court has no other option
My
to,
lord,
that whom they will ask
My lord,
to.
and at least, my lord, the show cause notice.
You have any property, tell me that.
My lord, I have to verify, my lord, whether.
Verify tomorrow.
My lord, tomorrow, my lord, one submission. My lord, till
You
then, my
verify
lord,
that.
the arrest notice came to be issued, my lord. Till then, my lord,
If you file an affidavit saying that you have no other sources of income, I will
my lord,
grant.
if even though, my lord, the alternatively, if I have a property, my lord, the property could be attached, my lord.
I will direct them to attach.
They have to do.
See, if person having some income will grant a stay saying that deposit some percentage of amount. If you have that, I will say that deposit 50%, I will grant. If you say you don't have any money, the purpose is granting an interim order will not serve. Person who has suffered an accident, lost their family members, you have to see their fate also, mister.
My lord,
Then
that amount
you-
already been.
Insurance companies, you should,
paid,
it's a public money, there is a
payment.
pay and recovery, you have not challenged that order.
Well, we have not
Then your,
challenged. That is
then
fine,
your
my lord.
liabilities is there.
Yes, my lord.
Yes.
My lord,
If you don't have money to pay even 50%, then you show me that property is there, I can say that court can proceed on that property.
my lord, the
Tomorrow.
procedure undertaken by the executing court, my lord, even show cause notice also not been issued, my lord.
If you want on technicality, I will pass an order.
Day after tomorrow.
Yes, day after tomorrow.
Preliminary.
Yes, same stage. Day after tomorrow. Huh? Yes.
Serial number 47, Lingaraju KR.
Bit of here for petitioner, my lord.
Yes.
Is the plaintiff petition, my lord. Plaintiff filed suit for declaration, my lord, claiming under the sale date dated 14/4/1961.
Yes.
My lord, along with suit, my lord, application had been filed for seeking not to alienate, my lord, IA number 2. Initially, interim order has been granted, my lord, by directing the parties to not to alienate the suit schedule property. My lord, subsequently, the defendants have filed IA for IA number 7 for.
Suit for?
My lord, suit for declaration, my lord. I am claiming under the sale deed. Only, my lord,
What is the reason given by that both the courts for?
my lord, trial court came to the conclusion that, my lord, section 52 is there, my lord, para number 16.
Yes, or issue notice. Parties are directed
Not to alienate.
not to alienate that petition scheduled property till next date of hearing.
Much of.
Yes.
Serial number 48, V. Manjunath Prasad.
Yes.
Only pass over the matter.
Password.
Serial number 49, GV Shashikumar.
Suit for declaration and injunction was filed.
Yes.
Thereafter, it was amended for possession also. And since there was construction going on, an application under Order 39 Rule 1 and 2 for restraining them from continuing the construction was filed. That came to be rejected. All that thereafter I did was filed an application under Order 39 Rule 7 for an inspection to take few photographs and produce it before the court. That application is rejected on the count that your application for injunction is dismissed and no grounds are made out is what is. My lord, may kindly.
Now that
Please.
you are suit for declaration.
Yes, my lord. Sought for possession now.
You
Amended.
are seeking for a
Possession also.
Now admittedly you are not in the position now.
No.
Now that why do you want to take the photos?
Well, 39 rule 7 says for an inspection of the property also.
Yes.
So detention, prevention, inspection, etc. of subject matter of the suit. The court may on the application of any party to a suit and on such terms as it thinks fit, make an order for detention, prevention or inspection of any property which is the subject matter of the suit or as to which any question may arise therein.
Detention, prevention, inspection.
Inspection. All that I have sought is an inspection.
On the application of any party to the suit, on such term as it think fit,
Yeah, my
make
lord.
an order for a detention, preservation, inspection of any property which is subject matter.
Subject matter of the suit.
As to which any question, no, you, inspection has to be permitted to you or court has to appoint?
Court appoint a commissioner. I have sought for an advocate to go there, inspect and produce, file a report to the court.
Yes, notice.
The court rejects that application.
Yes, notice.
Lord, cross-examination is going on. And only thing that I have sought is
Yes, they are further proceedings in OS number 923 of 2009, pending in the file of 5th Additional City Civil Judge, Bangalore, till next date of it.
published.
Cell number 50, Abubakar Shetty.
Serial number 50, I appear for the petitioner, Lord. In this case,
Yes.
Lord, petitioner is the first defendant before the trial court, Lord.
Yes.
And the first respondent herein was the plaintiff, Lord. Plaintiff files an injunction suit, my lord, by camouflaging, because, my lord, the entire transaction is a commercial activity, foreign business,
Yes.
my lord, and the amount involved is more than 50 lakhs. Your lordship may
Yes.
kindly see.
Now, what is that order you are challenging now?
Now I am jurisdiction, very jurisdiction of the court of trial court. I am challenging here, my lord. The entire proceedings is null and void because the, my lord, Commercial Courts Act Section 21C attracts.
Where is that order, Mister?
Entire proceedings, my lord. Proceedings I am questioning. The entire proceedings
No,
and jurisdiction of.
No, if the court has no jurisdiction, you file an application under Order 7, Rule 11, Mister. You can't challenge
No,
here. You file an application.
Order 7, Rule 11, my lord, that has been rejected.
Then
now I am before this honorable court only with regard to the jurisdictional point, my lord, because Commercial Courts Act Section.
Mr. Counsel, if the court has no jurisdiction, Order 7, Rule 11 is available for you. If it is rejected, you challenge that. You can't see when that is rejected. You can't filing in a written challenging that. Yes.
No,
Where is that rejection?
I place before your lordship some of the citation judgments of this honorable court. Your lordship may kindly see the entire judgment separately. I annex it to this petition. This honorable court passed the order, lord. Your lordship may kindly see the judgment citations placed before your lordship. At first, my lord, there are 4 citations I placed before your lordship. The first passed by this honorable court. Footwear, fine footwear, private limited versus Skechers. This honorable court laid twin test, my lord. That is nature of dispute and specified value. Your lordship may kindly see my citation number 1 at page number 6. Page number 6, my lord. Page number 6, twin test, para number 9. It has been well set. Para number 9, my lord. It has been well settled position of law that the plaintiff, being the dominus litis, has the prerogative choosing the court and determine the valuation of the suit for the purpose of pecuniary.
That is all right, Mister. If you have that order on that application, they have come before this court, not that quashing of that entire proceedings. You can file an application. Now, where is that rejection order of Order 7, Rule 11?
Lord?
Where is that application rejected your Order 7, Rule 11, Mister?
That
you produce that copy. Yes.
Even my lord, your lordship may kindly see Commercial Court Act, section 2, my lord. Section 2.
No, I know that, Mr. You produce that order, 7 rule 11 order, then we'll answer. Yes. Is this matter of 2 weeks? Yes.
No, my lord, date may be fixed, my lord. Date may be fixed.
Date, my lord. Yes. Next week.
Next week, one date may be given, my lord.
Yes, 29th.
For the petition in this matter, my lords.
Yes.
Is defendant's writ petition, my lords. My lords, respondent number 1 filed a suit for bare injunction, my lords.
Yes.
Against the defendants, against the petitioner as well as the response 2 to 4, my lords. My lords, the suit property is 1 acre 21 guntas, my lords. And he says that in his plaint at para number, my lords, page number 29, my lords. Suit for bare injunction, my lords.
Yes.
Page number 29, my lords. That is the plaint filed by the.
What is that order you are challenging?
The order is at annexure, my lords, page number 22, my lords. It is the, my lords, the order where the learned trial judge grants the police protection ad interim, my lords. And my lords, the suit property belongs originally to my brother, my lords.
Where is that order? Yes.
Page number 22, my lords. My lord, suit property originally belongs to my brother.
Any injunction order?
My lords, there is an injunction order, my lords, but he is the son of a local MLA, my lords. The present respondent number 1 plaintiff is son of local MLA, and the suit.
The injunction order is there.
It is there, my lords.
Yes. Whoever may be that, have you challenged that order?
My lords, kindly come to page number.
I am asking that, is that injunction order passed by the trial court? You said yes.
Yes, my lords.
Have you challenged that?
I have not challenged, my lords.
Then
the very reason is this, my lords. The suit for specific performance is pending between myself and my brother, my lords. It is at page number. Page number 82, my lords. The very suit property was agreed by my brother to sell in my favor, my lords. An agreement was also entered. It is at page number. Agreement is at page number, my lords.
Yes.
73. In that 2016 itself, I entered into an agreement and I took the possession, my lords. Totally 1,51,000 was the sale consideration.
Yes.
I paid 1,50,000. Only 1,000 was remaining, my lords.
Yes.
In the meanwhile, my lords, the plaintiff, my lords, respondent number 1, being the son of local MLA, took the entire sub-register set up to the home of my brother, and he got the sale registered, my lords. Thereupon, my lords, he files application under, my lords, section 151 at page number 1110, my lords. Page number 110. After obtaining TI order, my lords, he files application seeking jurisdictional police help to enforce injunction order by way of removing the illegal alert put up by the defendants, my lords.
What is that injunction order?
Injunction order, my lords, is not to interfere, my lords. It is at page number 102, my lords. 106 is the operative portion, my lords.
Yes.
The learned trial judge, my lords,
Yes.
after filing this application under 151 by the respondent number 1 plaintiff,
Yes.
kindly come to order sheet at page number 21 once for a moment, my lords.
Yes.
21, my lords, page number 21. That is on 25 to 2026, my lords. Counsel for plaintiff for defendant present. The counsel for plaintiff filed IA under order 39 rule 1 and 2 CPC and IA 5. Office is hereby directed to register the separate miss with respect to IA 4 and put up with this case by next date of hearing. Heard the counsel for the plaintiff on IA 5. Kept by. The counsel for the plaintiff also filed memo with documents. The counsel for defendant praised time to for objections to IA 5 for orders kept by. On the same day, my lords, without granting me an opportunity to file my objections.
What is that order passed by the trial court?
Page number 22, my lords. 22. That is ad interim ex parte. The prayer itself is not sought as per page number 110. That is IA number 5, my lords. Being a son of local MLA, my lords, yielding to the political. Please, my lords.
Have you violated the court order?
I have not violated, my lords.
Then what is
My
the
lords, the thing
difficulty
is
if
this,
the
I am in
police is-
possession of the property, my lords. As per 78, 79, 80, 81 page number,
No,
I am in
what is-
possession of
What is the
property.
injunction granted by the trial court?
Not to interfere, my
But
lords.
then why you have not challenged if you are in the possession?
My lords, the thing is that, and he has also filed an application at around,
No, Mr. What is that value of the court order which is passed an injunction?
my lords.
See,
He is,
even if it is not filed any application, it is for the duties to see that court order has to be implemented.
please, my lords.
You have not challenged.
My
That
lords,
is what the police protection.
the
says.
respondent
Time
number,
and again saying that MLA son, MLA, you is an MLA son or any chief minister's son. It is not, no material in this.
My lords,
Court
my
has to pass an order on that.
my lords,
merit
please,
of the
please,
case.
for a moment, my lords. The respondent number 1 herein has filed IA under 1 rule 10 in my suit for specific performance, my lords.
Now I am asking that why you are not challenged that injunction order which is against you. If you say that you are in the possession,
Please.
you are kept quiet. Now that they have asked the police protection to implement that court order, what is wrong?
Ad interim is not grant, ad interim, my lords. It is granted ad interim. Page number 22 preamble portion, my lords.
Yes,
The present application is filed by the plaintiff under section 115 of CPC,
yes.
seeking ad interim ex parte police protection for effective enforcement of the temporary injunction already granted by
I
this
add
court.
interim police protection,
Alla,
borough
that-
life, there may be wrong. They are ultimately what they have given a police protection to implement that order.
ಅದೇನಾಗಿದೆ ಸ್ವಾಮಿ, I am in possession as per the agreement at,
By guise of that police protection,
please.
police cannot be dispossessed to any person who is in the possession.
My lords, the petitioner was made to sit for a whole day in the police station, my lords. He is before this honorable court.
How he came? Why you have not challenged that order?
After learned advocate before the trial court went to the station and he got these things and my lords.
You should
Kindly,
notice. Which is a police station?
SHO Bangarpet, my lords.
Eh?
SHO Bangarpet.
Station house officer, Bangarpet. The Bangarpet police station is directed in guise of police protection. They cannot dispossess the parties who are in the possession. If there is any violation, court order, they have to report the same to the court. Learned counsel appearing for learned counsel appearing for the petitioner submitted that in guise of impugn order, police protection, the police are dispossessing that petitioner from the suit scheduled property. Pursuant to that order of the court, the police has to implement that court order, not to dispossess that person who are in the possession of that property. If police station party ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ ಸರ್, ಯಾಕಂದ್ರೆ ಇದು
Why?
since my lords trial court order has been challenged, I sought stay on the execution of the said order, my lords.
Yes.
25, if that is stayed, my lords, coercive steps will not be taken, my lords, because they have issued notice, my lords. It is at page number 113. Police has issued notice, my lords. Opportunity is not
that
granted.
above. Stay of order dated. What is the date of order?
25 to 2026, my lords.
25
to 2026.
25 to 2026. This interim order will not come in the way of police to give a implement that court order. In the guise of that implementation, they cannot dispossess any party in that
I am in possession. my
position.
lords. I am-
Whoever in that position, they
Please.
cannot dispose.
My lords,
Yes.
on number submission, my lords. Notice to response 2 to 4 may kindly be dispensed with, my lords. They are the formal parties.
Yes, Kudi,
They are the husband and children of the present petitioner.
issue notice to
Respond number 1, my lords.
respondent number 1,
Please.
dispense 2 to 4. Yes.
Number 52, Sharath Esroda.
So the first petitioner's husband, my lord, he had his own business, and out of the said business, he had purchased several immovable properties.
Yes.
Unfortunately, my lords, he died. Thereafter, my lords, the father-in-law and the other children,
Yes.
they cornered this lady because she was she lost her husband and she had minor sons.
Yes.
And in a partition suit, they
Yes.
forced her to enter into a compromise decree.
Yes.
That compromise decree, my lords, was challenged by filing miscellaneous petition under Order 23 Rule 3 because separate suit cannot be filed.
Yes.
My lords, that miscellaneous petition has been rejected, as against which this present petition, my lords.
Where is that order?
My lords, that is Annexure A. Lords, one small
It is rejected, yes.
Lords, it is rejected because it says compromise petition, your signature is there in the compromise petition.
Have you alleged any fraud?
Yes, my lords, fraud is alleged, coercion is alleged, undue influence is alleged, because she was in such a position, my lords, that she had lost her husband, she had a minor son,
Yes.
and she was cornered. All the business were taken over by the father-in-law.
Take notice.
My lords, by inadvertence, I have not sought for interim prayer, my lords. I'll add that interim prayer, my lords, and
File application, separate.
my lords, it's coming up for first time, my lords.
Then you take back and file an application, then we'll hear that matter.
Please, my lords, can it be taken up?
Yes, leave this matter next week.
My lords, can it be on 29th, my lords, by that time?
29th.
Please.
Bill number 53, Ananta Narayana PF.
Yes.
53,
None appears. Leave this matter after 2 weeks.
54,
Not
Ravindranath
appear for
K.
the Lord. Lord, plaintiff petitions. Lord, plaintiff, Lord, wife of one late Asaya. Lord,
Yes.
filed a suit for injunction in respect of the house property where, Lord, she reside. The defendant is, my Lord, the opposite house person. To try to interfere with, Lord, taking that, Lord, he has got some, Lord, the oral understanding between late Asaya that he will going to give that scheduled property to the
Suit for?
suit for bare injunctions, my Lord.
Yes.
She is a petitioner or plaintiff is the wife of late Asaya.
That order you are challenging.
Lord, order is that, Lord, subsequently one Parvatam, Lord, she's filed an impleading application in the bare injunction suit that she wanted to implead, but she alleging that she's she's also one of the wife, but she's not produced, she's not said where she's got married, nothing has been
What is
outside.
that injunction you are sought?
Lord, injunction is not said, not to interfere with my peaceful position.
Yes.
That is what is the, Lord, prayer which is.
Pleading applicants.
Lord?
Who is that impleading applicant?
Impleading application, subsequently she come before the court, said that she is also one of the wife of the, Lord, the late Arsaya.
Why father, why that in the injunction suit, what is
That's
there?
why, that is what, my Lord, I have challenged. Well, see, in the injunction suit, she cannot come before the court, my Lord, in the impleading application.
Notice.
Lord, seek for, my Lord, order of that, stay of that order.
Dated. Elide.
Lord, order it, annexure A, my Lord.
Date yavatri.
Date, my Lord. Annexure A, my Lord, sorry. Annexure, date, my Lord, 28 January 2026.
15?
Lord, 28 January 2026.
Why that in that operative portions of the order you are not mentioning the date and all?
Lord,
Everything will be
sorry, my Lord.
Inserted
No,
later.
no, prayer it is in.
ಏನು ಅವೆಲ್ಲ ಫಾರ್ಮೆಟ್ ಡೇಟ್ ಅನ್ನಲ್ಲ ಆಮೇಲೆ ಸೇರಿಸೋದು
No, 27, 26, no, no, sir.
See that your interim prayer, Mr.
No, no, subsequently because it is
Yes.
typographical.
Stay of order dated 28 January 2026. Passed by first additional civil judge JMFC Nelmangla in OS number 354 of 2024 till next date of it.
Great.
Yes.
Bill number 55, VB Shivakumar for petitioner, Umashankar PU.
Yes. Yes.
An application for amendment to the plaint was filed.
Case.
Yes.
Senior is
Password.
There's only one thing, Lord. The learned judge makes a cut paste order throughout. There's an earlier order where I had filed a writ petition before this court in WP number 27192 of 25. This court stayed the order on the ground saying that the amendment application is filed after 17 years and therefore stayed that order. Second application is filed after the stay granted in that writ petition. This is the other application.
No,
I've
on the-
extracted that
On
order.
the same prayer for amendment.
There's different prayers that are being sought.
Yes, Mr.
But that WP number 27192 of 2025, not page 18, I have extracted that order. A copy of which is also sent.
Yes, password. Let him come.
Yes, Lord. Similar orders are passed.
This
And
is
Lord,
also after
he
17.
doesn't want to step into the witness box, doesn't want to lead evidence on.
Earlier amendment is for 17 years. Subsequent, more than 17 years. It cannot be less than 17 years. Then on same ground it has to.
It's a suit for partition.
ಅಲ್ಲ ಏನೇ ಆಗ್ಲಿ earlier amendment filed by you has been stayed by this court that it has been filed after 17 years. This is in 25. Now 26, it will become 18 years. It is not 16 years. Yes, pass over. Yes.
Could it be tomorrow, my lord, because
Tomorrow, yes.
Nale.
Leave this matter tomorrow. Nadithu.
Let him not carry out amendment and all that.
Friday. Yes.
Serial number 56, MB Chandrachud.
Yes. Yes, Mr.
Suit for declaration and injunction.
Yes.
Based on the registered partition deed dated 23/10/2019. Mutation was certified. I am in possession of the property in question. The defendants have nothing to do with the property in question. The learned trial judge was pleased to grant an order of injunction in my favor.
What is that injunction?
Injunction not to interfere with my possession. Defendants have nothing to do with the property in question.
No, they are not.
They are not relatives at all.
No, it's suit for partition.
Suit for declaration and injunction based on the registered partition deed.
Yes.
Between myself and my other family members.
Yes.
Defendants are not parties to the partition
Now, why
deed.
it is reversed in that first?
Reverse on the ground, the father of the defendant was a foster son of my father.
Yes.
No documents are placed before the court.
To notice, parties are directed to maintain status quo in respect of
regard to possession and revenue entries.
Status quo in respect of possession and revenue entries till next date of hearing.
Please.
57, Ashok Chanti.
My lords, in this matter, a judgment and decree is passed against a dead person, my lords. During the proceedings of courts, one Ramaya passed away, my lords. He was not brought on record.
Suit for?
Suit for declaration, my lords. He was the respondent's great grandfather was granted 4-acre land.
Now, what is that order you are challenging?
My lords, I have challenged the judgment and decree before RA court, my lords. There I have filed an application for stay of the judgment, my lords. There is no stay as of now, my lords. The notice have been served. Now, in the meantime, by virtue of the judgment and decree, they are come to this spot and they are trying to dispose me from the position, my lords. In fact, they did not retain any.
Parties are directed to maintain status quo in respect of petition scheduled property till next date of hearing.
Great, my lord.
With your lordship's kind permission, serial number 119.
Lordship, under 19 for petition, lordship, there was
But he is making the payment on Friday, my lord. Therefore, matter may be called on Friday.
ಕೊಡ್ಲಿಲ್ವಾ ಮತ್ತೆ?
ಕೊಡ್ಲಿಲ್ಲ ಅದೇ ಇವತ್ತು ಕೊಡ್ಬೇಕಾಯ್ತು ಇನ್ನ ಕೊಡ್ಲೇ ಇಲ್ಲ.
Lordship, it's been processed, your lordship. Friday we are making it. That is why Friday we are requesting.
Serial number?
119.
119.
119, leaves this matter on Friday.
Interim order may be extended.
Interim order granted earlier is extended till.
My lord, serial number 41.
41.
41. Interim delivery hand of interim order stay may kindly be given. And delivery of interim order.
Memo ಕೊಡಿ. Yes.
Next Friday ರಜೆ. Next Friday ರಜೆ. ಈಗೊಂದು ಡೆಲಿವರಿ ತಂದು ಕೊಡ್ತಾರೆ ಮಧ್ಯಾಹ್ನ ಸರಿ ಬೇಡ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರೆ ಆಮೇಲೆ ಡೇಟ್ ಕೊಟ್ಟು ಡೇಟ್ 70 ಹಾ ಇಲ್ಲ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಕಂಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ
ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಆರ್ಡರ್ಸ್ ಇದೆ ಅದೇ ಇವತ್ತು ಹಿಯರಿಂಗ್ ಮಾಡ್ತಾರೆ
ಅವ್ರಿಗೆ ಸರಿ
ಇದು 91 ರೀಚ್ ಆಗುತ್ತೆ 91 ಲಂಚಲ್ಲಿ ಇದು ಪಾರ್ಸಲ್
ಸೀರಿಯಲ್ ನಂಬರ್ 84 ಏನಾದರೂ ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 84
84
ಹೇಳಿ ಯಾರು ವಿಸಿ?
Sir, serial number list 1 serial number 84. ಏನಾದ್ರು ಅಜ್ಜನ್ ಆಗಿದೆಯಾ ಅಂತ?
ಇಲ್ಲ. ಇಲ್ಲ.
Sir, 117. 117. ಅಜ್ಜನ್ ಆಗಿದೆ.
ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಸರ್ 53 ಮಿಸ್ ಆಯ್ತು, ಏನಾಯ್ತು ಗೊತ್ತಾಯ್ತು. ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
Memo.
ಅದೇ ತಪ್ಪಿಲ್ಲ
ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಇತ್ತು. ಅವರು ತಂದೆ ತಾಯಿನ ಅಡ್ರೆಸ್ ಎಲ್ಲ ನಂಬರ್ ಅಲ್ವಾ? ಆಚೆ ಬಂದ ಇಲ್ಲ ಅದು ಅವನು ಸಿಕ್ಕಿದ್ರು ಆಮೇಲೆ ಗೊತ್ತಾಗಿಲ್ಲ. ನಾನು ಅಲ್ಲಿಂದ ಆಟ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದೆ ಅವನು ಸರ್ ನನಗೆ ವೇಟ್ ಮಾಡಿ ಅವ್ರು ಹಾಗಾಗಿ ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. ಅವನು ಹೇಳಿದಂತೆ ಹೇಳಿದ
ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡೋದು ಮನೆ ಕೊಡ್ತಾರೆ ನಂಗೆ ಇಲ್ಲ ಇಲ್ಲ ಏನು ಕಾಲೇಜು ನಾನು ಬೇರೆಯವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಇಲ್ಲ ನಾನು ಬಂದ್ಬಿಟ್ಟು ಬರುತ್ತೆ
ನಾನು ನೀರು ಕೊಡ್ತಿಲ್ವಲ್ಲ ಇವತ್ತು ಕುಡಿಲ್ಲ ಬೆಳಿಗ್ಗೆ ಕಾಫಿ ಕೊಡ್ತೀನಿ ಇಲ್ಲ ಬೇರೆ ಕಾಫಿ ಟೀ ಮಾಡ್ಕೊಂಡು ಬಂದಿಲ್ವಾ ಈಗ ಕಾಫಿ ಮಾಡ್ತಾರೆ ಎಲ್ಲ ನೀರು ಕುಡಿಸ್ತಾ ಇರ್ತಾರೆ ಇಲ್ಲ ಹಾಲು ಹಾಕಲ್ಲ ಅದನ್ನ ಕೊಡೋಲ್ಲ ಹಾಲು ಬೆಲ್ಲ ಹಾಕಿದ್ರೆ ಅದು ನಾವು ಕಾಫಿ ಹಾಲು ಹಾಕಲ್ಲ
ಹೌದಾ ಒಳ್ಳೆ ಇಂಟ್ರೆಸ್ಟ್ 72 ಇನ್ನೂರು ಕಮ್ಮಿ ಅಲ್ಲ 72 ಎಲ್ಲ 178%, 140 ಇಲ್ಲ ಪರ್ಸೆಂಟ್ ಕಂಪ್ಯೂಟರ್ ಎಲ್ಲ ಕೋರ್ಸ್ಗಳಲ್ಲೇ ಬರೀಬೇಕು, ಏನ್ ಮಾಡ್ಬೇಕು ಆದ್ರೆ ಇವ್ರು ಏನ್ ಮಾಡೋದು ಗೊತ್ತಾ, ಇವ್ರಿದ್ರೆ ಎಲ್ಲ ಮೊಬೈಲ್ ಬೇರೆ ಜೋಬಲ್ಲಿ ಇತ್ತು, ಎಷ್ಟು ಕೂತಿದೆ ಎಲ್ಲ ಬರ್ತಾರೆ, ಆಮೇಲೆ ಮೊಬೈಲ್ ಹೊಡೆದ್ರೆ ಕೋರ್ಸಿದ ಕಾರಣ ಅಲ್ಲ ಆಟ ಹೇಳಿ ಬರ್ಕೊಟ್ಟು ಆಮೇಲೆ ಸೈನ್ ಮಾಡ್ತಾರೆ. ಎಲ್ಲಿ ಗೊತ್ತು ನನಗಿದಲ್ಲ ಸೊಪ್ಪು ಗೊತ್ತಿತ್ತು ಹಂಗಾಗಿ ಅಚ್ಚಿಗೆ ಬಂದಿದ್ದಲ್ಲ ಅವನು ಗೊತ್ತು ನೋಡಿ ಅದೇನು ಮಾಡಿದವಾಗ ಮೇಲಲ್ಲಿ ಇಮೇಲ್ ಕೊಟ್ಟೆ ಇಮೇಲ್ ಏನೋ ಕಳ್ಸಿರ್ತಾರೆ ಲಿಂಕ್ ಕಳ್ಸಿರ್ತಾರೆ ಲಿಂಕ್ ಕಳ್ಸಿದ್ರು ಆ ಲಿಂಕ್ ಎಲ್ಲ ಓಪನ್ ಮಾಡಕ್ ಗೊತ್ತು ಅದರಲ್ಲೂ ಫಾರ್ಮ್ ವರ್ಕ್ ಮಾಡೋದಲ್ಲ ನನಗೆ ಗೊತ್ತಾ ನೋಡಿ ಇದನ್ನು ಅಷ್ಟೇ ಪೇಮೆಂಟ್ ಎಲ್ಲ ಅದರೊಳಗೆ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಲೇಬೇಕು ಹಂಗಾಗ್ತಾ ಇದೆ ಏನು ಇದು ಕಣ ಇದು ಇದೇನು ನೋಡಿದ 100% 430 ಮೇ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡಿದ್ರೆ P1 Zoom 90% ಇದು ರೀಫಂಡ್ ಇದೆ 80% ಅದೇ ರೀಫಂಡ್ ಇದೆ ಅಲ್ಲಿವರೆಗೂ ಇದೆ ನೋಡಿ ಇದು ಒಳ್ಳೆ ತರ ಇದೆ ನಮ್ಗೆ ನೋಡೋಣ ಜೂನ್ ತನಕ ಅಪ್ರಿಲ್ವರೆಗೂ 90% ಇರುತ್ತೆ ಆರಾಮ ತಗೋಬೋದು ಅಲ್ವಾ ಇದೆ ಅಂತ ಕಾಲೇಜಲ್ಲಿ ಬೇರೆ ಕಡೆ ಡಿಮ್ಯಾಂಡ್ ಇರುತ್ತೆ ನೀನು ಓದಿ ಇನ್ನೂ ಗೊತ್ತಾನೆ ಅಂತ ಇಲ್ಲಪ್ಪ ಅವ್ರ ಕಡೆಯಿಂದ ಏನು ವ್ಯವಸ್ಥೆ ಮಾಡ್ಬೋದು ಅಂತಾನೆ. ಮೆಸೇಜ್ ಏನೋ ಏನ್ ಮಾಡಿದ್ರೆ
ಸರ್ 230 ಲಿಸ್ಟ್ ತಗೋತೀರಾ ಈಗ? ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಸರ್ ತಗೊಂಡು 230 ಹೇಳಿ.
So can we say that let them merge all the contentions to the trial court itself? What contentions? Court fee. For us, stamp duty, the anyway trial court. My document is already. We do things on that. You said no in the memo, correct? Which one did you? I gifted me an iPhone a while back. Section is it 17? 17. It's the first 230 matter. Yeah, it's only 230 matter. Your number is? The end of the cause is. I've never had emotional sympathy. Maybe I have felt that I'm not good enough. But I've never felt that I am. I'll just say this. Like, I'm on that puts me to shame. I've come back and said I will. But I never felt useless. Not felt that because I think my love for the practice and take a back step forward. Sometimes I do feel that maybe I should try to reduce the levels. But tomorrow, 7 hours. That's 7 hours right for 7 have to be hard. First and foremost, the real challenge is seats like this. Let's assume that if I'm not stop, 11:30 to 11:30, I do this. 11:30 to 5:30, I there's a strong that's not. There's no pressure, but it doesn't happen. It will happen. Say that. I think the challenge really for me is it's kind of broad work. This practice, I've seen number 18 may reach, may not reach. I meant if I got to go and say something on talking to what happened. I was trying to tell her that, it look better I at least have some.
ಬೆಳಿಗ್ಗೆ ಸ್ವಲ್ಪ ಒಂದು ಮ್ಯಾಟರ್ ಫಾರ್ ಟುಮಾರೋ ಮೆಲಾಡ್ FTP ಕೋರ್ಟ್ 27th ಇದೆ.
Fresh matter or?
Fresh matter.
Tomorrow, yes. 2:30. Hello, now put it date. Yes.
2:30 matter, serial number 122, Vinay N for petitioner.
Oh, this matter. Yes.
Kumar.
Yes.
But I examined the judgment which my learned friend relied upon.
Yes.
And I don't think it will help him.
Yes.
But Lord, to put a quietus to it, Lord, can I make one suggestion?
Yes.
Lord, I will deposit the amount in the court. Let them not withdraw. If this ultimately the court, because one, Lord, there is no prayer. Now, if he succeeds in the suit and the court orders to be paid, then let the court decide on it. Rather than not now, otherwise, if I take notes of this order of which my learned friend relies upon,
Yes.
but there is a clear distinction. When it comes to means profit, there has to be an inquiry. Without an inquiry, means profit cannot be ordered to be paid.
And we'll also direct the suit to be disposed of early.
And also, then the other question would be, but that, Lord, I would request not in my writ petition, but let there not be direction against me, because he let him come to court and seek for a direction, non-writ petition only. Direction, he is asking for early disposal.
No, that court and 227 we can direct to dispose of the suit expeditiously. It is not
Also,
that
Lord,
parties-
now, Lord, the other thing is not the marking of the document. Not that, not order Lords may have to set it aside, because what not the trial court has done is it has now allowed marking of the document subject to objections. Having once said that the document, that issue will have to be considered at time of marking, proceeds and goes ahead and marks the document. That order Lord may set it aside. Let the trial court consider whether the document can be marked in evidence at all or not.
I have an alternative suggestion. If his issue is regarding stamping of the document.
Yes.
My lord, there's a judgment of this honorable court following a Supreme Court judgment which says mere marking of the document does not mean that the court has judicially determined whether the document is required to be stamped on. No, my lords, the document is marked. My lords can direct the court. I filed it in my memo.
Yes.
My lords can direct the court to determine what is the stamp duty which has to be paid on that. And my lords, whatever is determined, I said I have given an undertaking there also saying that I will pay it subject to my rights and remedies available in law. My lords, that can be done. Insofar as the other aspects of the
stamp duty is concerned,
yes,
if you want to, court has to pass an order, they has to assess the stamp duty plus you have to pay 10% penalty.
My lords, yes.
If it is sub-register, then you have an.
My lords, no, my lords, I am perfectly fine with the court only deciding it. I'll tell my lords why. Because the document today is already marked.
Yes.
My lords, the judgment which my lords have relied on to pass that order, that was a case where it said that if the party desires, the party can take the document back from the court before it is marked, take it to the sub-register. No, my lords, in my case, it's already marked subject to issue regarding. Insofar, my lords, there are my learned friend has raised 3 other contentions regarding the admissibility of the document. First, he has said regarding the fact that it's not notarized. That, my lords, the answer, the court has said that I have to prove the execution. So that is one part. Insofar as the second part is concerned regarding non-registration of the document, the court has said it's a collateral purpose. Then, my lords, the third aspect of the matter is that these are the 2 other aspects. Apart from stamp duty, these are the 2 other aspects.
Yes.
So insofar as those 2 aspects are concerned, the order of the court has to be upheld. And the court has clearly said, my lords, the trial court has clearly said, the stamp duty has to be determined. I may just request my lord to kindly take the order itself. It is very clear. It says that the document is required to be stamped.
No, that.
Then in that event, Lord, I'll have to argue because I thought
it is only for a collateral purpose.
Yes.
But then, no, it will not be collateral purpose. The 2 things, Lord. That is why the order is bad.
Yeah.
Now, what the court says is, the court says the document consists of various aspects. The GPA one portion says you're entitled to execute. The second portion says that you can file a suit, etc. Now, my lord, in Rajni Tandon's case, the Supreme Court was considered Section 32 of the Registration Act.
Yes.
There, the question was whether, my lord, a document where the person is authorized to execute a document before the sub-registrar, does it require registration? The court said only for that purpose, 32C will come, it will be required registration. In 2025, the apex court has taken a different view and has referred the matter to larger bench, saying that if you are asking for registration of a document, per person executes and gives someone to go to the registrar's office, register. If that requires registration, then the reasoning in Rajni Tandon is not correct, because for the purpose of execution of document also it requires registration. That is what not the latest judgment of the apex court says. Therefore, the question would be, Lord, it is not only with regard to stamp duty, as my learned friend tries to point out. It is registration also. It is stamp duty also. It is also the fact that, Lord, it is not notarized, and it will not be collateral purpose, because the one purpose of this document is for registration. The other purpose is to lead evidence. So you can't say that this is a collateral purpose. Therefore, that order to that extent will have to go, and the marking will have to go. And let the trial court reconsider that issue.
Already argued, my lords, all of this was argued. My lords, this is very most unfortunate, my lords. My learned friend argued that point.
That judgment which he has cited,
Collateral purpose.
even that there are a different purpose it has been given. The purpose it is being used is for only a collateral purpose, can be part of that documents can be used for that purpose.
He's now re-arguing the matter again, my lords. In the guise of saying I'm conceding to something, he's re-arguing them. Very unfortunate, my lords.
Even that document is marked, how it will be affected your rights.
Document is marked.
Only thing is that it is not stamped. That will direct it to pay that stamp duty.
Yes. Lord, can I make one request in the alternative? Yes. Lord, may keep that issue open. Otherwise, what will happen is, Lord, I will not be able to raise my contentions on that. Lord, what I felt was, but this is taking a lot of court's time, and also, Lord, that it is going on and on. I did not want to take further time of the court. Therefore, Lord, I advise the client also that insofar as the payment is concerned, you deposit it in court. Let them not withdraw it. Let it be ultimate result of the suit.
Yes.
And Lord, insofar this is concerned, it will be sorted out. Let the trial court decide these issues. Let the issue be kept open.
My lord's question of keeping issue doesn't arise. Court has given a conclusive finding saying that it is for collateral purpose.
All that order.
It's passed an order. That order has to be upheld.
There is that order.
My lords,
No, that is the order impugned.
My lords, page 93, the order starts, my lord.
Yes.
Kindly take the order, my lords. My lords, the reasoning of the order, my lords, starts at page 100. The reasoning of the order starts at page 100, my lords.
Yes.
My lords, may I request, my lord, to kindly see, my lords, paragraph number 23 at page 103.
Yes.
My lords, paragraph number 24 says that registration is not required.
Yes.
A clear finding given.
Yeah, finding it tappu ant helta
My lords,
in light of the apex court judgment.
No, my lords, I'll address, my lords, my learned friend has argued saying that the finding is wrong.
Last time, argument is though, I have to respond. I thought I'll close the matter.
Yes.
My lord, this is being, I don't know how to say, being more than necessary.
Now, one question I have put last time.
Please note.
That you have to be answer. What is that
point? My lord said that under section 42 of the Court Fees Act, suit for eviction, when I pay court fee under 41(2), that is inclusive of damages.
Yes.
41 subclause 2 is inclusive of damages, because the explanation to the Court Fees Act makes it clear that is inclusive of damages. My lords, I had relied on a judgment of our High Court which had extracted that portion. My lords, to which the distinction which was brought out by my learned friend was, yes, he said mean profit is different. I am not on mean profit. I am on admitted rent.
Yes.
Admitted renting, I don't need to pay court fee. On mean profit, I am required to pay court fee. On admitted rent, I don't need to pay court fee. I have not asked for determination of mean profit. I have asked for future rents.
Yes.
My lords may take section. Give me the judgment of this man. Our site list of authorities. My lords may just take my list of authorities for a minute, my lords.
Yes.
My lords, in my list of authorities, page number 20, my lords.
Yes.
My lords, paragraph number 14.
Yes.
whether in a suit for ejectment, landlord is required to pay court fee on the amount of rent or the amount of damages he claims after termination of tenancy. My lords, then section 41 is extracted. My lords, may see subclause 2 which is extracted.
Yes.
In a suit for recovery of immovable property from a tenant, including a tenant holding over after termination of tenancy, fee shall be computed on the premium, if any, and the rent payable for the year next before the presentation of the case. Andre year next before andre next year again rent payment bakagitto adra mele court fee. Explanation says rent includes damages for use and occupation of a tenant payable holding over. Andre, if he is holding over also, he is bound to pay the rent, and that rent which he is bound to pay, court fee is liable to pay. My lords, this question was answered. My lords, there are two parts to it, my lords. First part where the
You have argued that point.
my lords, I've argued it. My lords, that is that insofar as that aspect is concerned, my question that my lords asked my learned friend was, please see the explanation. Explanation says that it is inclusive. The matter was adjourned only for the purpose of my learned friend to clarify on that one issue. All the other issues, my lord, matter was argued. Collateral purpose was argued, notarization was argued, everything was argued.
Yes. Yes, Mr.
If he's finished, Lord, I'll make my submission.
Yes.
Lord, please turn to that judgment. Let us understand as to what the context of that case was.
Yes.
Lord, please turn to the very first para at page 16. It arises out of an order, page 16 of his memo citations.
Yes.
Lord, the revision petition, order of Justice Javed Rahim, Lord, which my learned friend was relying upon.
Yes. Yes.
ಅದರಲ್ಲಿ ತಾವು page 16 ಗೆ ಬಂದ್ರೆ
Yes.
keep that open. The first portion itself says whereby it was with reference to order 7 rule 11 B and C of CPC.
Yes.
Then please then turn to para 4 at page 17. In the suit, the principal prayer is for grant of decree for ejectment, directing the tenant to quit, vacate and deliver vacant potential property to the plaintiff, directing an inquiry into means profits.
Yes.
Future means profits under order 20 rule 12 of CPC from the date of the suit till delivery of vacant possession of the scheduled premises. Incidental relief is also asked for cost. Now, my lords, in this context, the question arose as when you seek for means profit, what would be the court fee payable?
Yes.
Please then turn to para 9.
Yes.
Now, because para 8 refers to how he has calculated 1 month, etc.
Yes.
Para 9, as required under section 42 of the Act, plaintiff has indicated in the plaint tentatively the amount which he seeks to recover from the defendant as means profit, since there was no such estimation in the plaint and no court fee was paid thereon. It was urged court fee was not sufficient, not only insufficient but also erroneous. Hence, the suit is liable to be rejected.
Yes.
Then please turn to para 14. The question therefore is whether in a suit for ejectment, landlord is required to pay court fee on the amount of rent or on the amount of damages he claims after termination of tenancy.
Yes.
But I will take my lords to the plaintiff, last time also pointed out, their pleading is the lease has been terminated. And the amount that is mentioned there also is nothing but means profit. Because then please see para 15. The issue shall not hold us long because the language section 41 is very clear. It reads thus. No, this is between a suit
Yes.
with landlord and tenant. Lord, I'll skip the first portion. Please turn to subclause 2. In a suit for recovery of immovable property from a tenant, including a tenant holding over after the termination of tenancy, fee shall be computed on the premium, if any, and on the rent payable for the next year before the date of presentation of the plaint. Rent includes all also damages and the use and occupation payable by a tenant. Therefore, subsection 2 clarifies that if there is any premium paid by the tenant, while quantifying the amount on which court fee is payable, it shall be on the components. For example, if there is a refundable deposit of 10,000 paid by the tenant, then after calculating 12 months rent, it has to be added as one of the components, and the amount so arrived will be the subject for paying court fees. The explanation to the provision no doubt clarifies that the rent includes damages, but what is important is a relief sought if the landlord were to seek damages from the tenant from the date of termination of tenancy, then undoubtedly the amount he claims would be the component on which court fee would be payable.
Yes.
But if the landlord does not seek for recovery of damages after termination of tenancy, then it is only rent which is agreed upon that becomes the basis for computing court fee.
That is
In
what
this,
the 12 months court fee, see, he has to pay that.
yes, not that is what the court. Then please see in this view, valuation done by the plaintiff on 27,000 so on being 12 months rent had to be the basis for computing court fee, which he has done. Office has accepted the valuation, therefore contentions contrary overruled. Now please see 17. Regarding the ground that in a suit plaintiff had to seek first decree for means profit and then seek determination. It has to be kept in mind, Order 20 Rule 12 itself is the answer. It postulates where a suit is for recovery of possession of immovable property and for rent or means profit, the court may pass a decree A for possession of the property, B for rents which have accrued on the property during the period prior to institution of the suit, or direct an inquiry as to such rent. BA for means profits or direct inquiry as to such means profit. C becomes important. Directing an inquiry as to rent or means profits from the institution of the suit until delivery of possession of to the decree holder, relinquishment of possession of the judgment debtor, which with notice so and so, etc. 18. Therefore, proceedings under Rule 12 of Order 20 CPC, particular clause B mandates an inquiry if rents have accrued on the property during the period prior to the institution of the suit. Now, my lord, please see what court has ordered. Court has ordered during pendency of the suit. There is no inquiry. Now, Order 20 Rule, kindly see the Order 20 Rule 12 as well. Therefore, my lord, without there being a prayer,
The inquiry is during that
during the pendency of the suit.
period
During the pendency of the suit.
prior to institution of the suit.
Not only that, kindly see at the cost of repetition.
Yes.
Order 20 Rule 12 Clause C at page 23. Directing an inquiry as to rent or means profits from the institution of the suit until delivery of possession to the decree holder. Therefore, there has to be an inquiry being held by the court. It cannot be by filing an application. Then, Lord, please see para 18. Therefore, proceedings under Rule 12 of Order 20 CPC, particular clause B, mandate an inquiry if rents have accrued on the property during the period prior to the institution of the suit. If such relief is sought, then undoubtedly the provision of Section 42 of the Act would be attracted, which mandates, Lords may please see 42 that is extracted. In a suit for means profit or for immovable property and means profit, fee shall be in respect of means profit to be computed where the amount is stated approximately and sued for and on such amount. If the profits ascertained to be due to the plaintiff are in excess to the profit approximately estimated and sued for, no decree shall be passed until difference between the fee actually paid and the fee that would have been payable had the suit comprised the whole of the profit so ascertained is paid. So here also, Lord, unless there is an inquiry as to what is the amount payable and the court not passes an order, that has to be paid. Then 2, where the decree directs an inquiry as to means profit which is accrued on the property, whether prior or subsequent to institution of the suit. May kindly note this.
Yes.
No final decree shall be passed till difference between the fee actually paid and the fee which would have been payable had the suit comprised the whole of the profits accrued due till the date of such decree is paid.
Yes.
Lords.
What is that application they have filed?
No, the application is not to deposit the rents. Lord, I'll just take my lords to the plaint for a moment just to show.
Will direct it to reconsider that application.
Please let the trial court reconsider. No difficulty.
Application.
Well,
For,
I will-
regarding this
Can I just answer what my learned friend-
documents to marked and all, then you both as argued, I will consider that.
My lords, on
But
that
with-
aspect of reconsideration of that, can I just make a subtle distinction between what my lords, there are two aspects. My lord. Under Section 41 of the Court Fees Act is a suit for eviction. Section 42 is a suit for mean profit. This was a case where there was a inquiry sought to be made under Order 20 for mean profit. Inquiry was sought to be made. That inquiry is done post adjudication. Insofar as the admitted rent is concerned, admitted rent was 27,000 in the facts of that case.
Yes.
He asked for 40,000. So a 40,000 barbeka beda annodake inquiry ಮಾಡಬೇಕು. But on the admitted rent, my lords, the law is settled by this honorable court as well as by the Supreme Court on this issue, saying that a tenant who is holding over is required to pay the rent. He cannot, my lords, please look at his conduct, my lords. I am suffering from cancer.
No,
from 20
see, paying the rent, if tenancy is terminated, that question of payment of monthly rent will be, it's only a damages.
My lords, the 42(2) says damages is included in rent. My lords, I asked myself the question, please see the provision again. My lords,
No, that's what that, now that once it is claiming that as in a damages, then you need not pay that court fee.
My lords, it is not required. Insofar as the admitted rent is concerned. Insofar as admitted rent is, if when I am asking excess, on the excess I am required to pay court. My lords, I ask myself, okay, court fee has to be paid or not. But whether court fee has to be paid or not is a question that has to be raised before the trial court. The trial court can consider it and pass suitable orders. Today, my lords, on the payment of admitted rent, my lords may put me on the same terms that my lords have put in the other writ petition, saying you withdraw the rent every month, subject to the undertaking that if you lose the case, you will pay it, and whatever is the court fee that has to be paid, ultimately if it is determined by the court that you have to pay some court fee, you pay that court fee. Why I say this is because section 42 is very clear. Section 41 subclause 2 is very clear.
Yes.
My lords, my learned friend is trying to say that don't look at suit for eviction. Treat it as a suit for mean profit. My lords, I have not asked for mean profit. I have asked for damages.
Yes.
I have asked for future rent. I have not even asked for damages. Kindly see, my lords, kindly see my prayer, which my learned friend has pointed out several occasions. My lords may just take the plane for a second. My lords, my plane says future damages and the costs of the suit. Page 32, my lords.
Yes.
Future damages and cost of the suit.
Yes.
Now, my lords, please now read 42 subclause 2 again, my lords. 42 subclause 2 of the Court Fees Act, my lords.
It is extracted here.
Extracted in page 21, my lords. Extracted in page 21.
Yes.
My lords, why would the framers of the law ask for deposit of the next year's rent? They are asking not for this previous rent. They are saying pay equivalent to next year's rent. The understanding was ಒಂದು ವರ್ಷದೊಳಗೆ eviction suit ಮುಗ್ದೋಗುತ್ತೆ. ಆ ಒಂದು ವರ್ಷದಲ್ಲಿ ಏನ್ damages ನೀನು claim ಮಾಡ್ತಾ ಇದೆಯೋ ಆ ದುಡ್ಡು ನಿನ್ಗೆ ವಾಪಸ್ ಬರ್ಲಿ. And you are entitled to that money. Now, my lords, this aspect of the matter regarding the requirement to pay the admitted amount is considered by this honorable court in several judgments. My lord, I have pointed out 2 of those judgments in the very beginning. Kindly take the first citation, my lords. Kindly see the first citation which I have relied on.
Yes.
My lords, I have the first citation. There was an application filed to deposit arrears of rent and continue to deposit the rent. Page number 2, my lords.
Yes.
Which was allowed by the trial court. Same kind of a writ petition was filed.
Yes.
My lords, the order is extracted, my lords. In the order which is extracted at page number 5, my lords.
Yes.
Page number 5 in that order which is extracted, my lords.
Yes, yes.
Paragraph number 12 and 13.
Yes.
In the objections filed by the defendant, it is principally contended that without paying the court fee on the said amount, the plaintiff cannot seek for such a direction to the defendant to pay the rent. Same contention was raised and same contention was addressed by trial. At the outset, present application is filed under Order 15 Rule 5, which is an amendment of CPC only in force in the state of Uttar Pradesh and Punjab. My lords, kindly now come to paragraph number 14 at page 6.
No, I have noted that. Yes.
Yeah, my lords. My lords. So, my lords, ultimately, what was, my lords, this honorable court upheld the order, saying that directing him to pay money every month. Lords, why they are doing this, my lord, is basis of the judgment of this honorable court in Bangalore Builders case. Bangalore Builders case, my lord, the High Court has held that in a suit for ejectment,
yes,
he is bound to pay the rent. My lord, this aspect has also been considered, my lord, by another judgment. My lords, next,
Yes,
my lords,
yes.
at page 27, my lords, all those judgments, my lords have seen.
Both of them argued only that point has to be answered now.
My lords, my suggestion, my lords, insofar as my learned friend's contention regarding damages is concerned, if at all any court fee has to be paid on that, if he raises such a contention before the trial court will adjudicate on that. And my lords, whatever is the court fee that the trial court adjudicates is bound to be paid, I'll pay it. But till then, my lords, he cannot say I should not withdraw the money. My lords, please see the situation. My lords, this is nothing but, my lords, trampling upon the landlord. My lords, my lords, my wife and mother passed away due to cancer because this gentleman did not pay the rent which is due for 4 years.
Yes.
My lords, now again he is trying to put the same trump card. My lords, it's a valuable property in Indranagar. He's squatting on it. He doesn't want to pay a penny. My lords, that most unjust. My lord. Please consider that and direct him.
Paying a deposit in court. If he has not sought for appropriate relief, not it is not my fault. He should have sought for appropriate relief, not because the apex court says
Yes.
you have to seek relief and your pleadings should be in consonance with that. If he had sought for appropriate, there would no difficulty.
My lords, I have sought
And
for it.
not
My lords.
bang.
Let me
Can I just please finish?
Just one
I mean,
minute.
you
I
can't
can address it
interfere like
together.
this, Ajay.
My lords, his contention, just one aspect. My lord. I just missed that one aspect. Kindly see my application for a minute. My lord. He said that I have not asked for, I have only asked for deposit. I have never sought for the liberty to ask for deposit. Kindly see page 58 for a minute, my lords. Page 58 for a minute, my lords.
Yes, you're.
I'll just read, my lords. I have now lost my faith in the defendant. My lords, I further state that the defendant is liable to pay damages illegally for occupation from the date of termination, liable to pay damages in all total of 22 lakhs. He is undergoing as the plaintiff is undergoing treatment of cancer and is in need of monies for treatment. Therefore, the defendant is liable to pay the balance of the rent along with interest for loss, etc. I have now lost my faith in the defendant. As such, it is imperative that the defendant deposit the rentals which will payable arising from the court in the court, so that I will be in a position to take necessary steps to derive rental incomes as and when required or deemed fit by me in the captioned case. I have specifically reserved my liberty. So that one aspect I just want to correct. Sorry, ma'am.
Yes, Mr.
But my submission is, I'm ready to deposit in court. Now, my lord, ultimately, if the suit is held to be not maintainable, it will lead to other complications. Now, my lord, what I've said is, in Bangalore builders case, it was a case wherein the court was considered with regard to striking out of the pleadings for alleged non-payment of rent. That is not the case here. The prayer there was different, prayer here is different. If my only submission is, Order 20, Rule 12 would require an inquiry.
Yes.
Now, therefore, I will not trouble the court further, my lord. I would only request that the contention with regard to marking of the document be kept open so that not I can agitate it. Collateral purpose, my lords, I leave it to the court.
Yes.
Because, of course, the judgment which my learned friend relies upon makes a distinction which in a portion which can be looked into, which cannot be looked into. I leave it to the court on that. But with regard to stamp duty and other contention, my lords may keep it open so that I can raise that contention. So to that extent, at least, my lords may consider my submissions.
Yes.
My lords, on stamp duty, insofar as non-notarization is, court itself in its order has left his option open. Court has put the burden on me to prove the execution.
Yes. Yes. How reserve.
Please. Grateful, my lords. I think we took a lot of the court's time.
This is the first matter I took in GMCPC for 3 times in 2:30. I heard. Yes. Otherwise,
but otherly, there is an interesting issue. Not why I also felt it has to be argued because, but the apex court judgment which I showed the court says, without there being a prayer, you can't, because interim relief should be in the aid of the main relief.
yes, we'll see. We'll look
That is
at
the.
it. I have taken notes. I will see.
Please.
Yes.
Continuation of list. Serial number 58, Akshay Kumar Jain for petitioner.
For the
Yes.
petitioner, my lords, I have one submission to make before my learned friend starts.
Yes.
I was served with the final copy of the writ petition last evening. I request for a short accommodation. I'll file my objections. The matter can be disposed.
Objection for what?
This is, my lord,
order, my lord, an application for amendment.
Objection to what?
The writ
The objections are already filed before.
What is that objection you can file in the GMCPC, Mr. Application, objection will be filed in the trial court.
Please.
Here only the petition, whether that order is correct or not. No objection can be filed here. Yes,
No,
if you want time to go through that, it is different. But not that filing an objection like writ petition and all. And there is no application here, separate application for stay and all.
It's a pre-trial amendment,
Yes.
my lord. Even before framing of issues, my lord, even before they file the written statement, I filed an application for amendment. That is now rejected, saying that, my lord, the nature of the suit is changed because of the amendment. The suit, my lord, is with regard to my right as a sublessee of the property.
I think you file and will stay that proceedings.
Yes, my lords, I have one objection for staying. I am the defendant in the suit.
It's my suit, my lord.
The amendment, my lords, is barred by limitation. There are.
I three will hear you are going to stay this suit. Why do you worry, Mr.
My lords, I'm just being harassed for this. 3 orders have been passed by this court as well as the trial court, my lords. saying that they are not in possession of the property. I've demolished the entire building. They're asking me to atone the lease in their favor, and there is no building only, my lords, in the property now.
No,
There are
it is-
judgments, my lord, may I just point out. to
Hear
you,
that. See, when plaintiff itself is before the court, if you make out some case, I will grant a stay because its suit is going to stay. We'll hear that later, yes. Or issue note, you will take notice to whom?
Only for
Respondent number
defendant
6,
numbers,
my lord.
only respondent number 6.
Respondent number?
6. My lord, only contesting party. Others, my lord, I'll file a memo for dispensation.
Yes, filed in a memo dispensation of.
In fact,
notice.
para 2, we have stated, my lord, it may be.
Yes, file memo, yes.
Yeah, fine.
So and so, Kvater undertake to appear for respondent number 6. Stay of further proceedings in OS number 3173 of 2022, pending in the file of First Additional City Civil and Session Judge Bangalore till next date of hearing.
Okay.
Now you can file whatever you want. We'll
May I request for a date to be fixed, my lords?
leave this matter on 15th June.
Please.
Yes, dispensed for a period of 2 weeks. Yes.
Cell number 59, Sanat Kumar Shetty K.
Plaintiff's petition,
Yes,
it's a suit for ejectment
yes,
and arrears of rent and mean profits.
yes,
During the pendency of the proceedings,
yes,
the plaintiff filed an application seeking for a direction against the tenant
yes.
to deposit the arrears of rent, mean profits, and to deposit the mean profits regularly before the court. That application
Yes.
has been kept in abeyance.
Yes.
I'm only seeking for a direction to the court to dispose
yes.
of that application.
Suit for,
Suit for rejectment and mean profits.
what is that application you have filed?
Yes, my lord. Application. My lord, I have filed this application at page number 33.
Yes,
My lord, for the reasons stated in the accompanying affidavit, the applicant plaintiff raised that the defendant may be directed.
yes of
to
rent.
pay- Yes,
Now what is that order passed by the trial?
order, my lord, this application has been kept in abeyance.
Why?
No reasons have been assigned.
Where is that order?
Yes, it is at annexure. Lord,
Page?
page 46, my lord.
Yes.
Last portion,
Hmm.
after the order. The application filed by the plaintiff seeking for a direction to the defendant to deposit the monthly rent amount to the court is kept in abeyance for the time being.
Yes, in this writ petition, petitioner sought following relief. Petitioner plaintiff has filed a suit for
Ejectment
suit for ejectment,
and mean profits, arrears of rent.
mean profit and arrears of rent. On service of summons, defendant has appeared through counsel and filed a written statement. During the pendency of the proceedings, petitioner has filed application under order 15 rule 5 of the CPC. Is it correct, Mr.?
Yes.
CPC seeking direction to deposit admitted rent. The trial court has not passed any order on that application, which is filed on 5/8/2025.
Admitted rent and mean profits also.
Yes. Since no order has been passed, the petitioner is before this court seeking early disposal of that application. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of that application filed by that petitioner plaintiff under order 15 rule 5 of CPC as expeditiously as possible, not later than 3 months from date of register of complaints. Yes.
Cell number 16, GS Srikante Gowda.
Yes, Mr.
Cell
Yes.
It's a suit for a bare injunction.
Yes.
The plaintiffs 1 and 2 are the owners
Yes.
of site number 81.
Yes.
May I request you lordships, because this is very important for the mission.
Now, what is that order you are challenging?
Order is, I sought for temporary injunction because the respondent number 1 herein, claiming that she is the owner of site number 81A. Like she is making an attempt to interfere with my property in site number 81. There is no such site number 81A at all.
No, now
my
that you have filed in a suit for injunction,
Injunction.
then what is that order you are challenging now?
Let the order, my lord, notice has been issued. Though my lord, K-Waiter advocate was served,
You have filed a 39(1) and 2 as no order is passed.
no order has been passed.
Yes, how issue notice. Parties are directed to maintain status quo in respect of petition
Not to
schedule.
interfere with my property.
Status quo, if you are there, they cannot interfere.
Yes, my lord.
Till
They are
next date of
claiming a
hearing.
different property with different schedule.
No, I am said in suit schedule, writ petition scheduled property
Yes,
has to maintain status quo till next date of hearing.
but
Dispensed for a period of 2 weeks. Yes,
Bill number 61, A. Madhusudan Rao for petitioner.
yes.
Plaintiff's writ petition.
For
That
the
the
KVA
suit is-
respondents.
Yes.
Suit is one for permanent injunction.
Yes.
Trial court granted temporary injunction. First appellate court has reversed it. That the suit scheduled property is a site.
Yes.
Which is a part of a layout approved by Buddha.
Yes.
Mysore Urban Development Authority. And it had allotted the site to the father of the petitioners. Thereafter, a registered the title deed was also registered lease
Yes,
comes
what
here
is
also
this
was-
contention?
The they contend that they are relying upon a sale deed which they have executed, which have got executed in 57/1, survey number 57/1,
Yes.
in the year 2022, in respect of 1 acre 27 guntas of land, which according to them is not part of the acquisition proceedings.
Yes.
That is their main contention. And the eastern boundary of that particular property, whatever they are claiming, is the layout formed by the D Group Employee Society, of which my site is a part.
Yes.
Now the question would be this, Milord. They claim that as per an
That you
endorsement.
maintain status quo, both of them.
Yes,
Maintain
Milord.
status.
Apart-
I make this submission.
One more submission, Milord.
Suit itself is not maintainable.
That
Because
let-
of,
yes.
because of this reason, your lordship may kindly take the plaint.
No, you file an application for rejection of plaint if it is not maintainable.
Lord, Lord, my submission is, when the suit itself is not maintainable, there is no question of granting interim order. That is the judgment of this honorable court. My lords. Before that, may I persuade your lordship to take annexure A,
Before
my lords,
that, there
which
is
is
one
the plaint.
aspect I want to bring
No,
up.
which is the
Your lordship's
plaint, my
kind
lords,
notice.
because in the plaint,
No, they see, if suit is not maintainable, remedy is to file a rejection. And other thing is that if trial court is granted an injunction, appellate court's remedy is to limit it. There are all judgment in all the way.
my lords, your lordship may kindly appreciate whether there is a. prima
Therefore,
facie-
you maintain status
Lords,
quo.
whether- my
It
lord,
is,
my-
what is
my-
that land? It is a site.
My lords, they are claiming a site from a society.
Yes.
The total extent of land was, my lords, 6 acres, 17 guntas. Out of the 6 acres, 17 guntas, my lords, 4 acre, 30 guntas was notified by Muda.
Yes.
Muda, my lords, this 4 acres, 30 guntas has handed over to this society has formed sites.
Yes.
But there is dispute whether this extent of 4 acre, 30 guntas or some other extent.
Yes.
Be that as it may, my lords, admittedly 1 acre 27 guntas was not notified by Muda. But by inadvertence, in the revenue records, in the RTC, the entire extent of 6 acres 17 guntas got reflected in the name of Muda. Now, my lords, we, the erstwhile landowners, challenged this, said 1 acre 27 guntas remained unacquired. Therefore, the RTC showing entire extent of 6 acres 17 guntas in the Muda, in the name of Muda is not proper. Assistant Commissioner accepted our contention, restored the extent of 1 acre 27 guntas in the name of erstwhile landowner. Deputy Commissioner confirmed it. Now, my lords, this society through whom the plaintiff is claiming, they filed writ petition before this honorable court. In the writ petition, they came to know that they are not going to succeed because admittedly 1 acre 27 guntas is not notified. But they are claiming in respect of this 1 acre 27 guntas. My lords, they cautiously and knowingly, in a tactical manner, file a withdrawal memo saying that they have already disposed of all the sites in this, therefore they do not want to pursue the writ petition. But this very same society goes and files objections
Yes.
before the Muda,
Yes.
saying that no, we have not utilized, we have not formed any land in survey number 57/1.
Yes.
Now the dispute is survey number 57/1.
Yes.
They produced a layout plan claiming that this comes in 57/1. Now my learned friend is submitting before this honorable court that my land is different, his land is different. But your lordship will kindly see whether he can take up this contention in the light of the prayer sought in the plaint. Your lordship may kindly see the prayer sought in the plaint. Page 16, my lords.
1/6.
Yes. If I am stranger to this property, maybe my learned friend is right.
Yes.
Now let's see, if your lordship will kindly see, what is his prayer in the plaint? Page 16, your lordship got it, my lords.
Yes.
My lords, the first prayer, permanent injunction restraining the defendants, their agents, servants, followers, laborers, so and so, from interfering, trying to demolish our compound wall, and they are trying to put up new compound wall, so and so. That is, that if that is all the prayer, my lord, it is fine. Your lordship will now call this second prayer. Permanent injunction, restraining the defendants, their agents, power of attorney holders, family members, or any other persons claiming on behalf of the defendants from alienating the suitable property by way of sale, mortgage, lease. My lords, in an injunction suit, if the plaintiff himself says that I am having title, I am about to alienate the property, that means, my lords, his title is under cloud.
No,
He can,
no, see,
my lords, and your lordship will
even if
also-
you have any title, they can be sold the property. Person there for a
My lords,
purchase.
my lords,
That can be, if he seek that not to alienate, that doesn't mean that he has lost the title.
Yes, no, that means there is cloud over the title. I'm not saying he has lost.
No, no, even if you have any
But, and your
full
lordship is
title,
saying, your
you
lordship,
can seek not to alienate.
your lordship, no,
See that,
my,
yes.
my respectful submission, you cannot seek that. Your lordship may kindly see annex, prayer C also. My lord.
Yes.
For declaration, declaring that the kata and other revenue records stand in the name of the defendants are null and void, not binding on right of the plaintiff in any manner. By virtue of this prayer, my lord, it is clear that the land.
No,
which
this is a main prayer. in
This
that-
is the main prayer.
Yes.
If
They
in the
make
main
one
prayer
submission
he is seeking for a relief,
Yes.
to say that the kata which is standing in the name of the defendants are null and void. That means, my lord, the plaintiff and the defendants are claiming the same land. If that is so, my lords, how can the plaintiff maintain a suit for bare injunction without seeking for declaration of title? My lords, therefore, my lords, your lordship may kindly permit me to place this judgment on
Before,
record.
He can say, my lord, I want to draw your lordship's attention to one aspect. The only ground on which they are making a claim is that, as per an endorsement given by MUDA dated 6/7/2007, MUDA has given an endorsement stating that 1 acre 27 guntas in survey number 57/1 is not acquired. That is what they are claiming. That is the reason why First Appellate Court has reversed it. What has happened is, till then, my lord, entire 6 acres and dot was shown to be acquired by MUDA as per as per the revenue records. Apart from that, adjacent
No,
site owner, but one more
revenue
submission,
records is not that. Where is that acquisition notification?
that nobody is producing it. What has happened is, I submit one more thing.
May
Let-
pass on
let
this.
me- I'll make my submission. One more aspect is, this very same endorsement dated 6/7/2007, said to have been issued by MUDA. After land was acquired in 86, in 2007, after formation of layout approval, they give an endorsement like this. Society also is colluding with the other private owners now, after selling all the sites. Now, one of the site owners, adjacent site owners, I am the owner of site number 8. Site number 6 owner has filed a writ petition before this honorable court in WP number 3282 of 2024, wherein they have challenged this very same endorsement. And this honorable court has ordered issue notices to my reference clients also, who are respondents in this case, and the matter is
No, that-
pending.
What is this prayer? I thought that it is an injunction, interim prayer you have sought.
No,
You
yes.
sought that injunction and sought that not to alienate.
Yes, brother, my submission is this, prayer may be wrong. My submission is only this, whether the suit is maintainable or not is a question which has to be adjudicated at a different stage altogether.
Yes.
Here is a case where temporary injunction is sought. I am claiming that I am the owner of a site formed by a layout which is approved by MUDA, granted by MUDA, sold by MUDA and all that. Now question is, they say that they are the owners of 57/1 and
What
it's
is
not
there in
acquired.
that land? Is
Yes,
it a
brother.
vacant land or
It's a vacant land.
then you maintain status quo?
That's what I am
Your
submitting.
lordship may for a moment.
Direct the
Now,
suit
apart
with
from that,
this-
Your
I
lordship
want
may
to-
record-
another submission is, when
Your
the matter
lordship
is
may
pending
record-
before this
your
court,
lordship may
in
record
respect
their
of the very same
statement that this
endorsement.
suitable property is a vacant land. And your, let's, before that, my lords, may I pass on this. Your lordship may kindly see this judgment, my lords, for a moment. I just stand it.
Yes.
ILR 2011, my lords, KR 3141, in this compilation, my lords, at page 36.
Yes.
Your lordship may kindly come to para 10, my lords. We are running page 47.
Yes.
One of the factors to be considered by the court,
47.
47, running page 47, para 10, my lords.
Yes.
One of the factors to be considered by the court while considering the case of temporary injunction is whether prima facie case is made out by the plaintiff, which certainly would include the nature of the suit filed and its maintainability. The trial court ought to have kept in view whether the plaintiff could have obtained the relief relating to the subject matter of the suit in the pending proceedings between the parties. Therefore, my lord, the law declared by this honorable court is prima facie case means including the maintainability of the suit. My lords, my respectful submission is, I have pointed out to your lordship the prayers. One is seeking to declare my kata as null and void. Two is seeking not to alienate.
No,
Then
that,
in the said
in
circumstances,
such a circumstances, court cannot grant one relief, that injunction, other can be rejected.
my lords,
Maintainable is there, it can be maintainable, it is not that there may be an inconsistency in the prayer, if he proves that he is in the possession,
my lords,
that
your
injunction
lordship,
can
my
be
lords, your
granted.
lordship may kindly see this, my lords. The Honorable Supreme Court has now made it clear. When a suit for injunction has to be filed, when a suit for possession has to be filed, when a suit for declaration of title. The plaintiff himself, by nature of the prayer which he has sought, has casted cloud over upon his title. When there is cloud over his title, my lords, certainly, my lords, he himself says that declare the katas which are standing in the name of defendant null and void. When he makes that prayer, my lords, how can he, my lords, all this will happen because only to avoid court fee. When the plaintiff very well knows where he stands, and he knows he will fail if he files a suit for declaration and he is not able to pay the court fee. Simply they will design this way and file a suit for bare injunction. It is only a result of clever drafting, my lords. He is not entered because prima facie case includes whether the suit on the first instance. I am not taking your lordship to other aspects at all. Then your lordship.
Is it stands in that municipalities or a revenue this thing?
This is a mood of matter.
Mysore.
Mysore property.
But
And Milord, what has happened?
what
is,
are
I'm sorry,
the
Milord.
documents after that sale deed? It is stands in your.
Kata is made in my favor. Muda has given Kata in my favor. In fact, Milord, I have
No, that-
small shed is constructed. Milord. This is the photo.
No, that see, that is ultimately for the court to decide whether
Milord.
injunction can be granted or not. For temporary injunction is concerned, what is that subsequent material which is shows that who is in the possession of the
Lords,
property?
your lordship may kindly take this his own document, which I have now produced. My learned friend was referring to a legal notice.
Yes.
Page 132.
Documents could have been furnished earlier. Milord.
Put your copy.
They are giving the
Here
documents
he is
now.
not disputing. He said I have issued
What
this
I am
legal
submitting
notice.
is this. Whatever documents he is
Yes, when
filing.
do you want? When do you want?
Tomorrow, Milord.
Yes, this matter on Friday.
Please.
Yes.
So, what that is expected is whatever they are filing, they should have given me at
Lord,
least.
these documents are all before the trial court. We are on KVA. It is his own document. My learned friend submitted. He has issued a legal
I know
notice.
what are the documents that are going to be
Yes.
given.
Yes, you give that copy, we'll see. Yes,
Cell number 62, Abhilesh.
Grateful.
We have a petitions this match.
yes.
Attachment warrant has been issued in an execution petition, my lord.
Yes.
Execution petition is arising out of a compromise petition.
Hmm.
My lords, I would like to draw your attention, page number 64.
Yes.
Page 65 is the typed version of it, my lords.
Hmm.
Arrest warrant to JDR number 2, that is the plaintiff, petitioner here.
What is that compromise petition?
My lords, the compromise petition involves several properties and several transactions, my lords, where the compromise decree states that the decree holder will have to execute a sale deed or a release deed in favor of me. In return, I'll have to give him 40 lakh rupees. 20 lakh rupees I've already issued in the year 2015. And I've also issued a post-dated check in the year 2015 itself, which will be realized in 2017. But till today, he has not given me the possession of the property, nor executed the agreement, my lord. My lord, just for a
Now,
moment.
who has filed that execution petition?
My lord,
Who has filed that
the
execution?
decree holder.
Who has filed the suit?
The suit was filed by me,
Hmm.
and then we compromised.
Hmm. Who is the degree holder?
Decree holder is my brother,
Your brother?
my brother.
Yes,
My lord, just for a moment, my lord, at page number 57.
yes.
Same execution, I mean, the trial court passes an order.
Now, where is that execution petition?
Execution petition is at page number 37, my lords. Annexure C.
You have to pay balance
80
of
lakhs.
rupees 46 lakhs 98,000.
They claim main.
And he
they
has to
claim-
execute that sale agreement
My lords, yes.
in your favor. Have you paid that 46 lakhs 98,000?
I've already paid 20 lakhs, my lords. The due is only 20 lakhs now. He is claiming interest. My lords, just for a moment, my lords.
What is the degree says? Is there any interest?
The trial court passes an order of 6% interest, my lords. In the execution petition. In the
20
execution.
lakhs, 18% interest, it comes to 64 lakhs, 46 lakhs.
True, my lord.
Hmm.
My lord, just for a moment, my lords. Page number 52.
Yes,
Page number 57, the relevant portion, my lords.
yes.
The order passed by the trial court itself very clearly states that
Hmm.
only when the decree holder executes an agreement in my favor, then he is entitled for recovering the money from me. Such being the case, my lords, he files a memo.
Where is that?
Page number 57.
57. Read. What is this order?
So subsequently, he files an application to recover the property from me, take the possession. So the trial court very carefully passes an order, my lords. The application filed by the decree holder under Order 21 Rule 36 of CPC is partly allowed.
Yes.
The decree holder is entitled rupees 20 lakhs with interest at the rate of 6% per annum from JDR number 1. My lords, very careful, very important point to be noted, my lords. It is against JDR number 1.
You are the JDR number 1.
I am JDR number 2. In contrast, the decree holder has to execute the document as per compromise. The execution of the document by decree holder only when the JDR number 1 is liable to pay the amount.
Yes.
So he doesn't even execute an agreement. At the same time,
After executing the documents by the degree holder, only that JDR. Yes. Now what?
And
is
again,
that?
JDR number 1 is liable to pay. I am JDR number 2.
JDR number 1 is not a party here.
He is a party member.
Why?
Not a party to this petition, but he is a party in the execution petition.
What is that order passed against him? Both of them, there is an arrest warrant.
Only against me, my lords.
Why?
No direction also here.
Why?
That is the error committed by the court, my lords.
No, is there any application is filed?
No, my lord. Subsequently, the decree holder files a memo stating that I have not paid the JDR number 1 has not paid 20 lakh rupees to me. But the order is very specifically states.
Where is that order?
59, my lords. Page number 59 is a memo.
Yes.
He files a memo stating that the JDR number 1 has not paid 20 lakh rupees. But the order at page number 58
attached
is
the warrant against that immovable property mentioned in that earlier application. Property belongs to whom?
Property belongs to, it is a undivided family property.
Yes. Now that, where is that order, impugn order?
Impugn order is at page number 64, my lords. The typed version is at 65. So that the direction is against the JDR number 1. But the warrant is issued against me, JDR number 2.
Yes, heard. Issue notice. Stay of order dated
4/4/2026.
4/4/2026. Passed by Principal Civil Judge Senior Division CJM Tumkur in execution number 139 of 2020 till next date of hearing.
Office objection, first time matter, serial number 63, Uday KS.
Yes, Mr. What is that office objection? Not made a party.
My
necessary
colleague
application.
has appeared in this case. Your lordship directed us to produce the company has got a registration there or not.
No, what is that office objection? Petitioner, execution petition not made as a party. Necessary application to be filed for bringing a loss of auto. Yeah, now that, what is this matter?
Decree holder number 2, respond number 2 is dead. His LRs are already on record.
Yes. Now, what is that matter?
To produce any document to show what is the address of the company. That is the company address is there. I am producing the document of registration certificate.
Yes.
But
Where
along
that?
with it, I am producing a lease deed, your lordship.
What is that address of the company?
Address of this company is same, but the lease deed your lordship has to look into. Lease deed nalli page number 5 tagondre. Rental agreement between the objector and the lessee, all that part and parcel of portion of premises in second floor consisting of one room with a wardrobe and one bathroom living separate interest in the property.
No, first floor, second floor is for company.
Second floor only this room. Mickey rest of the property, this lady is living, old lady. Therefore,
Now, what is that order you are challenging here?
warrant is issued in respect of the entire property, your lordship.
Where is that?
Annexure A, your lordship, page 11.
Yes, that is not the company's property.
Yes. Only at that room, that has to be modified.
Issue notice. Stay of order dated 16/4/2026 passed by 38th Additional City Civil and Session Judge Bangalore in execution number 1303 of 2019 till next date of it. Yes. Office objection is overruled. Yes.
Serial number 60.
Issue and
Yes.
Serial number 64,
I
Nagesh.
assume not for the petitioner. There are two office objections.
Not one objection is that there is a common order passed by the trial court on
Yes,
IA
that's-
number 9 and 10. We have filed one common writ petition paying 2 court fees. That is
2 court
permitted.
fees paid. Yes.
Yes, yes. Other
Yes,
one,
yes.
aggregate not signing, that has been done, you know. Now the
Yes.
issue arises like this. I am not the defendants in the suit. Not the suit
Yes.
was filed in 2013, and my lord, for various reasons, my lord, it has come up and down the Honorable High Court and back on more than one occasion. In this case, my lord,
Yes.
evidence actually commenced in 2025. And we
Yes.
have a written statement, evidence was recorded. At that stage, my lord, there was no attempt to settle the matter. So that went on for
Yes.
a few months. Thereafter, my lord, the matter was set down for our evidence, at which stage, my lord,
Yes.
the other side, the plaintiffs filed an application saying they want to reopen the case for filing some more documents and evidence. That application was heard. Meanwhile, my lord, I said I would like some time to file my evidence. The court had closed my evidence in November of 25. All this took in the interregnum. The learned judge will not reject my application to say this is a very old case. Not my submission is there is a severe defense available to the
No, your application for what?
for recalling the order, closing my site to give evidence.
Yes, where is that order?
That, my lord, your lordship to get at page 26, my lord.
The operative person is at 29.
29.
Your lordships may see, my lord, at page 30, the
Yes.
reason begins from there, my lord, page 29 bottom. I may read from page 30, my lord.
Yes, yes.
This is a 10-year-old case. This court has granted time as the last chance as mentioned in 61125. Therefore, by assigning reasons, this court has rejected the prayer and closed the evidence of defendant as nil. On the same day, counsel for plaintiff filed a recall and reopen application by way of files 6 and 7. These two applications came to be registered with cost on 500 on 3/13/226. However, when defendant evidence is closed, case is posed for plaintiff's argument. When defendant is assigning reasons that due to retirement resignation of employees, defendant was to read evidence in the time. Therefore, defendant short time is not correct. It may be 10-year-old case, the matter had come. What happened in this case was initially, the plaint was rejected. That came up before your lordships.
Yes.
That writ petition was allowed, the matter was restored. Thereafter, my lord, there was a request to transfer this to commercial court. That was rejected.
Yes.
That appeal came before this on the court, and that was allowed. Then some procedure leave. So really speaking,
Yes.
my lord, it is only in November of 2000. Your lordships may just notice this one date, my lord. They concluded their evidence in July, August of 2020.
No, earlier, there is a application filed by that plaintiff is also rejected, has been challenged before this court.
We have
Yes,
not.
actually, my lord, the learned judge should have considered both these together.
Plaintiff has filed a recall and reopening application.
Please. I have not challenged that, my lord.
Two came to be rejected.
If I may.
You are not challenged that.
Your lordships may say the dates, my lord. My,
Yes.
my,
No,
my lord, the
Earlier,
closure-
that plaintiff is also filed an application. Yes. Plaintiff application is also rejected
Yes,
for
my lord.
recalling.
Plaintiff has already adduced evidence, documents are marked, witness is cross-examined. Then, my lord, it was set down for my evidence, and my evidence
Yes.
was closed. Then, my lord, they filed an application to reopen their side. If they now don't want to pursue it, that is different. But I must be given one opportunity not to adduce evidence because there was a settlement talk that is going on. The order sheet bears it out, my lord. More
Where is
than-
that? Yes, show me that, that reasons.
At page 29.
29.
One opportunity, my lord, I request that should be given, my lord.
What is the next date before the trial court?
27th of.
25th.
What is that?
If I may, my lord, one
No, what is the stage now it is posted?
For their
It's for
defendant,
arguments.
final
Arguments.
arguments, I have completed my final argument also. If I may, my lord, as far as this, if my lord,
No, you want to that reopening for what purpose, mister?
Or my evidence, my lord. I want to adduce evidence, my lord. I am the defendant in the
No,
case.
you have not adduced any evidence.
No, my lord, that's
Will
what I'm
give
submitting.
the situation
All
here is
this
little
period,
different.
The matter
To
was
SAVH project.
till November
No,
of
on 27th itself, let him conclude that. We will
The
impose some
issue
cost.
here is not about them leading evidence, my lord, because this is what I foresee, my lord.
As far as the WS is concerned, my lord, I agree with my lord senior on their submission. WS was filed, no documents were produced. This is a commercial court matter, my lord.
Yes.
Where they, under statement of truth, they ought to have said any documents is produced or not. However, the statement of truth doesn't mention about what documents are produced, except barring board resolution, nothing has been produced now. Today, assuming that we allow this repetition, my lord, they will file tomorrow an application for production document. I will have to sit and contest that also. We are literally reopening case management.
No, that only will allow it to examine. There is no production of additional
Please,
documents and all.
My lord, I am the defendant in the case, my lord. Supposing the plaintiff, my lord, now the plaintiff wants to produce additional documents, that is rejected. Now, my lord, in my defense, whatever is in my defense, whatever is permitted in law, my lord, I will do it.
No, you have given opportunity, you have not availed that opportunity. Therefore, you can't say that it is in a commercial suit.
No, my lord, the difficulty is this. My lord, this was not a commercial suit, my lord. This suit was filed before the Commercial Courts Act came. The suit was filed in the year 2013. Then, my lord, so there is a question as to whether the Commercial Courts Act will apply or no. But I'm not on the technicality, my lord. I also want to adduce evidence, and my lord, my right to adduce evidence, my lord, cannot be foreclosed like this. Is my submission.
No, this is it is before the commercial court. There is no dispute that.
They have filed statement of truth.
It comes to commercial court only in 2023.
Then they have filed their WS.
No, after 2023.
They filed
Say that it is filed in 2023.
And the statement of truth
what
is
is
at
the
page.
time limits which is given under the commercial court court management this thing proceedings?
And the statement
Now
of
you
truth
want
has
to
been
reopening everything. You want to produce the documents and all. Is it permissible?
My lord, what I am submitting is this, my lord. This suit is from 2013 to 2023. It was languishing. There was no urgency. Nothing was happening. Now in 2000.
When you have filed a written statement. When you have filed a written statement.
My lord, before that itself. I have filed my written statement.
Kindly come to page 86.
When you have filed?
4/7/2014, the WS was filed, my lord. This was 4/7/2014.
14. It was earlier in the civil court or
Yes, my lord. And then it was not taken on record. Then the this honorable court directed the WS to be taken on record. In the WS, they filed the statement of truth, which is required under the Commercial Courts of Act. Now that is at page 89.
Now when that they have filed under Commercial Court Act WS?
That is at 4/7/2014.
4/7/2014.
Yes.
No, that time commercial court is not established.
Nil, sorry, my lord, it was taken as nil.
How?
Subsequently, my apologies.
When that, Mr. If it is before, it is coming to
5/8/2024, my lord, in the list of dates.
5/8/2024. He has filed
W. This is pursuant to the order of this honorable court on 1/7/2024, where they were allowed to file the WS and it was taken on cost of 25,000.
What is that next date of events?
Then thereafter, my lord, I have adduced my evidence before the.
I want that particular dates.
It's in the statement of list of dates, my lord, at page 3.
Page
3.
Lord, my written statement is at Annexure C, page 49, my lord. It was filed on 6/10/2023.
23. No, you just point out in that your synopsis, date of events.
Yes.
Commercial court written statement record completion of orders.
5/8/2024, Commercial Court took the written statement on record, my lord.
No, you point out the date, Mr.
5/8/2024, my lord.
5/8/2024.
That was the date it was taken on record.
Commercial court took that written statement on records compliance with that order of that passed by this court. Yes.
Yes. Then issues were framed, my lord. Case management hearing happened. My evidence was taken before the court.
You point out the date. Yes, don't tell that this is all the procedure. I want to know
then on 6/12/2024, issues were framed. 10/1/2025, I filed my evidence affidavit. 21/2025, further evidence of PW1 was recorded. Then cross-examination was conducted on 6/2/2005, 1/3/2005, 24/4/2005, 29/7/2005, 11/9/2005, and then the report of the commissioner was submitted on 16/9/2005. Now on 27/9/2005, my lord, was the date on which they were supposed to commence the different evidence, my lord. On the 3 occasions,
they did not adduce any evidence. I will admit to the fact, my lord, one date there was an out of conversation of settlement.
Give that commercial court acts for production of additional documents. What is that limitation?
Lord, I'm just saying, Lord, your lordships may kindly leave that open, my lord. If in case I am permitted, I will file. Otherwise, I won't file. Actually, I am a defendant, my lord. I have to only refute the claim of the plaintiff. I may not have to produce any document because the burden of
documents which is available at the time of written statement has to be produced. It cannot be permitted later. No, that is true. See, it will be delayed that process. You will file an application. Court will definitely reject it. Then it will come before this court. It's all again
no, my lord,
giving an one opportunity. It should not be dragged that matter. That is what that because.
I'm saying, my lord, please see, my lord, if I have dragged it, my lord, kindly consider this, my lord. It was in November of 2025 that after the commissioner was appointed that the report comes. After that, one date of hearing it comes, then both parties submitted that we are trying to talk to out of court settlement. Then next day, following day, because the talk was going on, the court said,
then when is that? No, what is the date for settlement?
The settlement discussion was 27/9. There's a report. The order sheet is produced.
Settlement tax, yes, 27/9.
Yes.
To 6/11/2024. Commercial court declined to grant the time close that evidence of defendant.
That is their contention. However, the
Court
fact
commissioner
is,
report was taken by the commercial court. Cross-examination PW1 adduced fully. Now, after that cross-examination of PW1, is before starting evidence that commissioner report has been obtained.
Please.
Then that matter has been urgent for the settlement.
Yes, my lord.
That's what that is their contention, my lord. However, settlement in the per se, my lord, did not stop them from reading evidence.
No, it is not that all these date matter has been urgent for the evidence of the defendant.
It was, my lord. Kindly have a look at the order.
That order sheet.
My lord, order sheet has been produced by them, my lord, at annexure L.
After that 16/9/2025, show me what has happened. Annexure.
The lordships may turn to page 174, my lord. 174 is the typed copy of the order sheet.
Yes.
The first date, my lord, on top is plaintiff's closed. Counsel for defendant's pays for 9. Defendant's evidence for 27/9. Then counsel
defendant evidence by yes.
Then counsel for time adjourned to 18/10. Both counsel are present, defendant absent. Counsel for defendant pays time 500 rupees costs. Then next day 175. Cost paid, defendant absent, counsel for defendant pays time, defendant evidence has last chance.
No, there is no any reference that settlement.
That's exactly.
It was there, my lord.
Nor is see all this date you have taken a time.
No, that's what I'm saying, Lord. My submission is that in this interregnum, Lord, there was a settlement talk that was going on.
But your friend is denying that there is no such talks.
My lord, there was one talk, not from the time of their saying that so many dates happened.
No,
that was.
Which is
kindly come to my objections, my lord. In my objections, I have stated the whole situation.
Where is that?
It's at page 119, my lord, of my objections.
Where is that objection?
At 119 of the petition.
119.
19.
Yes.
Para 6.
Yes. Yes.
Sorry, man. Page 118, para 4.
Yes.
It is. While it is true that defendants had requested for a discussion and pursuant thereto, a personal meeting was held on 28/10/2025 between the petitioner representative and the defendant representatives. However, the defendants failed to make any fruitful offer for there to even be any settlement discussion with the plaintiff. As such, it is vehemently denied that there were any settlement discussions. It is now projected for so many hearings, settlement talks were there. Be that as it may, it was a without prejudice.
No, I'm not saying for so many days settlement was on. I'm only pointing out, it is a fact that parties did attempt to make a discussion. That
means to say, what is represented on 28/10/2025.
That's the only date we met.
Yes. After that, only 6/11/2025.
Please.
Time to close that on 11/11/25. It is closed. That
now come to para 6 of my objections, my lord. I'll read that out. Further, it must be noted
when
that
the evidence of the
that will negate, my lord. It is called.
See, according to you only, your objection on 28. Where is that paragraph?
Para number 4, my lord, 118. On 28
Pointed out that parties has
28/10/2020.
28/10/25.
Yes, my lord.
28/10/25.
Now that was the day pursuant to the date on which the evidence was listed, my lord.
No.
27, kindly come, that's why, my lord, kindly come to.
27/9.
Please.
But 18 till 28/10/2025.
Please.
On that day, there was a negotiation.
My lord, the meeting happened on 28. They were said, this is a settlement talk, we want to meet. We said, okay, fine, you let us know when.
Yes.
Now, earlier to that, there were dates on which they had to reduce
Earlier
evidence.
only one date, Mr.
Please,
27/9.
please.
28/10. there was a-
18/10 was another date, my lord. So two hearing dates were there.
No,
Then
that-
the
in
date
the
of meeting
meantime,
happened.
28/10, there was a
My lord,
question for that. That
Correct,
means to
ma'am.
say they have one impression that matter may be settled.
it was their proposal, my lord. So that doesn't stop them.
See, 28/10. After that, hardly another 15 days, is evidence has been closed.
Please. It was closed, my lord. Kindly come to para 6, my lord. That's what I'm trying to explain. My lord. It must be noted that the caption matter was posted on 27/9/2025, my lord.
Yes.
For different days. Thereafter, the matter was posted on several occasions, including 18/10, 16/10, my lord. Now, 18/10 is one date on before which we met. Then 28/10, as per para 4, my lord, we met. Thereafter, there was no communications. In fact, no.
We'll ask him to examine on the next date of hearing.
Very well, man. My whole contention is, man, if they open the stage of filing documents, my lord,
To
then
object it because it cannot be, if the document which is available at the time of written statement, if it is not filed, that is not permissible under that.
please, my lord. My only contention is that it should not be entertained from the fact of
No,
delaying further.
You take that contention and
Please,
we
very well.
will only permit it to now that for adducing that evidence.
Please.
On next date of hearing, Mr.
Yes,
My
We'll
only,
dispose. Yes.
my only request, my lord, there may be a timeline for disposal of the suit, my lord.
Will
because-
also that, now that both the parties has to cooperate, now you can say that dispose of within 6 months from the date.
3 months because of definite evidence.
Yes.
Now, one
No,
thing
now
whether-
that will say 4 months.
Please, very well, my lord.
Dali. In this writ petition, petitioner called in question, order dated 2/4/2026, passed by 82nd Additional City Civil Judge, Bangalore, in OS number 9055 of 2018, on IA number 9 and 10, whereby application has been rejected. Plaintiff has filed a suit for. What is the suit for?
Recovery of money.
Suit
Money.
for recovery of money. On appearance, defendant has filed written statement. The matter was filed in the regular court in view of the establishment of the commercial court under the Commercial Court Act. The matter has been transferred to commercial court. When it is transferred, Mr. 2023.
23.
2023.
23rd February 23.
Yes. Thereafter, the defendant has filed a written statement in the year 2024.
5/8/2020.
5/8/2024. On the basis of the pleadings of the parties, the trial court is also framed that issue on 6/12/2024. Thereafter, plaintiff has examined his witnesses. Evidence of the plaintiff has been closed. On 27/9/2025, matter was posted for evidence of defendant. Defendant, on request of the defendant, it has been urgent to 18/10/2025 and 16/11/2025. On 11/11/2025, evidence of the defendant has been closed. Thereafter, defendant has filed this application for reopening stage of the defendant evidence and permitted the defendant to adduce that evidence. That application as dismissed, being agreed by the same, the petitioner is, the defendant is before this court. No doubt, this court, the commercial court has given a sufficient opportunity to the defendant to adduce that evidence. The defendant has not adduced that evidence. Learned counsel for the senior counsel appearing for the petitioner defendant has contended that petitioner was under the impression that matter may be settled between the parties. Therefore, they have not adduced that evidence. Since matter was not settled, they are seeking for giving an opportunity to adduce that evidence. Be that as it may, in the interest of justice, to give one more opportunity, the writ petition is allowed. Writ petition may be allowed with certain conditions. Writ petition, accordingly, writ petition is allowed. Order dated so and so is set aside. IA 9 and 10 filed by the defendant is allowed, permitted to reopen and examine that defendant witnesses on the date fixed by this court.
27/4.
The defendant has to examine that witnesses on the next date of hearing on 27th without seeking any further adjournment.
27th, my lord, this month.
Yes, 27th.
Just immediately after vacation, my lord. Because
No, you do it. No, I have to fix the date after vacation. It has to be closed.
No, you're also being 4 months time, my lord, for closure.
Yes.
I'm only requesting that it had immediately on the reopening day or one day after that.
27th, we can request for another 2 days on 29th or 30th, but it has to be closed before this.
Tell your lordship what the problem is. This is a dispute of the year 2013. All my employees who are there are no longer working with me. So I have to now not reconstruct something and get somebody.
No,
to...
you know that you are witness, mister. Now that
This is doctrine of indoor management.
Yes.
And 27th would be too short a date.
27th.
This is the date fixed by the trial court.
Yes.
So they're
On
very well.
27th.
Trial court
on
is
that day,
fixed.
it is not concluded. Wait, on that day it is not concluded. The next day, which is fixed by the trial court, he has to be complete that evidence. And also, trial court is directed to dispose of this suit as expeditiously as possible, not later than end of August. Yes. Office objection is over. Yes. Yes.
Pleasure.
Serial number 65, Samir Sharma for petitioner.
Yes.
Matter arises from probate proceedings before the trial.
Post before the court of an order. Court fee has been paid.
Court fee has been paid. I paid it yesterday.
How much you have paid?
100 rupees. Because
No,
one petitioner.
No, there are 3 IAs you are challenging.
No, I am not challenging any IAs. In fact, if you lordships were to please see, here is a case wherein I had filed 2 separate interlocutory
Directing
applications.
this court districts.
One
to
at which,
pass an order on accordance with the disposing of the interlocutory application.
yes, although it is filed for expeditious disposal at the hands of your lordships, may I be permitted to make a couple of submissions. The probate petition relevant portion your lordships were to find, the prayer in the probate petition is at page 34. Seeking issuance of a probate certificate in respect of the properties.
Yes.
Now, I took out paper publication, nobody contested the matter, the respondent is that is why nil. Then when the matter came at the stage of evidence, the petitioner is a 71-year-old residing in US.
Yes.
She is a green card holder there. She cannot come because of this entire war and all of these diplomatic difficulties. As a result of which at page 35, I file an application seeking permission to lead evidence through VC. Now, this application, I have averred necessary, I've made necessary averments to state as to why I cannot come. Please permit me to lead evidence through VC. Then subsequently, at page 40, I file another application during the pendency of the previous application, directing appointment of a court commissioner to conduct evidence through VC. Now, why this happened was, if your lordships were to come to the order sheet for a moment, at page 23 is the relevant portion. On 13/6/2025, I filed the first application. I make submissions before the learned trial court as to how this is permissible. In fact, this honorable court on the administrative side has come out with VC guidelines, VC video conferencing rules. I placed that for the trial court's kind consideration. That I have produced before your lordships as well at page 59. Now, I press that into service to say that I'm permitted to lead evidence through VC. There's no difficulty. The learned trial court, if your lordships were to please see at page 23, 13/6/25, case called out, counsel for petitioner has preferred an application under so and so to hear colon. Please turn overleaf to page 24. 24/18/6/2025, again case called out to hear application colon. Then again 28/7/25, counsel for petitioner present submit, she will keep present the petitioner and examine. Hence the application is left open for hearing, no difficulty. Then on 15/10/2025, lordships were to please turn overleaf. Again, I make submissions and then for further arguments, I take time. Now, if your lordships were to now see at 26/11/2025, again case called, again petitioner counsel present and has furnished memo with authorities to hear on application. And if your lordships were to now come to page 26, then on 28/11/2025, I filed the second application which I adverted to earlier. Then at page 26, again, I make submissions, trial court is not passing orders. Now my grievance is, I'll have to be candid, I'm making a very responsible submission before lordships. The trial court is of the view that they do not have enough adequate facilities to conduct PC, which is why that prompted me to file a second application to say, please appoint court commissioner. The trial court, despite that, is not passing orders on this. Now, if your lordships were to please come for a moment to page 120, there is a judgment of a coordinate bench of this court.
I will direct it to dispose of. You place
I
the
understand.
judgment before that.
No, I've already placed. Now, what my difficulty, I'll explain to your lordships. Please come to page 120. This is a judgment of a coordinate bench of this court, which has relaxed conditions under the High Court, the VC rules of this honorable court. Now, if your lordships were to please come to the relevant portion at page 128.
Yes, Mr. You go and.
Nan one thing advert madbeku, just at page 128, this relaxation, the coordinate bench of this court says, trial court has no power to relax this condition. It is only this honorable court which has the power. Now, please see 128 at para 12.
Yes.
In this backdrop, the contention advanced on behalf of the respondent number 2 husband that the petitioner ought to have approached the learned magistrate for seeking relaxation of rule so and so cannot be accepted. The power to relax the operation of rule so and so is not conferred on the trial court, but is specifically vested in the High Court under Rule 18. Consequently, the objection that the petitioner has prematurely invoked the jurisdiction of this court without first moving the trial court is misconceived and untenable. It is therefore within the domain of the court to consider whether the facts of the present case warrant exercise of the power of relaxation under Rule 18 so as to enable the petitioner / complainant to record her evidence through VC without being constrained by the strict mandate. So whereas obviously your lordships can dispose of this petition by directing expeditious disposal, another additional relief I'm seeking at the hands of your lordships is this particular rule may be relaxed. Let the trial court decide on the applications, but the trial court has no power to relax this. That is what a coordinate bench has held in this case.
No, that what is that prayer you are sought
Now,
here?
with regard to that, my only respectful submission is, I understand I have sought for expeditious disposal. If a lordship permits.
If they reject it, then you come before me. We will relax and state that.
Our relaxed madak power illa aurge is what this court has said, which is why
Then pass an order on that. Then we will modify it and say that you do it. We'll see that whether this circumstances is required for that. All the trial court has to give a finding.
Can I just make one suggestion, which will, because if that were to happen, I'll have to come back again before this honorable court.
Yes.
If I'm given permission, liberty today itself to add that particular prayer in the prayer column in this writ petition, I will also seek an issuance of direction at the hands of your lordships that Rule 18 may be relaxed and let the IS be considered. That is all I'm asking. There is no contest on the other side, because Ilandre, I'll have to go back.
Whatever you want, then we'll see.
If your lordships could then have this matter day after, because permit me to kindly amend the prayer, because Advan tappogittu.
You do it whatever you want, Mr. Then we'll see that. Yes.
In that case, could a lordships have it day after?
Leave this matter on 28th. Yes.
In fresh matter, in preliminary hearing.
Yes, it will come. Yes.
Please, great.
Cell number 66 of Basavanna KM.
The
respondents number 2 and 3 are not parties in the execution petition, my lords. They are the legal heirs of judgment dated 2, my lords.
Yes.
Judgment dated 2 died during the pendency of the petition, my lords.
Yes.
In fact, despite the application was filed, my lord, the amended petition has not been filed. The decree holder has not filed the amended petition, my lords.
Pin ಹಾಕ್ತಾರೆ. So open it. Yes.
It's page 34, my lords.
Yes. Madam, but yes.
In page number 34, my lords.
Yes.
Annexure C, the judgment dated, my lords. One Bhavani, the petitioner in, and H.S. Jayashankara.
Now, what is that decree?
My lord, decree is, my lords, it's the matter arises of pre-litigation conciliation, my lords.
Yes.
Kindly page 21, my lords.
Yes.
The respondent number 1 files an application before the District Legal Services Authority seeking recovery of an amount of rupees 25 lakhs.
Yes.
My lords, after service of the notice, my lords, the petitioner appeared before the conciliation committee and agreed for a full and final settlement for 20 lakhs rupees on the set date on, my lords.
Yes.
That should be paid within 4 months from the date of the settlement.
Where is that order?
Please, my lords. Kindly come to page 30, my lords, annexure B.
30.
Please, my lords. Annexure 30, page 30 is the compromise petition.
Yes.
My lords, if my lords come to page, this one, my lord, ಅರ್ಜಿದಾರ ಎದುರುದಾರರಿಂದ ರೂಪಾಯಿ 25 ಲಕ್ಷಗಳನ್ನು ವ್ಯಾಜ್ಯಪೂರ್ವ ಪ್ರಕರಣದಲ್ಲಿ ಇತ್ಯರ್ಥಪಡಿಸಬೇಕೆಂದು ಜಿಲ್ಲಾ ಕಾನೂನು ಸೇವೆಗಳ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅರ್ಜಿ ನೀಡಿದ್ದು, ಉಭಯ ಪಕ್ಷಗಾರರು ಕರೆಸಿ ಮಾತನಾಡಿ ರಾಜಿ ಸಂಧಾನ ಮಾಡಿದಾಗ ಎದುರುದಾರರು ಅಂತಿಮ ಮತ್ತು ಪೂರ್ಣ ರಾಜಿಯಂತೆ 20 ಲಕ್ಷ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. ಎದುರುದಾರರು ಅರ್ಜಿದಾರರಿಗೆ ಇಂದಿನಿಂದ 4 ತಿಂಗಳ ಒಳಗಾಗಿ ರೂಪಾಯಿ 20 ಲಕ್ಷ ನೀಡಲು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಎದುರುದಾರರು ಮೊದಲನೇ ತಿಂಗಳು 3 ಲಕ್ಷಗಳನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. 4 ಎದುರುದಾರರ ನಂತರ now I have paid 20 lakhs rupees, my lords. The only issue is, my lord, the quantum of interest. My lords,
the interest
page, if my lords come to point number 6, my lords. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎದುರುದಾರರು 4 ತಿಂಗಳ ಒಳಗಾಗಿ ಪೂರ್ತಿ ಹಣ ಪಾವತಿ ಮಾಡಲು ತಪ್ಪಿದ್ದಲ್ಲಿ 2% ಬಡ್ಡಿ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಪ್ರತಿ ತಿಂಗಳಿಗೆ 2% ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ನೀವು 4 months ಅಲ್ಲಿ 20% ಕಟ್ಟಿದಿರಾ ನೀವು?
20 lakhs ಇಲ್ಲ. Initially within 4 months 13 lakhs I paid 13 lakhs, my lords.
In 10 lakhs remains.
10 lakhs ಇಲ್ಲ in 7 lakhs remains, my lords, out of
13 lakhs ಕಟ್ಟಿದ್ರೆ in 7
Please, my
lakhs. 7 lakhs what is the interest? 2% ಆದ್ರೆ
2% per annum ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಅವ್ರು ಹೇಳ್ತಾರೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ 2% ಅಂತ ಹೇಳ್ತಾರೆ.
4 ತಿಂಗಳೊಳಗೆ ಪೂರ್ತಿ ಹಣ ಪಾವತಿ ಮಾಡಲು ತಪ್ಪಿದ್ದಲ್ಲಿ 2% ಬಡ್ಡಿ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. ಏನಂತ ಹೇಳಿಲ್ಲ ನೀವು
ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಏನ್ ಮಾಡಿದ್ರೆ ಮೈ ಕಂಟೆನ್ಸ್, my lords, ತಿಂಗಳಿಗೆ ಅಂತ ಅವ್ರು ಸೇರಿಸಿದ್ದಾರೆ ಅಂತ ಮೇಲೆ I am disputing that portion. My lords, if my lords kindly next page B1 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ
no, that amount has to be paid monthly, therefore it's monthly you have to pay 2%, mister. Who will give annual 2%?
ಅಲ್ಲ, ಈಗ B1 ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ, my lords, that is the award, my lords. B1 ಅಲ್ಲಿ
award alla hoytri, settlement is different. Elli the award ide?
Next page B32, my lords. B1. If my lords kindly come to page 32 is the document, 33 is that point number 6, my lords. ಎದುರುದಾರರು 4 ತಿಂಗಳ ಒಳಗಾಗಿ ಪೂರ್ತಿ ಹಣ ಪಾವತಿ ಮಾಡಲು ತಪ್ಪಿದ್ದಲ್ಲಿ 2% ಬಡ್ಡಿ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. There is no mention either it's annum or per month.
No, who will that, mister? ಯಾರು ದುಡ್ಡೇ ಕಟ್ಟಲ್ರಿ ನೀವು?
In fact, my lords,
2 ವರ್ಷಕ್ಕೆ 2% ಆದ್ರೆ ನೀವು ಆ 7 ಲಕ್ಷ ಯಾವನಿಗಾರ ಕೊಟ್ರೆ 8% ಕೊಡ್ತಾನೆ. ಸುಮ್ಮನೆ 2 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಕೊಂಡು
ಇದರಲ್ಲಿ
that is not the logic.
ಇದರಲ್ಲಿ ಇದರಲ್ಲಿ it's a housewife, my lords. It's a transaction. ನನ್ನ ಪ್ರಕಾರದಲ್ಲಿ only 10 lakhs was paid. Despite this, my lords, we paid 20 lakhs.
No, that is not that. Now you, according to you, that 7 lakhs is pending.
Please, ಇಲ್ಲ ಅದು pay ಆಗಿದೆ. If my lords kindly come to page in page number 10, my lords, paragraph 14 of my petition. As on today, during the pendency of the execution petition, my lords, I paid the entire thing.
ಎಲ್ಲಿದೆ? Where is that? Where
page
is
10, my lords, paragraph 14. ಅಲ್ಲೊಂದು tabular column ಹಾಕಿದ್ದೀನಿ ಸಮೇತ.
Yes.
If my lords kindly, my lords, as on the date of settlement 18 on the paragraph 14.
ಏನ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
My lords, ಎಲ್ಲ ಕೊಟ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಮೆನ್ಷನ್ ಆಗಿದೆ. In the order sheet, in the execution code, my lord, the order sheet, everything is mentioned.
Then why that execution then?
Alla, adenaitu, my lords. Within 4 months, my lords, I paid 13 lakhs. After that, my lords, COVID came, my lords, I could not able to file it. In the year 2020, my lord, they filed the execution petition. The respondent number filed the execution petition.
ನೀವು ಎಷ್ಟನೇ ಯಾವ ವರ್ಷದೊಳಗೆ ಕೊಡ್ಬೇಕಿತ್ತು?
My lords, ಅಲ್ಲೇ 2019 ಅಲ್ಲೇ ಕೊಡಬೇಕಾಗಿತ್ತು.
ಈ 2019 ಇದು.
Please, my lords.
2019 ಅಲ್ಲೇ.
Please, my lords. 2020 they filed an execution petition.
7 lakhs, 3 lakhs, 1,50,000.
Up to 2025 ಎಲ್ಲ ಹೋಗಿ 20 ಲಕ್ಷ 20,000 ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆಯ್ತು, ನೀವು ರಿಮೈನಿಂಗ್ ಗೆ ಕೊಡ್ತಾ ಬಂದಿದ್ದೀರಲ್ಲ,
ಎಲ್ಲ ಬಂದಿದೆ.
ಅದಕ್ಕೆ ಇಂಟ್ರೆಸ್ಟ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ ಆಮೇಲೆ?
ಅದ್ರ ಮೇಲೆ my lords, my contention, my lords, if it is calculated 2% per month per annum ಅಂತ ಮಾಡಿದ್ರೆ 72,000 ಅಷ್ಟೇ ಇನ್ನು ಉಳಿಕೆ ಬಂದಿರೋ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಈಗ ಏನಾಗುತ್ತೆ ಅಂತ ಅಂದ್ರೆ, ನೀವು ಫಸ್ಟ್ 2019 ಅಲ್ಲಿ 7 ಲಕ್ಷಕ್ಕೆ ನೀವು ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ಬೇಕು. 7 ಲಕ್ಷನ 21 ವರೆಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕು. 21 ಅಲ್ಲಿ 3 ಲಕ್ಷ ಕಟ್ತೀರಾ, ಮತ್ತೆ 5 ಲಕ್ಷಕ್ಕೆ ಹಾಕ್ತಾರ ಇಂಟ್ರೆಸ್ಟ್ ಕಟ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
ಆ ರೀತಿ ಅದೇ ಗೊತ್ತಾಯ್ತು. But my lords, my contention, my lords, I have disputed the signature and insertion portion, my lords, I disputed.
What insertion portion?
ಅಲ್ಲೇ ಇದರಲ್ಲಿ ಇದರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರ್ಬಿಟ್ಟು ಸೈನ್ ಹಾಕಿರೋದು. I am disputing it is not my signature ಅಂತ.
Then why you have paid that amount, mister, if it is not?
ಅಲ್ಲಲ್ಲ, after filing the execution, my lords, I came to know about that, my lords.
What is that insertion?
ಕೈಯಲ್ಲಿ paragraph point number 6 ಅಲ್ಲಿ ಇತ್ತಾವ, my lords. If my lords come to page 30, my lords. Point number 6 ಅಲ್ಲಿ ಅಲ್ಲಿ ತಪ್ಪಿದಲ್ಲಿ 2% ಬಡ್ಡಿ ನೀಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ ಅನ್ನೋದಕ್ಕೆ.
It's a court order, mister. You can get it that order from that.
ಅದಕ್ಕೆ my lords, I filed an application seeking expert opinion for appointment of a commissioner, my lords, under order 26 rule 10A.
No, you go and apply original certificate copy.
ಅಲ್ಲಿ ಮಾಡಿದೀವಿ. ಈಗ ಅದನ್ನ they are not given an opportunity, my lords. That order is being challenged before my lords now.
Where?
Kind ಇಲ್ಲಿ page, if my lords come to page 166, my lords. N2, annexure N2. I filed an application because previous to this, my lords.
Now, what is that order you are challenging here?
Page my application for appointment of the expert is been rejected. Page 166. ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ರೆ it's a local ಲೋಕ್ ಅದಾಲತ್ order can't be challenged ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
ಹೌದ್ರಿ, ನಿಮಗೆ ಎಕ್ಸ್ಪರ್ಟ್ ಒಪಿನಿಯನ್ ಅಲ್ಲ, ಲೋಕ್ ಅದಾಲತ್ ಕಾಪಿ ನೀವು ಅಬ್ಟೈನ್ ಮಾಡಿ ನೋಡ್ರಿ. Is it insertion?
ಅದಕ್ಕೆ ಅಲ್ಲ, ನನ್ಗೆ I am not provided an opportunity, my lords. ಅಲ್ಲಿ ಒರಿಜಿನಲ್ the court has to call for the originals, my lords. Everything is before the court, executing court. They themselves has to look into the document. Not ಈಗ ಏನಾಗಿದೆ 21 section, in terms of section 21 of the Lok Adalat order, my lord, act, it's not permissible to reopen the matter. It's the findings of the trial court.
Reopen ಸರಿ ರೀ, ಅಲ್ಲಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ is it the insertion or it is there ಗೊತ್ತಾಗಲ್ಲ.
ಅದಕ್ಕೆ I am seeking for an appointment of the expert, my lords.
ನೀ ಯಾಕ್ರಿ ಕೋರ್ಟ್ ನೋಡಕ್ ಆಗಲ್ಲೇನ್ರಿ?
ಅದನ್ನ ನೋಡಿ ಅದನ್ನ ಅದು ಮಾಡಿಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, my lords. It's not been done by the trial court, executing court.
As it court said that it cannot be looked into that records.
ಅದನ್ನೇ ಹೇಳಿರೋದು ಸ್ವಾಮಿ ಇಲ್ಲಿ. ತಾವು if my lords kindly look into the impugned order.
No, I will secure that record tomorrow itself. I will see that whether this is an insertion or. Please. Then you will dismiss it. How can that Lok Adalat records can be tampered, Mr.? Yes, office is directed to secure. Where is that order?
My lords, page 166, my lords.
Original records. From the trial court in respect of
PLC number 3364 of
page 1.
PLC number 166, my lords. 166.
166.
ಅಲ್ಲ ಇದನ್ನ ಇದ್ರದ lords. ಅದು ಲೋಕ್ ಅದಾಲತ್ ಆರ್ಡರ್ ನ ಕೇಳಿದತ್ತ.
ಲೋಕ್ ಅದಾಲತ್ ಆರ್ಡರ್ ನ ತರಿಸಿ
annexure A and A1, annexure B and B1, my lords.
Annexure
B and B1.
Yes. Are directed to secure that Lok Adalat award passed in PLC number 3364 of 2018 by Lok Adalat held by the District Legal Service Authority at Mysore, dated 8th December 2018, forthwith by telecommunication. Leave this matter on 27th. ಅವ್ರಿಗೆ ಹೇಳ್ರಿ.
ಅಲ್ಲಿವರೆಗೆ let the matter is coming up day after tomorrow.
ಏನಕ್ಕೆ ಬರ್ತಾ ಇದೆ?
ಯಾಕಂದ್ರೆ to take steps for attachment ಬರ್ತಾ ಇದೆ.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ನಿಮ್ಗೇನ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಪ್ರೊಕ್ಲಮೇಶನ್ ಬಂದ್ರೆ, ವಾರಂಟ್ ಪ್ರೊಕ್ಲಮೇಶನ್ ಬಂದ್ರೆ ಬನ್ನಿ ಅಷ್ಟೊಳಗಡೆ. Yes, we'll get that records and see.
Much obliged.
Yes.
Office objection, second time matter, serial number 67, Rangaram Muggi.
Appear for the petition. Only start, by mistake, my lord, the date of the order was not mentioned in the prayer.
Writ petition is filed challenging more than that 2 AS ado.
Regarding all those things as complied, my lord, I paid the court fee for all the
Court fee paid.
Court fee is paid.
Petitioner 3 to 10 in the writ petitions are not a party. Index to be filled soon.
Only regarding date of the order is
Court fee
not mentioned, my lord. I mean, permitted.
ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಾ court fee?
300.
ಎಲ್ಲಿದೆ? Acknowledgement. Here it is not produced.
And 100 is produced, subsequently I paid to 200, my lord.
There is, the acknowledgement is there.
Yes, sir. What is? It is also intimated to the scrutiny, scrutiny.
Acknowledgement ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು, ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, ಅಲ್ಲಿ intimation ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes.
Intimation ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes, what is this matter?
The suit is filed by the respondent is for a suit for partition. The petitioner father has purchased the property in the 2005, my lord. At page number 28. The original owner, the land was granted by the land tribunal in favor of Javraguda.
Suit for partition.
Suit for partition filed by the children, the daughter-in-laws.
You are not party, why you have made as a party here?
Because they are the children of the Mukhtar Ahmad Beg. They have made only certain parties and I have made all the necessary parties here. They have brought only 2 or 3 persons. I made all the necessary parties of the children of Mukhtar Ahmad.
Why?
Mukhtar Ahmad is the person who has purchased the property. Your lordship kindly, page number 28.
What is the suit for?
Suit for partition. At page number 21. Arati, whom so and so Mallikarjunaya. Mallikarjunaya is son of none of that.
ನೀವು ಯಾರು? Who are you?
I am the purchaser of the property from the original owner.
From whom you have purchased?
Javraya, page number 28, my lord. Annexure E, page number 28. This land was granted by the land tribunal in favor of Javraya. Javraya sold the property in the 2005. Registered sale deed is there. I am in possession of the property. I am cultivating it. The suit is filed in the year 2020, my lord, after lapse of 15 years.
When you have purchased?
2005, my lord.
2005.
23/6/2005.
Yes, now they have filed in a suit for partition.
Suit for partition in the year 2020 after lapse of 15 years.
I see.
All the children have also signed the registered sale deed except
ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀರಾ ಈಗ?
they have brought the LRs of the Mukhtar Ahmad.
No, you are party in that suit for partition.
No, I am party in the suit for partition because they came to know that I was dead. No, no more. Then they brought some of the LRs on record. So the IAS.
What is your name, mister? Who you are a defendant number?
In the suit, my lord, defendant number 5.
No, you are the defendant number 5.
Defendant number 5, page
So
number
that
21.
Mukhtar Ahmad Begum is dead, that LRs has filing in a petition.
Wait, please, my lord. They already brought some of the person and
ನೀವು LRs ಹಾಕಿದ್ರೆ ಸರಿ ಬಿಡಿ.
ಹಾಕಿದ್ದೀವಿ. The LR application
ಏನ್ ಕೇಸ್ ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Allowed by the trial court, my lord.
What is that
LR
order?
application at page number 18. Common order at page number 18, my lord.
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
Common orders and all the 3 IAs, my lord.
IA filed by that plaintiff to bring LRs of the defendant number 580.
Order 22, rule 4, 29, so on so.
Side in the abatement. Application allow ಮಾಡಿ LRs ತಂದಿದ್ದಾರೆ, ಏನೀಗ ಅದರಲ್ಲಿ?
Allah, I am not a necessary party because suit for partition, I am not a joint family members or and also they have not filed any application to cancel the sale deed.
No, that.
The sale deed is there, my lord, registered sale deed.
No, your father is party, therefore they have bring an LRs on death of your father.
I am not a necessary parties because of the reason it's not for partition, I am not a family members. Suit for partition is only for family members and also they have not seek for cancellation of the registered sale deed dated 2005.
Heard. Issue notice. Stay of order dated What is the date of that order, Mr.? 13/8/2025.
31/2015, my lord.
Passed in OS number 390 of 2020 by Additional Civil Judge JMFC Srirangpatna till next date of hearing. Submission is accepted, objection is voted.
Cell number
It's not
68.
for an order of handle, I'll file the application.
Yes.
Prajwal Raj HD.
The only reason that Harsha is not made as a
Just to be
party,
stated in the prior serial number 2 to 6 from that order sheet dated 3/6. Yes, what is this?
Harsha has not been made a party because, my lord, he's already died, my lord.
Yes,
And the LRs of, his LRs are already on record, my lords.
yes.
And which so far as to second objection is concerned, my lords,
What
no
is this
separate
matter?
orders. My lords.
ಆಯ್ತು ಏನ್ ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ.
Lords, I have filed a suit for declaration by way of adverse position upon item number 1 and for cancellation of sale deed with respect to item number 2 of the suit shall property, my lords.
Yes.
Subsequent to the filing of my suit, my lords, the defendant number 1 has filed a suit against me, some of the plaintiff in the initial suit, my lords, for a bare injunction, my lords. Initially, both the suits were tried on a 2 different court.
Yes.
Subsequently, as per the order of the PDJ, order dated 5/2/2024, my lords. Your lordship may kindly come to page number 69. This is a
Yes.
copy of order from the Honorable PDJ Court Hassan, and the same is enclosed here with
Your suit for,
adverse position, my lords.
now that what is that order you are challenging?
Challenging the order, I filed a clubbing application. After both the suit has been transferred to the same court, my lords, I filed a clubbing application, my lords.
Now, that your suit number is
My suit number is 448 of 2023, my lords.
448.
Yes, my lords.
The suit for?
Adverse position and cancellation of sale deed.
No, what is that another suit?
It's a bare injunction suit, my lords.
Who has filed that?
Defendant number 1, my lords. Upon the same property, my lords. Both are similar properties.
Your application for clubbing rejected.
The clubbing is rejected.
Where is that order?
At page number 26, my lords. The only reason they are quoting is that 2 parties from that suit is not party in the present suit. When it is a summary suit, the defendant's suit is a summary suit and mine is a much larger suit, my lords. And it is not necessary for them to make everybody as a party, my lords.
Yes.
And one more thing, my lords, here it is specifically stated in the order passed by the trial judge
Yes.
that
To notice stay of further proceedings in OS number 448 of 2023 and OS number 542 of 2023 pending in the file of third additional civil judge JMFC Hassan till next date of hearing.
much obliged.
Submission is accepted, objection is voted.
Cell number 69. G. Narayana Rao for petitioner. Lokesh Rao.
None appears. Is this matter of 2 weeks.
Cell number 70. Pramod R for petitioner. Janardhan G.
I have complied all the office objections, my lord. One more office objection raised. Only with regard to the principal judge and the first additional that correction only made, my lord.
Respondent ಕೇವೇಟರ್ ಕಾಫಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
The caveator, after filing the writ petition and after raising the objection, now they have filed the caveat petition. Now it has,
ಯಾವಾಗಲಾರು ಫೈಲ್ ಮಾಡಿ.
now it has been raised. Even they have not appeared, my lord. That's why.
Yes.
The question simple is that, my lord, an application has been filed by the plaintiff's writ petition. The application has been filed by the suit for specific performance, my lord. I have filed a suit for specific performance with respect to suit property. Wherein, my lord, when the matter is posted for the defendant evidence, the defendants have filed an application under section 18 rule 17 and read with section 151 of CPC for recall of PW1 and to give the stamp voice recording of the plaintiff in order to send the same to the FSL. These 3 prayers have been made out in the one thing, my lord. My humble submission that, my lord, the pen drive
allowed.
That is directed me to produce the same, my lord.
Issue notice stay of further proceedings in OS number 138 of 2020 pending in the file of principal senior civil.
Municipal, first additional, I'll make the correction, madam. First additional civil judge, senior civil judge, madam.
First additional senior civil judge CJ Mandia till next date of it. Madia correction sir.
I'll correct it.
Correction matter. Yes. Office objection is over.
Serial number 71. Yes, Victor Manoharan.
Let's common order is passed on 3 applications, my lords.
Court fee paid.
Paid, my lords.
How much?
300. My lords, suit was for bare injunction, my lords. The sole plaintiff dies, my lords, and the LR application is filed through the general power of attorney of a dead plaintiff, my lords. And those 3 applications have been allowed, my lords. Against that order, I have filed this writ petition, my lords.
What is wrong in
Order
that?
is no.
What is wrong in that?
No, sole plaintiff dies, my lords, and cause of action does not survive.
No, in the injunction suit, this court said LRs can be come on record. There is a judgment. Our Sanjay Gaud judgment. There is a judgment. Justice Sanjay Gaud said in.
No, my lords, I have also referred to one page number 16 of the order may kindly be seen because there, my lords,
no, application is allowed.
Applications are allowed. That too on a person, on a general power of attorney of a dead person, my lords. He has filed the application.
That is what that earlier, if that person who is claiming an injunction dead, there is no cause of action is continued. But I think there is a judgment.
No, my lords, even if cause of action survives, my
No,
lords,
antandre judgment aitandre no antandre henga. Judgment, have you seen that?
No,
There is a judgment, mister. I think adela ittallri Sanjay Gaud. What is that judgment? What is
this says it is not.
That is what that recent judgment says. Even LRs can continue. This is 2021, but here there is no any law has been but there is a judgment, mister. It's not.
But application at page number 40 may kindly be seen. On the basis of a general power of attorney of a dead person, my lords, these applications are filed. Page number 40, my
That's
lords.
what they said. It can be allowed. Let us see. Yes.
No, in the order, my lords, at page number 17, the objection raised regarding the general power of attorney also does not merit
OS number 346 of 2017, pending in the file of first additional civil judge JMFC Malwali till next date of hearing. We'll see.
Serial number 72. Divyatej HN for petitioner.
Stay of further proceedings.
Yes.
Parted matter, my lord, senior counsel is engaged, my lord. He's honestly before other.
Imparted.
Kindly have the matter day after tomorrow, my lord. I have informed the other side also.
Yes. We'll have it on 28th.
28th.
Yes. Leave this
My lord, office objection may be overruled, my lord.
Let us see. Yes.
My lord, office objection, last time your lordship heard, my lord.
What is that office objection?
My lord, I have not made the parties of in OS number 7256. They have not contested this IM.
All the parties in OS to be made as a party in that.
They have not that is connected matter, my lord. They have not contested this IM, my lord.
Rank of the parties of all OS number to be.
Please, my lord, that is pertaining to the connected matter, my lord.
The rank of the parties has to be stated.
I have stated in the petition, my lord.
Rank of the parties to be stated correctly.
I have stated correctly, my lord.
Copy to be served to the caveator.
I have served, my lord, already served.
Yes. Submission of learned counsel for petitioner is accepted. Office objection is overruled. Leave this matter on 29th. Yes.
In the preliminary hearing.
29th, Bharat, yes.
Third time office objection, serial number 73. Ramachandra.
29.
This one.
Yes. Office objection, yes.
Yes, your lordship. It's
All
only.
advocates, yes.
Yes, your lordship. The copy of the FDP was sought for. It is there. We will just file it, your lordship. Only that it may kindly be.
No, you file it in that office.
Yes,
I will
we
serve
will.
a copy to the caveator. Copies
It is
to the
one that-
caveator.
Caveators are the ones who have filed that FDP in the court below, your lordship.
No, madam, copy has been served to the caveator.
Caveator, we have already served. The main thing has been served, your lordship, not this FDP copy.
This petition has to be served, madam. Your camera is off.
My lord,
No,
in
I'm
this
trying
case,
to
my
switch it
lord,
on, your lordship. I'm trying to switch it on. I don't know.
When do you want? You serve a copy
day
to the curator.
The day after tomorrow, your lordship.
Yes, day after tomorrow. You comply office objection.
Much obliged.
Fourth time office objection, Manu Shankar SS, serial number 74.
Yes, none appears. Leave this matter after 2 weeks.
Serial number 75.
There are two IAS, the two court pay have paid. That's the only objection. Actually, a registrar has accepted that my submission, it should be listed for preliminary hearing.
You have paid court fee?
Yes, my lord.
Yes, ready?
Yes, my lord. Yes, my lord.
Yes.
Yes, my lord. Yes, my lord. There are the original plaintiff, my lord, has filed a suit for declaration and injunction, my lord. So the defendants here are the grandchildren of plaintiff, my lord.
Yes.
Original plaintiff has died. So,
suit for?
That's the declaration injunction that is filed by the original plaintiff Borama.
You are a plaintiff.
Here, my lord, what happened? The defendant number
If
two,
not party, anything.
defendant number 2 has filed application to come on record as the LR of original plaintiff because he is the grandson. And another, there is a will in favor of defendant number 2. Another IA is also filed to come on record as legatee of the will. So two orders are passed, same reasons are given. What the trial court said, separate suit can be filed, not in the same suit.
Where is that order?
Yes, my lord. That is not page number, the 66, my lord, the on one IA, my lord. Same reasons are given. The IA number 6, my lord, page 60, last, my lord. IA number 6 filed by the defendant number 2 under order 1 rule 10(2) of CPC.
For what?
That is, my lord, to come on record as a LR of the original plaintiff because he is the grandson, defendant number 2, to transpose him as a plaintiff. Rejected, one. And another IA, my lord, to come on record as legatee of the will, that is will in favor of defendant number 2.
Who has filed that?
The plaintiff, my lord. This defendant number 2, same defendant number 2.
You have filed an application?
There are two applications. One to transpose me as a plaintiff.
And then both application is rejected?
Rejected, saying that since the will is dated before the filing of the suit, not during the pendency of the suit, so separate suit can be filed. Therefore, on that ground, both applications are dismissed, my lord.
Yes, you take notice. Issue notice.
The office objection may be overruled.
Yes, submission is accepted. Office objection is overruled. Issue emergent notice.
Fifth time office objection, serial number 76, Ajit Shetty for petitioner.
There are two office objections.
APF for responding this matter, Manoj.
Kvita was not served, that has been complied, not have served a copy. The other Manoj is the interlocutory application. Manoj, they have asked me to mark that as a separate annexure. I have said that it is not needed.
No, not marking. Annexure to be attested by that competent
Manoj,
authority.
that has been done. That has now been done.
Yes.
Manoj, the only issue is this.
Yes.
Manoj, it's a suit for bare injunction.
Yes.
Now, defendant Manoj, who is the petitioner before your lordship,
Yes.
Manoj, he files an application not seeking appointment of a court commissioner. Manoj, with a prayer to identify this land. Reason being, Manoj, there is a decree in favor of the defendant in a previous suit. Manoj, restraining a gentleman named Rajesh from interfering with his possession.
Yes.
Now, the present suit is filed by the uncle of the said gentleman named Rajesh. The plaintiff's name is Ramchandraya.
No, that earlier suit is filed by the same plaintiff.
It's by the defendant, by the petitioner before your lordship.
You have filed a suit.
I have filed a suit, my lord, for bare injunction. That was decreed. Thereafter, my lords, it is
You have filed against whom?
My lords, I had filed against a person named Rajesh.
Rajesh.
Now, my lords, the plaintiff in the suit before your lordship is a person named Ramchandraya, who is his paternal uncle.
Of Rajesh.
Of Rajesh. But all that I am saying is that, my lords, the land which he says he has purchased has been purchased from my father. My lords, I am his vendor's vendor.
Yes.
All, my lords, there are 3 portions of sales. None of them, my lords, were identified by way of a revenue, my lords, survey.
Yes.
All that I requested, my lords, is that a survey be done so as to identify the property. My only, my lords, issue was that I had filed this application at the very threshold, soon after I filed the written statement. The learned, my lords, trial judge says, my lords, page 51, if my lords were to see, the learned trial judge says that it is premature.
Yes.
Page 50, if my lords were to see, paragraph 11. By considering the same, thus this court is of the opinion that right now the parties have completed the pleadings. Before commencement of trial, appointment of court commissioner does not deserve any purpose, does not serve any. That is the only reason cited. But I relied upon a judgment of a coordinate bench of this honorable court, where there is a ruling which says that when there is a dispute.
What is the stage now?
But now I have, yesterday, I have completed cross-examining the plaintiff. But all that I request is, let this application be restored. Let the trial.
We'll permit you to fresh application now.
Very well. That is good enough.
Yes.
That's all.
Because
I
we have received copy yesterday,
court-
my lords. We are having serious
No, I am dismissing
objections.
this, mister. As
Please.
per the observation of the court, let him file in a fresh application.
application.
That will be considered in accordance with law.
Please,
Yes.
my lords.
In this writ petition, petitioner called in question, order dated 19 July 2024, passed by Additional City Civil and Session Judge, Bangalore, on IA number 4, filed by the petitioner for appointment of the court commissioner has been rejected. Plaintiff has filed in a suit for bare injunction. On service of summons, defendant appear through counsel has filed an written statement and filed an application under order 26 rule 9 for appointment of the court commissioner. The same came to be dismissed that
On the ground that it is premature.
on the ground that it is premature since parties are not led their evidence.
Please.
The learned counsel appearing for the petitioner submitted that now that evidence of the parties has been concluded.
The plaintiff's evidence is concluded, not mine is yet to commence.
Yes, now that matter is been scheduled for evidence, plaintiff evidence is completed. The writ petition may be disposed of after conclusion of the defendant evidence. Liberty may be reserved to file an application for appointment of the commissioner. In view of the above, the writ petition is dismissed.
But let it be disposed of.
Yes, disposed of, reserving liberty to the petitioner to file an application after completion of the evidence of the parties to file an application under order 26 rule 9 of CPC. If such a application is filed, trial court is directed to consider the same in accordance with.
I'm so glad.
Yes. Submission accepted, office objection is.
77, Girish MK.
Office objection is only one, my lord, common order, my lord.
Court fee paid.
Court fee paid, my lord.
Yes.
In page 16 is the common order passed on IA number 78, my lord.
What is the suit for?
Execution proceedings are going on. In execution 28/2022 before senior civil judge and JMFC Kollegala, wherein the brother and mother of the petitioner
Yes.
have mortgaged a property, which is an ancestral property,
Yes.
to some third person who has taken a decree and now he has brought that property for sale.
Yes.
This plaintiff has filed suit OS number 42/2020 before the senior civil judge and CJM Mysore, seeking partition and separate possession, making her mother, two brothers, and those who have obtained mortgage. Now, my lords, after coming to know about these execution proceedings, petitioner filed applications before the execution proceedings, praying that not to proceed to, for sale of the item number 1 property, which is the subject matter of the suit, till the disposal of the partition suit, my lord. And also she sought for stay of sale proceedings and stay of execution proceedings, my lord. Now, my lord, kindly turn
Is
to.
it that property is attached?
Now attached, my lord, now attached.
Where is that order?
My lord, now already sale proceedings have commenced. Kindly, I have produced the order sheet, my lord. Typed copy is at page 46. Illi bidddaararu bid madidare already. Page 47, my lord. Page 47.
Yes.
ಇಲ್ಲಿ ಲಾಸ್ಟ್ಗೆ ಒಬ್ರು ಈ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಆಸ್ತಿ ಹರಾಜ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಇನ್ನ ಸೇಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
ಎಲ್ಲಿ 2025 ಏನ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ತಾನೆ, how can that? It should be completed within 30 days, Mr.
ಅಲ್ಲ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಮಾಡ್ತಾ ಇಲ್ಲ. ಬಿಕಾಸ್ ಆಫ್ ಸಮ್ ಟೆಕ್ನಿಕಲ್ ರೀಸನ್ಸ್, ಬಿಕಾಸ್ ಬಿಡ್ಡಿದಾರರು ಬರ್ತಾರೆ, ಈ ಸೂಟು ಇರೋದು ಮತ್ತೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಇಂದ ಅವ್ರು ಮುಂದೆ ಬರಲ್ಲ. ಸೊ ಇಟ್ಸ್ ಹ್ಯಾಪನಿಂಗ್ ಲೈಕ್ ದಟ್.
Somebody has
Yes, my lord. I am not,
purchased the by in the action.
He has paid the money, but till sale, it's not completed. He has just deposited money to the court.
Deposit ಮಾಡಿದ್ಮೇಲೆ ಅವರು he will take that sale certificate, Mr.
ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ
ಅದು ಇಷ್ಟೇ, ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿವರೆಗೂ ಅಷ್ಟೇ. ಮುಂದೆ
ಆಮೇಲೆ ಏನಾಗಿದೆ ಆರ್ಡರ್?
ಆಮೇಲೆ ಡೇಟ್ ಹೋಗಿದೆ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಇನ್ನು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್
what has happened that? Already concluded, then nothing is survived.
ಅಲ್ಲ, ಕನ್ಕ್ಲೂಡ್ ಆಗಿದ್ರೆ ನಾನು ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. 28th or 28th ಹಾಕ್ಬೋದು ಪ್ಲೀಸ್. I will verify, my lord.
28th, yes.
Office objection may be overruled.
Submission is accepted, office objection is overruled. Leaves this matter for preliminary hearing on 28th.
Please.
Serial number 78, Anu Parnalli.
The objection is with regard to court fee, my lord. Court fee is paid.
Paid. How much?
200 rupees.
Yes.
This plaintiff's writ petition, suit for injunction. Now, my lords, my application for appointment of court commissioner is rejected, my lord, on two grounds. One, that it amounts
For the
to.
plaintiff.
Please.
You are sued for?
Suit for injunction, my lord.
Yes. What is the stage in that proceedings?
Now, my lord, it is for final arguments. Initially, I filed an application, it was dismissed, my lord, because it was before the commencement of trial. After the conclusion of evidence, my lord, I filed another application for appointment of commissioner. It is rejected on the ground that it amounts to collection of evidence and that it is beyond the scope of the trial, since on the ground that it is an injunction suit. Now, your lordship is well aware, my lord, this honorable court has taken a view that even in a case of in a suit for injunction, court commissioner can be appointed.
Oh, can it be appointed for collection of the evidence?
It is not for the purpose of collection. The, my lord, the premise on which suit is filed is that the defendants, my lord, is trying to encroach and carry out excavation activities within my property. The suit is, my lord, for prohibitory and permanent injunction, restraining the defendants from carrying out excavation.
Then you have to prove that he is excavating your property.
Well, I have produced, in fact, I have an injunction in my favor, which is confirmed in appeal, my lord.
Why that commissioner? Commissioner to verify whether he is.
My only prayer in the court commissioner, my lord, application is that he should survey my property. Only then I will be able to understand whether he has encroached or not, because unless, my lord, physically report is carried out, otherwise I will not be able to prove that he has encroached.
Or issue notice, stay of further proceedings in OS number 112 of 2019, pending in the file of first additional civil judge JMFC, Krishna Raj Nagar, till next date of hearing. Submission is accepted. Officer,
please.
Seventh time office objection, serial number 79 adjourned, serial number 80.
I am for the petitioner, my lord. In this case, my lord, the plaintiff.
IS challenging in court fee paid ಮಾಡಿದ್ರೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಎರಡು ಸರಿ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರೇ. ಕಟ್ಟಿದ್ದಾರೆ, 2 times ಕಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
2 times paid.
ಹೌದು ಹೌದು ಸ್ವಾಮಿ.
Yes.
The petitioner is the plaintiff, my lord. The petitioners filed OS for partition and separate possession, my lord. During the course of the proceedings, the IA number 13 was filed to recall and reopen the matter, my lord. But the same was rejected on the ground that it has been, all those filings were made just to drag on the proceedings, my lord.
No, that you have filed in a suit for?
Partition and separate possession, my lord. They are denying
order
in annexure A, my lord. Page number 13, my lord.
It is found that after 6 adjournment, plaintiff filed an affidavit when the case is set down for the cross examination. Petitioner did not tender the further cross examination. Yes, the case was posted for defendant examine the DW1. When the case was set down for the cross examination, finally application is filed. New alla application avaga.
My lord, the petitioners were searching for certain documents, my lord. Therefore, it was just delayed, my lord.
Already 2021 suit. 2025 ವರೆಗೂ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಸರ್ಚ್ ಮಾಡ್ತೀರಾ ನಿಮ್ದೇ ಕೇಸು ಅಂತಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಟ್ ಸೂಟ್ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮಿಸ್ಟರ್
ಫಾರ್ ಪಾರ್ಟಿಷನ್ ಅಂಡ್ ಸೆಪರೇಟ್ ಪೊಸಿಷನ್.
ಮತ್ತೆ ಅವಾಗ್ಲೇ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ವೆರಿಫೈ ಮಾಡಿ ನಿಮ್ ಸೂಟ್ ಹಾಕೊಂಡು ಬಿಟ್ಟು ನೀವು 5 ವರ್ಷ ಆದ್ರೂ ಡಾಕ್ಯುಮೆಂಟ್ ವೆರಿಫೈ ಮಾಡ್ತಿದೀನಿ ಅಂತ ಅಂದ್ರೆ is it
they have tried for to get the
that is not that purpose, mister. Now what is that stage? Now,
Now it is, I have to get,
then 10/7/2025, what has happened now?
I have not collected
You get
the,
that, collect that, what is there? Yes. Submission is accepted, office
No.
objection is overruled. Yes.
notice may be ordered, my lord.
Now you give, suit and dispose ಆಗಿದ್ರೆ notice ತಗೊಂಡು ಏನ್ ಮಾಡೋದು? Verify ಮಾಡ್ರಿ.
Please, my lord.
Yes.
10th time office objection, seal number 81. Narasimha Prasad.
Yes.
I'm filing a memo to dismiss this writ petition as against respondent 2 to 58 and 60 to 66.
Why?
The relief, first respondent is the plaintiff. He had filed a suit for partition and separate possession. And in which during the pendency of the suit, 2 properties were acquired by KADB and award was passed.
ಆಯ್ತು, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ ಅದಕ್ಕೆ ಬಂದಿದೆ?
Office objection, most of it will be, may not arise in view of this, my filing of memo.
Counsel for the petitioner has not furnished that amended cost type.
ಅದೆಲ್ಲ ಹಾಕಿದ್ದೀನಿ. ಈಗ I am filing a memo to
ಈಗೇನ್
dismiss
ಕೇಸು?
this writ petition as against respondent 2 to 58 and 60 to
ಏನಿದೆ?
66.
What is this matter, Mr.?
The suit was filed for partition and separate possession. May I request your lordship to kindly turn to.
You are the plaintiff or a defendant?
I am the first defendant. I am defendant number 19 and 20.
What is that order you are challenging?
The order is, your lordship would find at ink page number 29, Mala, 28. IA number 38 filed by the plaintiff under section 151 so and so is allowed. Defendant number 56 is directed not to disperse the compensation amount in respect of item number 22 and 23 in favor of defendant number 19. Defendant number 19 is the petitioner before your lordships. The suit is filed for partition and separate possession. He is claiming half share in the property. Entire amount is sought to be, an order is passed to restrain me from drawing the entire amount.
No, that,
at least to the extent of 50%, it could have been ordered to be deposited because he's.
Issue notice. Whom you want to dispense?
ಈಗ respondent 2 to 58 ಮತ್ತೆ 60 to 66 ಮೇಲೆ writ petition may be dismissed. I have filed the writ petition memo.
Passed out. Yes.
Passed over matter.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ half portion at least stay may be confined only to the half.
2024 3 ವರ್ಷ ಬಿಟ್ಬಿಟ್ಟು ಈಗ ನೀವು
ಇಲ್ಲ ಈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಗಳು ಕಂಪ್ಲೈ ಮಾಡಕ್ಕೆ ಆಗದೆ ಈ ತರ
ನೋಟಿಸ್ ಹೋಗ್ಲಿ, 3 ವರ್ಷ ಆಗಿದೆಯಲ್ಲ. ಎಸ್.
Seal number 48, passed over matter. P. Manjunath Prasad.
48. Yes.
Petitioner, my lord. My lord, the petitioner has challenged the order passed in the execution petition, my lord, wherein the court commissioner is appointed to execute the sale deed, my lord. That has been challenged, my lord. Annexure A, my lord. My lord, the petitioner is the judgment debtor, my lord. My lord, earlier the decree holder has.
Degree?
My lord, suit for specific performance, my lord. It's ex parte decree, my lord. Earlier, my lord, the execution petition has been filed, my lord, annexure B, my lord, wherein the court commissioner has been appointed, my lord. And thereafter, my lord, the sub-registrar has refused to register the sale deed because the POD has not been done and the demarcation has not been done, my lord. Because the property is entirely, my lord, around 861 acres is there, my lord, wherein the 3 acres has been granted to the.
What is that order you are challenging?
Order, my lord, the appointing the court commissioner for the execution of the sale deed, my lord. Page number 20, my lord, the operative portion.
20.
Yes, my lord.
ಆಯ್ತು, ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಲಿ ನೀವು. There is any degree in your favor against you.
My lord, the Lebanese sketch is not prepared, my lord, and the property POD has not been done, my lord.
ಆಯ್ತು ರೀ, ಅಲ್ಲಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಲ್ ಆಗಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ ನೀವು.
Kindly see page number 26, my lord. 25, my lord. Yes. The earlier execution petition, my lord, the parties absent in page number 25, my lord. The learned counsel for the DHR filed a memo praying to permit the DHR to withdraw the petition with a liberty to file the fresh petition after the necessary orders passed by the government of Karnataka. Learned counsel for the DHR submits that the present petition has been filed for the execution of the regular sale deed as per the judgment and decree passed in the suit bearing number 26 of 2010 for the relief of specific performance of contract. The JDR have acquired the status of ex parte and thus the court commissioner was appointed to execute the regular sale deed in favor of the DHR by stepping into the shoes of the
ಆಯ್ತು ರೀ, ಈಗಲೂ ಅದೇ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. 11 ಸ್ಕೆಚ್ ಇಲ್ಲ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ನೀವ್ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ?
Because, my lord, till date, my lord, the POD work has not been done, my lord.
ಆಯ್ತು ರೀ, ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ.
Yes, my lord, but my lord,
if you are challenging that, you show that you are not ready to executing that.
But yes, my lord, but for the registration, my lord, because my lord, in the earlier petition, they have taken the liberty, withdraw the liberty to file the fresh petition after the passing of the necessary orders by the government of Karnataka, my lord. But till date, they have not passed any orders, my lord. But without any reason, my lord, they have filed the petition and similar application has been, my lord.
How it is affected there, it is their headache, mister. If
Yes, my lord. But in
register
the,
says that it cannot be executed, you are happy. Why you are challenging? What is your ground?
my lord,
Degree is in
yes,
against you.
yes, my lord. But I have challenged the same, and it is pending in the RFA, my lord.
RFA go obtain interim
But in
order.
the identical matter, my lord, this honorable court has directed to file the online application for the 11 sketch. Sir.
ಆಯ್ತು 11 ಸ್ಕೆಚ್ ನೀವು ಮಾಡಿಸ್ಕೊಡಿ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ. ಇಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮಾಡಬಾರ್ದು ಅಂತ ಎಲ್ಲಿದೆ? This is what is that? This is that execution petition cannot be filed.
Yeah, my lord, in the para 4, my lord, page number 3, my lord. In that view of the matter, the contention urged by the learned government, additional government advocate merits acceptance when the transaction pertains to transfer of an undivided shares in the agriculture land forming part of the larger survey number. The same necessarily require prior identification and demarcation through the ODR subdivision process, culminating in issuance of the sketch under section 11 sketch of the Karnataka.
ಅದು ಅವ್ರು ಮಾಡಿಸ್ಕೊ ಬರ್ತಾರೆ ಬಿಡ್ರಿ, ಅವ್ರಿಗೆ ಡಿಗ್ರಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನಿಮಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Because the my lord,
ಅವ್ರು ನೀವೇ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಆದ್ರೆ ಸರಿ, 11 ಸ್ಕೆಚ್ ಮಾಡೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಿ, ನಾನು ಎಕ್ಸಿಕ್ಯೂಟ್
but
ಮಾಡ್ತೀನಿ. You are the judgment
decree has
letter.
been challenged, my lord. It's pending in the RFA, my lord.
Challenge that RFA for seeking an interim order, not here.
And my lord, only the 5,000 has been paid in the agreement as the advance amount, my lord.
Notice, yes.
My lord. Lord, interim order, my lord, otherwise the sale deed.
No, mister, sale deed cannot be, ನೀವೇ ಹೇಳ್ತಿದ್ದೀರಾ 11 sketch ಆಗದಾನೆ ಅಂತ. How can they do it?
My lord.
Yes. 90? Yes, 97. ಎಲ್ಲಿದೆ 97 ಅಲ್ಲಿ? 97 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ withdraw? Yes, 97 you are withdrawing that.
I filed the suit for partition was dismissed. The party, the council had not filed the application, but had informed me that they had filed.
Respondent number 4 minutes.
No, you are withdrawing or not?
I am withdrawing. My lord may observe with an observation that I will file an application, delay spent here maybe.
No, what is that you are challenging here?
I am withdrawing because suit
I
was.
will permitted to withdraw, but liberty and all, I want to see that. what is-
No liberty, my lords. I will file an application because without filing an application for recalling the order of dismissal, the council had informed me that he had filed an application. On
Yes,
verification,
learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this, dismissed as withdraw. Yes, ಇನ್ನೊಂದು ಯಾವ್ದು?
99 sir.
99 filed a memo seeking leave of this court to withdraw, dismissed as withdraw. Other matter, we'll have it on 118.
ಏನಕ್ಕೆ?
Urgency ಇದೆ, could your lordship have it to?
ಏನಕ್ಕೆ?
No, that
Let it to come in there. Your lordship kindly.
all this matter
Silver hearing ಅಲ್ಲಿ ಹಾಕ್ರೆ ಬರುತ್ತೆ.
on 28th.
ಸರಿ, ಏನಕ್ಕೆ?
Silver hearing my lord.
98th. All matters, yes, B group.
230.
Ready. Yeah. 10.
At least that can be overruled.
Withdrawal.
No, that this is only IA, ನೋಡ್ರಿ ಅದು ಏನ್ರ ಮೇಲೆ ಇದೆ.
2 years common order.
ಮತ್ತೆ ಯಾಕ್ರಿ ಅದು ಹಂಗ ಒಂದೊಂದ್ರಲ್ಲಿ ಒಂದೊಂದು ಆಗ್ತಾರಲ್ರಿ. What is that of subjection? Yes, lease this matter on Friday under office objection list. ಅವತ್ ನೋಡೋಣ. No. Office objection matters is treated as a preliminary hearing. I am taking that matter. I will also try to take vacating, but I cannot reach. But B group, I am helpless. I can't take that. Vacating, I
Seal number
take that.
8.
Now that is also not possible because of number of cases.
86 minutes.
Office objection with a preliminary hearing, I will take that. If compliance is there, I will.
It's
proceed because
84.
Yes.
Lords,
Seal
84.
number 86, Lords. 86.
Same thing, Mr. I can't.
86, Lords.
99 and 97.
Yes, 103, all this,
Vacating I.
B group, ಅದು ಯಾವ್ದು ಇರ್ಲಿದೆ?
ಅಲ್ಲ, vacating I.
86, Lords.
Vacating.
All orders ಏನಿದಾವೆ ಅದು? Steps to be taken, maintainability, withdrawal ಆಯ್ತಲ್ಲ?
Vacate.
Yes. Orders list and vacating.
Yes, Lords.
We'll
86.
have it on, day after tomorrow.
Lords,
Please.
but 86, Lords, not on Friday.
Huh? No, that on that day we'll see that.
Lords, 86, Lords.
88 ಅಲ್ಲಿ ಏನಿದೆ? ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ರೀ? Vacating stay will have it on that 28 you want.
28, okay, Lords.
No, it's earlier
84
date,
also.
an earlier date.
107.
No, it's 84.
Interim order will be extended.
No, it's 84 on hearing on vacating IA, 84.
Vacating IA will
Could it be had on Saturday, my lords?
Saturday,
Because,
I'm
yes,
sorry,
ma'am.
I'm sorry, I'm
It-
petitioner.
vacating application Saturday.
86.
My lord, sir, 84, my lords, I am the petitioner. Saturday, bed, so Friday or Monday, my lord, Saturday is not available. That 84 what my lord, friend.
84, then we'll have it on Friday.
Friday, please.
Yes, ma'am. I.
86. Lords, 86, Lords, some other day.
ಯಾರು Saturday work ಮಾಡಲ್ಲೇನ್ರಿ? Saturday, there is a chances of reaching on
Yeah,
Saturday.
please, Lords. Lords.
Which, when do you want, Mr.? 91, 92.
91 and 92, I am appearing for the respondents.
Lords,
Yesterday they served me the writ petition. There is an order of status quo in 91. I don't understand why.
ಆಯ್ತು ನೋಡೋಣ Saturday.
Saturday, I am yet to file my wakalat, my lord. And I need to take instructions.
25.
Allah, he has served me yesterday, my lord. Any date next week, my lord.
Lords,
Any date next
25th, my lord, 25th, 20, my lord, 86, Lords. Lordship, kindly post on Saturday, my lord, so that,
Saturday.
please, Lords, much obliged.
Whoever wants Saturday,
Please, my Saturday we want 86. Seal number 86.
vacating application
Lord, insofar
Saturday,
as-
Friday.
Lord, insofar.
Interim order will be extended.
Okay, please, Lords.
120? 121 for one na? Yes. Learned counsel for the respondent submitted that as filed an IA for vacating office to verify and post this matter on 28th. Yes.
Lord, 107.
Lord, serial number is 107.
Uh, 86 to.
My lord, 107, my lord. 107, my lord. Application is for dismissal of the writ petition. I am for the petitioner. Lord, petitioner is aged about 86 years old. Lord, it's listed couple of times. Lord. Could I request your lordships to list it any date in the first week, my lord?
No, that who has filed IA for dismissal?
The respondent.
my lords, appearing for the respondents.
Yes. Let us see what is there. We'll see on that 28th. Yes.
Very
Lords,
well. I'm-
27th, my lords, if it may be listed.
Yes, yes, madam.
My lords, 27th, 107, my lords.
27. Yes. 80 vacating, 82 vacating either Friday or Saturday.
92.
Any date you mentioned that interim order will be extended.
Your lordship kindly, my lord,
He who has filed and vacating, he wants after vacation, will grant it. But
your
not
lordship,
for the petitioner.
My lord,
118, my lord, repeatedly it is posted, I request your lordship to 238, 28th, my lord.
No, 108,
No, 118.
118.
Your lordship, kindly, 230 by 28th at least. No, otherwise it would not reach, my lord.
No, we'll see on 25th Saturday.
Lord, in that,
25th to 230, my lord.
Regular.
Lord, in that
230, my lord.
118.
107, my lord. In that 107, if it could be taken up at top of the list because it will not reach, my lord. In fact, it was me who moved the matter.
No, Mr. Council, all standing council here, they wants to see that matter has to be reached.
I understand.
If you take your
But
matter as 230 or they will all ask.
I'm keen for the dismiss, I'm keen for the matter to go on, my lord.
No,
That's the
do you
reason.
think that all other council it is standing simple?
I understand, my lord. I understand. And I understand your
See,
lordship's board also, my lord.
Yes, if there is urgency for all parties, if I granted 230 for one case, everybody will ask.
Then my lord, 28th is all right.
Therefore,
But
I'm giving an
27th
edge.
one.
See, in other rosters, sometime if the parties has pleaded urgency, I have given a 230. But here, in all suit cases, everybody is in urgency.
I understood.
If I take 230, other 50 matters will be 230, then 230, one more list.
I understood.
Therefore, I
28th is
maintain
all
that.
right, my lord.
That's
Otherwise, you could
27th,
have-
it may be
The
listed.
lordship said indicated 20th.
Party wants to dispose of the case. The
Yes.
thing is that all are on the same footing. I
Yes.
can't make any discrimination.
98, my lord.
Otherwise, we could have been here that.
Yes.
98 is.
Let us see, if more judges are come, it can be.
That's 27th, it may be listed,
98.
107.
Yes, all that date will be given. Yes, interim order will be extended.
Sir, 118 ಯಾವಾಗ? Sir, 118 ಯಾವಾಗ ಆಯ್ತು?
25ನೇ ತಾರೀಕು ಹೇಳಿದ್ರು.
ಹಾ?
25.
230 ಗ?
ಜಡ್ಗೆ ಕೊಡ್ಲಿಲ್ಲ, ನಾನು ಹೇಳಕ್ಕಾಗತ್ತಾ?
Sir, 86, 86. Serial number 86.
ಸರ್ 121 ಅಲ್ಲಿ
86.
ಹೇಳಿದ್ದಾರೆ ಬಿಡಿ sir ಅವರು. ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ ಅದೇ ಪ್ರಕಾರ ಪ್ರಶ್ನೆ.
121.1
ಯಾವ ತರ ಡಿವೈಡ್ ಆಗುತ್ತೋ ನೋಡೋಣ, ಅವ್ರು ಯಾವ ತರ ಡಿವೈಡ್. ಎರಡು ದಿನದ ಡಿವೈಡ್ ಮಾಡ್ತಾರೆ.
86.
ಹಾ. 86, 28 for ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ.
Interim order may be extended.
ರೆಸ್ಪಾಂಡೆಂಟ್ ವಕಾಲತ್ ಹಾಕಿದೀವಿ ಅದೊಂದು ಹೇಳ್ಬಿಡಿ ಸರ್.
Sir, 86, interim order.
ಹೆಸರು ತೋರಿಸ್ಬೇಕಷ್ಟೇ.
82, 55 ಹೇಳಿದ್ದಾರೆ. ಹೇಳಿರೋದನ್ನ ಕೇಳ್ಬೇಡಿ.
121.1 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದೀವಿ.
25 ಹೇಳಿದ್ದಾರೆ, ಅವ್ರು ನೋಡಿ ಮಾಡಿದ್ದಾರೆ, ನಾನು.